everybody.
We are live, you guys. 1 minute early.
For this
She is on time.
ongoing criminal trial, we're doing motions today and possibly for the next several days.
Possibly.
For the defendants, I have not met y'all yet. You have not met me. I'm Judge Whitaker. I am the new judge who has been assigned to take over this case and preside in this case from here on out. As I said to the attorneys about 10 days ago when we had a scheduling meeting, I am going to encourage the parties to engage or re-engage in any kind of plea negotiations that might be fruitful. I suspect that for both sides of this case, there is a good bit of uncertainty and a good bit of risk with continuing with this trial, with potential appeals, you name it. So just bear that in mind, and we will go ahead and get started with the various motions. So the first motion that we have is, well, they're not in any particular order, but I've tried to put them in an order that I think makes sense. And the first motion that I am going to deal with is the motion filed by the state essentially for a gag order on the defense. And with regard to all of these motions, I've read the motions, I've read the responses. If a response was filed, I have read any replies that got filed. So we don't need to take up court time rehashing what's in the motions. They're all well pled. If you have something that you want to add that was not in your written submissions, I'll listen to that. But with regard to the state's motion, which they didn't title for a gag order, but what it essentially is there anything further from the state that you would like the court to consider?
Adrian Love, Your Honor. For the state, Judge, we will rest on the authority that we have presented to the court and point out to the court that since the time of this filing, other instances similar to in nature to the ones that we pointed out to the court have occurred, and we would just simply ask the court to afford the relief requested in the state's motion.
All right, thank you. And
that was the fastest she got away from the podium.
Needs to add anything to what's been filed in writing?
Good morning, Your Honor. Doug
Okay, Doug.
For Diamante Kendrick. We will stand on our response. The only other thing I'd like to add is to point the court to the case of WXIA TV v. State 303 Georgia 428, which discusses the presumptive unconstitutionality and issues with gag orders as prior restraint. That case is with respect to the news media, but there is some analogous language in that, and I'd just like to point the court to that. Thank you.
All right, thank you. All right, with regard to this motion, you know, I know that there were some things in it that suggested that certain of the defense lawyers might be running afoul of bar rules, and if they choose to take action that might put them in that kind of a situation, that's kind of up to them. And if there is a complaint filed, then they will have to deal with it. But I think that in regard to the propriety of doing that in this case at this time, I'm going to deny the state's motion. Obviously, if facts change and the state or the defense at any future time believes that it would be appropriate to consider this issue again, please raise it again. But at this point in time, we are going to
it's a new court reporter too. She retired.
Instituting any kind of a restrictive order for speaking with the press in the case. With regard to the media, I'm just going to remind any of the media actors that are recording this case that the Rule 22s that are in effect in Rule 22 period only permits recording when the judge is on the bench, not during any recesses and not during any bench conferences. So let's make sure that we abide by that from here on out. I was having to reference some prior live stream that was in some of the motions that were filed and some of the responses, and notice that there were definitely times, at least in what I was seeing, that proceedings were being recorded when court was not in session, and Rule 22 does not allow that. So let's make sure that we stay within the bounds of Rule 22. All right. So the next motion that I would like for us to consider is Mr. Williams' motion, and I'm just calling him by who filed it. I know that everybody has joined in on everybody else's motions, but to essentially revisit Judge Krause's factual findings in her recusal order.
Good one to start with.
Mr. Steele, is there anything you want to add to what's in the written filing? Go ahead.
Good morning, Your Honor.
Good morning.
Good morning, everyone. Your Honor, may I just step back for 1 second? Good morning, Madam Court Reporter. I am Brian, B-R-I-A-N, Steele, S-T-E-E-L. And along with the Honorable Keith Adams, represent Mr. Williams. Your Honor, what the Honorable Judge Krause found in her result, we don't take offense to, or we agree with, actually, but when she made some comments which were that this ex parte meeting might have been, I'm not looking at her order, might have been okay if it was done in open court. I strongly, and Mr. Adams, Honorable Mr. Adams, strongly disagree with. And the reasons are in the joint affidavit of Mr. Adams and myself, dated July 8th, 2024. And what happened here is you have a witness, Mr. Copeland. He was sworn on June 7th of 2024, and he invoked a privilege. To my understanding, Your Honor, he did not have a privilege to invoke. The state, and we didn't have notice of it at the time, but the state ordered, or maybe we did have notice. I didn't have the motion, but I had the order, I believe. The state asked the Honorable recused court for an use immunity. So nothing that Mr. Copeland can use could be then turned around and prosecuted. So the way I understand the law is that protected anything that Mr. Copeland said. It was like an umbrella over him, so that anybody, federal courts, they could not use this testimony, but he could still be prosecuted. Somehow, according to the transcript, which is the ex parte hearing transcript, June 10th, 2024, there's the recused judge, Ms. Love, Ms. Bumpkus, B-U-M-P-U-S.
All right, and let me interrupt you for just a second. I've read the entirety of that ex parte transcript, so I'm familiar with what happened in that.
So my position is nothing there was good. Everything was wrong. And I believe, as stated in the affidavit and the motion, that there was intimidation put upon the witness. To change his statement, he made it very clear, send me back to the DeKalb County Jail. I'm not testifying. I have a case for the court. And based upon what you just said, if I could just get that case,
Okay.
I'll be right back.
Hold on, while they're doing that, I had 2 tabs playing, so let me fix this real quick. There we go. So on my end, I was hearing 2 streams, and I didn't want to interrupt and minimize the screen. The defendants look sharp.
All right, while Mr. Steele's looking for that particular case, just a heads up to everybody else that's going to be arguing case law. If they want to present a case, try to go ahead now and be getting that at your fingertips, okay? Is this a case that's not cited in your?
Yes.
Okay.
I was like, let's look at this BS.
May I approach?
Thank you. Thanks.
Steele might not have gotten a lot of sleep, if we're being honest.
So, Your Honor, I just provide to this honorable court and prosecution in one copy to the Honorable Douglas Weinstein of Archer, A-R-C-H-E-R versus Maryland. It is 859A, as in Elisa 2D 210 2004 case. And starting on page 6 of 22, Your Honor, of the copy I've given the parties, on the right-hand side, right in the center, the Maryland court explains that here Bailey had been convicted, sentenced, and the time for filing an application for leave to appeal his guilty plea had expired. Thus, he had no Fifth Amendment privilege to refuse to testify. Contempt proceedings were therefore an appropriate response to Bailey's refusal to testify. So it's the same situation, except he pled guilty. Mr. Copeland was never charged. He's called an unindicted co-conspirator. That's announced by the state. On page 10 of 22, the appellate court in our sister state goes through what happened with the judge. Now, this is not ex parte. This is in open court. So this gets to what you asked about Judge Krause's findings. And what the judge said on page 10 of 22 on the left-hand side in the center, first full paragraph, we find that the trial judge's efforts to persuade the witness to testify went too far. If Bailey persisted in his refusal to testify, Judge Prevas, P-R-E-V-A-S, had the option of either initiating direct contempt proceedings or constructive contempt proceedings. The authority to initiate contempt proceedings, however, is not a license to intimidate a witness into testifying. The purpose of the contempt power is to provide a means for a judge to uphold the dignity and integrity of the judicial process. And then skipping down to the next paragraph, similarly,
Can I interrupt
Yeah,
you?
of
And
course.
let's not skip down, because I think that part we're skipping is maybe important too, because it talks about the specifics of what that judge did in this
Yes.
case. So
Okay.
what is that?
Okay, well, he did a lot of things, but what the court is referring to, under the circumstances of this case, the phone call to another judge in the presence of the witness, the threat of life imprisonment as a sanction for contempt, and the suggestion that the other judge will give Bailey the longest possible penalty for contempt detracted from the dignity and integrity of the judicial process rather than uphold it. Similarly, it was unnecessary and excessive to instruct Bailey on how he could testify in the Archer case. Mr. Archer was the one on trial. Bailey was represented by counsel who could have advised him concerning the various testimonial options if that was deemed necessary under the circumstances. Even if Bailey was unrepresented, it was not in the province of the court to suggest to the witness how he could testify to avoid a contempt sanction or how to allay his fears of testifying. In either case, it was not the function of the trial judge to suggest to the witness that he could testify favorably to the defendant, Archer. Specifically, Judge Purvis advised Bailey that he could testify favorably to the defendant, and there is nothing that anybody can do to punish him for that. That admonition was incorrect because Bailey could be prosecuted for perjury. So it goes on. I mean, there's great language. And the reason I use it, I understand it's not binding precedent, is it's hard to find a case like ours, but I searched and I found this. And what happened here, as the court is aware, just to highlight, because I heard what you said, the witness said, can I have 2 weeks to go home on house arrest instead of in the county jail? His child was having a birthday. That was a big deal to him. And then I'll make a decision whether to testify or not. I want to think about it. That answer should be from the court, because the court can do anything in contempt.
Look at love.
It can give a fine. It can give weekends. It can give house arrest. It could do nothing. It could say you satisfy your contempt. That answer to that question was done by Ms. Hilton in front of the judge. Ms. Hilton said, no, you cannot. You have to go to jail. I find that offensive. This is my words. And that's why I'm disagreeing with Judge Krause. Number two, Mr. Copeland said in that meeting, everything I said was a lie. I've never told the truth in my life until this statement right now. That is like bullseye of Brady. It was hidden from us. It came out later, but it was attempted to be hidden.
All right, so that's in the context of another motion of yours, right? So let's focus on this motion for now.
My point is, nothing was done appropriate. I mean, and I don't want to get into, and the state actually filed a motion later saying the Honorable Judge Krause already ruled on this. I didn't know that they would do that, but I already said, I'm not accepting those factual findings, respectfully, because they're wrong, A, and B, they weren't even needed for the finding. Another issue that came up is Mr. Copeland was told how to testify. I don't know how this happened because I don't have the questions, but Judge Glanville told the state in front of Mr. Copeland and his lawyer, didn't you give Mr. Copeland the state's questions that they're going to ask him? I don't have those questions. The judge said to Mr. Copeland, remember what Miss Love told you. Unless you tell a big whopper of a lie, these are not quotes, you're not going to get in trouble. That's not in the transcript. So something happened outside the transcript. Those are just a few issues. There are more. They're all in our affidavit. But those are a few issues that when Judge Krause said everything that was done, if it was done in open court, was appropriate, everything that was done is intimidating a witness. And it changes the complexity of the case. Because what you will find out is Kenneth Copeland, these are my words, made misstatements to law enforcement. He made 6 statements. They're all audio, video recorded, except for 2. They track over 16 hours. The judge told him, and Ms. Hilton told him, and Mr. Copeland said, you previously told me, meaning Ms. Hilton, I could just say I don't remember, I don't recall. And the judge said, yeah, you won't get in trouble for that. Well, what that does is, under Georgia law, is that triggers a prior inconsistent statement, which is all that the state wants him. Mr. Copeland is just here for his prior consistent or inconsistent statements. And that's what happened in the Archer case. That's why they're saying, the judge said to Mr. Bailey, you can even testify for Mr. Archer. You won't get in trouble because, and it explains in the Maryland case, because that would trigger and open the door to prior statements, which is all the state wanted. So to me, as found by the Maryland court, this
a lot of
is
similarities, even
intimidation.
though
There was
it's
nothing
a
appropriate,
non-binding
and
case.
the Honorable Judge Krause, I'm confident, did not have this case, but I respectfully disagree, and that's why I wrote that motion.
All right. Anybody else? And I know that there is.
Please argue, love.
another- or
Please
there are a
argue
couple
it.
More motions for mistrial based on the ex parte that talk about coercion and things like that. And I'd rather take those up in the context of those motions. So if that's what you want to argue, hold off. Otherwise, come on up.
Your Honor, good morning. Max Shard on behalf of Shannon Stillwell. Of course, under the Harvey rule, I have joined Mr. Steele in his motion. I would like to, I guess I disagree with Mr. Steele in one small aspect. He is seeking to challenge the findings of Judge Krause, the factual findings, is the way he's articulated it. And I too have concerns about the order in the respect that it suggests that the ex parte meeting was or could potentially be appropriate. I don't believe it was appropriate at all, and I know that we're going to get further into that. But, Your Honor, I would, my disagreement in where I want to veer off from what Mr. Steele was saying is that I don't believe that they're factual findings. They're not necessary for her ruling. I believe that they're mere dicta. I don't believe that they're binding on you at all. What Judge Krause's order said, I believe that you independently can take a look at the transcript and make your own determination about whether the ex parte meeting had an appearance of impropriety or whether it was in fact improper, which it certainly was. So I just object to the characterization of these as factual findings because I don't believe that they are. I believe that they're merely dicta, and I believe that you're able to make that assessment on your own. Should you view them as factual findings, I, of course, join Mr. Steele in his objection to those quote-unquote findings. That's it. Thank you.
All right. Anybody else from the defense? All right, I'll hear from the state. And I know you haven't.
Here we go,
had a
you guys.
chance to see
Rate
and
rate
absorb,
Steele on 1 to
the-
10, and then we'll rate
Arnold rule.
Love on 1 to 10.
The case that Mr. Steele just, Archer, shared with us before now, but
Your Honor, I will use it as he has presented and just point out the most obvious omissions and distinctions that I see present with the Archer case. Mr. Steele stated to the court that Mr. Copeland had no privilege to invoke. He spoke about what did or did not happen during the meeting, during the hearing in chambers. I would ask that the court, as the court has already read the transcript, that the court take note of the differences between what occurred in the hearing and what Mr. Steele has represented to the court. As it relates to intimidation, Mr. Steele asserts that a statement made by Ms. Hilton essentially is part of what makes the hearing improper. The state has cited in its motion or its response to the court cases that support the state's position that this hearing was not improper. Essentially, in order for, as this is a motion to challenge factual findings, I'll speak to the factual findings that
Her nails
have
look
been
venom green or yellow.
challenged. Again, Mr. Steele cites that Judge Krause's finding, the way he said it, if it had been made in open court, it would have been proper. The
all
court,
right, why don't I just put on the record, because I've got Judge Krause's order right in front of me, exactly what it is that I think we're talking about. And I believe, and Mr. Steele, you can correct me if I'm wrong, but I think that the factual finding, that's the second one you're challenging, if it even is a factual finding, is Judge Krause's statement, it is worth noting that this court generally agrees with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. Is that what we're talking about? Yes. All right. Okay, Ms. Love.
Thank you. And so given the fact that the court has at its disposal the transcript of the hearing, Your Honor, and given the case law that the state has cited to the court, specifically, Your Honor, Allen v. State, 336 Georgia App 80 at 81, citing King versus the state, a Georgia Supreme Court case whose site is 273 Georgia 258.
They're going to rely on it being binding because it's from Georgia.
265 as authority for its ruling that appellant had no standing to contest the grant of use immunity to a witness. And King versus the state itself ruled after an appellant complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify at trial and confirming the use and derivative use immunity that would apply to that compelled testimony.
Remember, this is the one with the brief hearing.
A part of the proceedings against appellant, and that while appellant, quote, might have preferred that a key witness not be ordered to testify truthfully in his trial, there is nothing in Georgia law that would have permitted him to object to the state's request for the order, or that would suggest that appellant's rights were the subject matter under consideration, and that appellant had no standing to address the matter of the hearing outside his presence. I bring up those two cases, Your Honor, as well as Gilbert versus the state, and that site for Gilbert, Your Honor, is 306 Georgia App 776.
Thank you so much,
at
Rod Factor. I
777.
love the shirt.
Notwithstanding Gilbert's waiver, however, his argument is without merit because Gilbert has no standing to contest the grant of use immunity to Lang. The court again cited King and pointed out how the defendant there had argued that the trial court erred by conducting a hearing outside of his presence to determine whether a witness should be compelled to testify against him in exchange for use and derivative use immunity. They go on, this court goes on to cite the portion of King that I just read to the court, and goes on to say, on the contrary, the trial court was obliged to consider whether the testimony was necessary to the public interest, a matter which the defendant had no standing to address. In this particular instance, of course, there is the distinction that Mr. Copeland had invoked his right to not testify at a point
She's acknowledging
where,
the distinction.
there was no, I'll agree with Mr. Steele, there wasn't a privilege to invoke. The point at which he said, I plead the fifth, is when he was asked, I believe, his age in years. The concern that we had, the concerns that we had, we presented to the court, and mainly it was that Mr. Copeland, as is recorded in the transcripts of the July 10th proceedings in open court, that Mr. Copeland had questions that he was attempting to ask the prosecutor, Ms. Hilton, and the person representing Mr. Copeland would not afford him that ability while we were just outside the courtroom. And Mr. Copeland was then called in with the jury in the box without having had the opportunity to have those questions answered. The hearing in chambers, as is reflected in the transcript, dealt solely with Mr. Copeland's rights, what he faced, what his obligations were, The state's action of moving the court to compel Mr. Copeland to testify is what precipitated that chain of events that led to that hearing in chambers. And we wanted to ensure that Mr. Copeland was aware of whatever it was that he had sought to gain clarity about before he was forced to come in before the jury. So
Yes.
Can I just interpose an objection? I don't have any problem with Ms. Love referring to the transcript, but if she's going to testify, I would ask that she testify as a witness.
Yes, make her testify as a witness.
That she proffers information. I believe if she wants to be a witness, which I do believe she is, she would have to be sworn in to testify subject to cross-examination.
All right, thank you. So I have read the transcript, and the transcript is the best evidence of what happened there. And what we're dealing with is whether I can and or should reconsider, I guess, the factual findings made in Judge Krause's order.
So the state's position, Your Honor, is just as Judge Krause was the authority, the court tasked with making a determination regarding recusal. The court has been tasked with the responsibility, the assignment of continuing the trial. Judge Krause's responsibilities we submit to the court are Judge Krause's, not this court's. Just as each court that at each step in this process has its own set of duties, that one belonged to Judge Krause.
Okay.
So we would ask that the court deny the motion to challenge the factual findings of Judge Krause.
Anything else from the defense on this particular motion? Has there ever been an attorney invited to talk who didn't take the opportunity?
I took a pass a couple of times, Your Honor. Doug Weinstein for Mr. Kendrick. The only thing I want to add is that the King case and the Gilbert case are about a different circumstance than we are objecting to and complaining about here. That is a hearing about the issue of whether the immunity should be granted by the court. Presumably that was done in this case sometime prior to Mr. Copeland's testimony on the 7th. What we are concerned about, object to, believe violate our client's rights, is the ex parte meeting that took place in chambers on the 10th, far after that immunity decision was made, at least just speaking with respect to my client, Mr. Kendrick.
Okay, thank you. Anybody else? All right, with regard to just this particular motion, which is styled a motion to challenge essentially Judge Krause's factual findings in her recusal order. It appears to me to ask this court to almost sit as a reviewing court and find certain factual findings to be erroneous. And this court doesn't have an ability to do that. The time to have filed or sought a certificate of immediate review has passed. I can't really sit as a reviewing court over a fellow superior court's order. To the extent that it is a motion to reconsider that court's order, that's a little bit closer to something that I might be able to do, but I can't really do that either. That, as Ms. Love correctly pointed out, was a motion to recuse Judge Glanville. It was before Judge Krause, not this judge, and she granted the relief that the defense sought. I understand that the defense does not like some of what might be factual findings in there. There are other motions before this court right now for mistrial based on that, and I think it is more appropriate that I consider them in the context of that than going back and essentially undoing.
I wish the camera was on Love.
Potential factual findings made by Judge Krause. I think I agree with Mr. Sharp that this is probably dicta anyway, in that essential holding that the court made was that the recusal was based on Judge Glanville's engaging essentially while making a ruling on the motion to recuse and making kind of more than just the minimal necessary findings in his ruling. But I'm not going to reconsider Judge Krause's factual findings, so I am going to deny that particular motion, understanding that we still have other motions for mistrial to take up where some of the arguments y'all made just now might be more appropriately considered. All right.
Saying a lot, if you ask me.
So I think that actually the next motion I'm going to take up is the motion filed by Mr. Williams that has a very long style, but that essentially asks that any other ex partes be revealed, that a neutral judicial officer take a look at everything in the case that has been sealed and make sure that it is above board. And then for a mistrial based on the alleged judicial misconduct that occurred during the particular ex parte that was the, 10th of June? And prosecutorial misconduct there and prior to that. So I got from the clerk's office every sealed filing from the state or any of the defendants in any of these 6 defendants' cases. I've looked at all of them. There's nothing improper about any of them. I refiled them. The order that it accompanies the resealing, I'm sorry, not refiled them, resealed them, actually delineates each of the things that I looked at or the dates of each of those sealed filings. I'll note that a lot of those ex partes were defense ex partes. There's nothing wrong necessarily with something being done ex parte. We're kind of talking about this June 10th ex parte as though, ooh, that is such a horrible thing. And it may be, but an ex parte in and of itself is not necessarily a bad thing, and both sides have appropriately held ex parte communications about things that should be ex parte with Judge Glanville prior to this. So there's nothing in any of those sealed filings that the other side needs to see at this point or that was improper in my determination. All right. The next thing is the defense asking whether there have been
Thank you so
any
much,
other
NJB
ex partes
Nene. That's
that
so
we
nice of
don't
you.
know about. And so I'm going to ask everybody, and y'all know what ex partes you had with Judge Glanville, and you know what filings got made. And so is there any ex parte that occurred that is not connected to one of those sealed filings? And I'll ask the state first.
Launch. She
Your
launched
Honor,
up.
not being certain whether the seal filings include the transcript of the request from the state to have the hearing with Mr. Copeland, and not certain whether or not those sealed filings contain that.
Okay.
I can't say, but the state requested that we address the matter of Mr. Copeland's representation.
All right. And was that done in writing or was that oral?
The request was done orally with the court reporter there.
Okay.
We requested that the court allow us to address the matter and that it be taken down for the record.
Okay. All right. Anything beyond that?
Yes, there was also the state's request for a material witness warrant for one of the.
I think those are all reflected, and you may want to go back and look, but I know that there were material witness warrant requests from several different parties in the case.
I wonder why they didn't view that.
So those are the ex parte matters that we address with the court.
Okay, thank you. Mr. Weinstein, anything? Okay. Mr. Carlton? Mr. Matthews? Okay. Mr. Steele?
To my best memory, which I believe is accurate, there were 2 meetings with recused Judge Glanville. One was during voir dire. It is going to be the day, I could get you the date, but it's going to be the day that law enforcement executed a search warrant for the computer of the Honorable Eric Johnson. He's a lawyer in the case who's severed out now.
Okay. All right.
And that was announced in open court. I asked recused Judge Glanville whether we can have an ex parte. All the parties were here.
He was
then
Judge
everyone
Glanville.
went. So when I say everyone, all the people here went into chambers behind, and there was conversation in front of a court reporter.
All right. And when you say all the people here, does that include the state?
No,
Okay.
the
So you
state
mean
was here.
all of the defense attorneys?
And the state was here when I announced that we'd
Okay.
like to meet ex parte. The judge, former judge reconvened, our former judge reconvened.
Okay.
We went into the chambers here. So I have no idea if that's something you looked at or not.
And I don't know whether that's anything I looked at, because that would have concerned a severed defendant. I would imagine it's in that case and not any of these 6 defendants. And I only looked at what was in these 6 defendants' cases.
I can't
But-
answer.
Okay.
And when I say who was here,
Interesting,
yes.
'cause there's stuff that matters
Mr.
about certain
Weinstein, Mr.
severances.
Harvey, I assume Ms. Westmoreland, she's shaking her head. Misty Williams, I know Mr. Adams was next to me, Mr. Sharp, and I presume Mr. Butts. He's shaking his head, yes. And the second one was also asked in open court for a meeting with the recused judge ex parte, and that was on the day before, or coming up to a man named Mr. White, like the color, was going to testify, and we had it at the bench where the court is, and that was Mr. Sharp, Mr. Matthews, Misty Williams, myself, and Mr. Adams. And if my memory's wrong, I'd like them to correct me. That's who I remember being there. And it was on the record.
Okay.
So I don't know if you saw anything about that.
All right.
And that was the total that I've had with.
All right. Thank you.
Thank you.
Mr. Harvey?
Judge, just to be on the safe side, it wasn't, we had a in-camera meeting with Judge Glanville. When I say meeting, it was not ex parte, it was meeting Ms. Westmoreland and I believe a Hilton. But it concerned a scheduling conflict in federal court
Okay.
that I had, and we resolved that. I just want to make sure that.
All right. I appreciate it. Thank you. Mr. Short?
Your Honor, to the best of my recollection, I recall being with Mr. Steele in the announced ex parte regarding that gentleman, Mr. White. I also believe there was an ex parte regarding another permission to interview a separate witness who was unrepresented at the time. I believe that probably is reflected in the sealed records. I can't recall if Mr. Steele was with me or not, but that also occurred, and that would have been before the jury was sworn. That was late 2022.
Okay. Thank you.
Mr. Steele is indicating that he was present.
All right. Okay, so that takes care of that part of that motion, unless anybody wants to inquire further as to any of those. Okay.
Oh, Your Honor, what's confusing to me, Your Honor, is in the transcript of the June 10th ex parte meeting that we've focused on, there is, within the transcript, there's a clear indication that Judge Glanville is aware of, as Mr. Steele alluded to, questions that the state is in possession of, that they seek answers from Mr. Copeland about and wish to pass these questions on to him. There is nothing in the transcript that indicates a discussion between, I believe it was Ms. Hilton that was in possession of this list of questions. There's nothing in the transcript that indicates a conversation that even suggests how Judge Glanville would be aware of these questions, the existence of these questions. And it just leads me to the inescapable conclusion that either the transcript is not complete or there was a separate meeting that occurred, because there's just no context to it. It just doesn't make any sense to me logically. So that's my concern.
All right, so I read that part of the transcript, and obviously I wasn't there, but when I read it, I just thought, I think Judge Glanville used to be a prosecutor, and he assumes surely you must have given them a list of questions. Now, I have no idea whether that's, if it was just like, surely you have a list of questions, or if there had been a prior
Look at
conversation.
them.
And
They're
I'll
like-
ask Ms. Love that.
Yeah.
Your Honor, I believe that since Ms. Hilton was the one present.
Or Ms.
at that-
Hilton.
But I can say that I did hear Judge Glanville, I believe, in open court say something similar to that, but I will allow Ms. Hilton to
Okay.
address the specific.
All right. Ms. Hilton, was there some basis from something that had already occurred for Judge Glanville to have asked that?
No, Your Honor. We were very sure to only talk about
This
what
should
was
be
happening,
witnessed.
which was getting Mr. Copeland purged from his contempt. So I made it clear that we weren't going to talk about anything substantive, and to talk to the judge about any questions to me would have been substantive. So we never talked about any questions with the judge prior to Judge Glanville saying that during the meeting.
All right, and was everything
should
that
be- this should be
occurred in that
witnessed. This should
meeting
be under
other
oath.
than the times when Judge Glanville stepped out so that Mr. Copeland could talk to his own attorney and I believe talk to y'all? Was everything else recorded?
Yes, Your Honor.
Okay, from the outset of that meeting?
From the outset of the time that I entered the room, everything is recorded.
Right, because you weren't there at the beginning of it. But
Correct.
you did not have a conversation with Judge Glanville prior to when you came into chambers and it was being taken down?
Outside of
About-
the normal,
No,
During
explain it.
house lunch, yes.
correct.
Okay. And Ms. Love, you were in there at the outset. Was it
I hope the
recorded, taken
defense
down from the
all
outset?
speaks up about this.
Yes, and it was, she was there from the beginning. And as I stated earlier, the only other instance that we spoke on that was also taken down.
Okay. All right. And that was earlier that same morning?
I think it was the Friday.
The Friday before? Okay. All right. All right, so based on that, I don't find that there was any other untranscribed prior meeting between the state and Judge Glanville regarding Mr. Copeland and what they discussed in that June 10th ex parte. All right, another part of this motion is a list of purported slights and misrepresentations by Ms. Love that I'm not going to go through in more detail. They're in the motion. I'm just going to say, Ms. Love, make sure that your representations to the court and in court are accurate and professional. All right?
I will continue to do that as I have. Your Honor.
All right.
The court require all parties to make certain that that is.
Okay, all right. With regard to Judge Glanville's comments, I mean, he's off the case at this point. If we want to endeavor to craft some sort of a instruction to the jury, you know, I'll consider something that y'all want to present to me. But I know in particular, Mr. Steele, you took issue with apparently at some point, Judge Glanville used some adjectives about you, specifically unprofessional and unprepared, that are bothersome to you, and I can understand that. I would also say that not only is that in the past, but if that was in front of the jury can see for themselves how you present, whether you're professional, whether you're prepared, and so that ought to take care of that. And this court is going to instruct the jury, just like is done in every case, that nothing that the judge says, no matter whether it's this judge or the prior judge, is evidence. It's not supposed to indicate any kind of a bias one way or another. And so I'll give those those instructions anyway. And if you want something additionally curative wise, I'm willing to entertain that as well, okay? All right, so given that Judge Glanville is now recused from this case anyway, and I have instructed Ms. Love to conduct herself with professionalism. I am going to deny the motion for mistrial as it is sought and on the bases on which it is sought in this motion.
Your Honor,
Yes.
I just asked for clarification, whether the court is finding that there were any unprofessional or...
I am not making any such finding.
Thank you.
Yes.
I think we just, maybe I was lost for a second. I think we switched to a place where I didn't believe we were at, or I didn't understand the discussing regarding a mistrial. I didn't really understand us to be at that point in the
It's in relation
motions
to
yet. And I just wanted to be
prosecutor's
clear for the
comments.
record, to the extent that a mistrial was denied, Mr. Stillwell, it has been we never requested a mistrial.
Okay.
And to the extent that a mistrial's been denied, I just want to be clear that Mr. Stillwell has not requested a mistrial. And when we were going to move on to Mr. Harvey's specific request for a mistrial,
Yeah, I hadn't gotten to that one yet. Okay. All right. I appreciate
I just want
that.
to make that clear for the record.
Okay. Thank you. All right, so now we get to the motion to disqualify attorneys Love and Hilton, the two of the main ADA prosecutors in this case. And the basis for that, this is also filed
Let
by
Atkins take
Mr.
over.
Williams, is that they assert a need to cross-examine Mr. Copeland, attorneys Love and Hilton, and Judge Glanville with regard to the ex parte. Anything that, Mr. Steele, you want to argue that's not in your motion with regard to this? And I do have a question for you about one thing that you said.
Bring the binder. Oh my gosh. We're talking about disqualification of those two?
You want me to ask my question first?
Whatever you tell me.
So in your paragraph 3, you assert that Judge Glanville provided legally incorrect information to Mr. Copeland. I just want to make sure I'm clear as to what you assert that legally incorrect information is.
So going back to what you've read and digested, June 10th, 2024, ex parte meeting, the use immunity, as we discussed earlier, just protects Mr. Copeland. What Prosecutor Hilton And what Judge Glanville was telling Mr. Copeland was, you can say lies, as long as they're not big lies, and you will not be prosecuted. He could be prosecuted for perjury and false statements.
Okay, and when you say that, do you mean when it was mentioned that if you say, I don't remember,
No?
you
it said
can't be
it-
prosecuted?
No, I have to get the transcript in front of me, but it was, as long as Ms. Love told you, which is not in the transcript, but the Judge Glanville said, as Ms. Love previously told you, remember is a word used, unless it's a big whopper of a lie, you will not be prosecuted.
Do you have access to the transcript right now?
Yes. May I step back?
Yes, and, of course, I thought I brought it up here with me too, but I don't seem to have it in front of me either. Can you go see if it's on my desk somewhere? I don't know how it couldn't be here, but thanks.
All right, so we're looking at the transcript that we have found, there was no ex parte on June 10th, right before the ex parte. Now everybody wants to look at the transcript. And by the way, while we have a moment of silence, my mic seemed like it was hot earlier. Is this better? I turned off the auto volume.
May I approach?
You may. And I'll give that back to you. I've got a copy somewhere, just given that we're using a borrowed bench in courtroom. I don't have everything at my fingertips. All right.
But he
Okay.
handed me from the transcript of the ex parte hearing, June 10th, 2024. He directed me to page 40. It's Judge Glanville speaking, line 20. What will get you in trouble is you not, is you just invoking your Fifth Amendment privilege because you have been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said, if you overtly lie about something, like if you tell a bold-faced, not big whopper, bold-faced whopper, then they can indict you on that particular charge. That particular false statement. And then Mr. Copeland said that's what they're going to do. Then there's conversation by Ms. Bumpkus. That is what I was saying. You will be right back here. Then Ms. Hilton said on page 41, line 5, but if you say something that you know that you did not do, like you admit to something you know you did not do, whether you, and then Mr. Copeland said, like murder, don't have, like no statute of limitations, right? Ms. Hilton said on line 10, but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. Mr. Copeland saying, but y'all don't like ... His lawyer said, you could charge him with false statements and he will be back in jail. That's what I'm trying to say. And then Ms. Hilton on line 17 said, but if I know that you're lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying, I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you were trying to say you did now. And that can be part of this. I know you didn't do it. And the judge is there. So I hope that's answered your question. There's another space that I can find. I just need a second. But it's the judge saying you won't get in trouble. He says that throughout. You can say you don't recall. You won't get in trouble. There's also a place in here where the judge tells Mr. Copeland and Ms. Hilton that the statute of limitations, this is Ms. Hilton, the statute of limitations has run. In federal court, she says, I looked it up. In federal court, it's a 5-year statute of limitations. In Georgia, it's a 4-year statute of limitations. And if I could get that cite for you, I'll tell you exactly where it is. What page? I'm being told 24, Your Honor, but let me check. Mr. Adams said 24 going into 25. Your Honor. On page 24, line 12 is what I see. Ms. Hilton says, and what we'll say, and Mr. Copeland and I, we've talked about this. I'm not sure what your concerns are, what concerns that you expressed to Mr. Melnick last week. But if you are, if any of your concerns deal with being locked up for anything, you can't. Like there's nothing that can happen. The feds, Ms. Bumpkus interrupts. Well, that's not, Ms. Hilton interrupts. It is true. Ms. Bumpkus, said, no, I said that's not his concern. Ms. Hilton said, if it's his concern for his safety, we need to know that. Like that's not expressed. So we don't know what the concern is that we can try to resolve the concern. This is what I'm saying, Mr. Copeland, and I have had conversations before going to page 25, Your Honor, and here it is. I understand some of his concerns is potential criminal liability, hence why we gave you immunity. The federal statute of limitations done. The state statute of limitations done. So there is nothing, like I researched it this weekend again, both those statute of limitations for what you and I talked about, which is a 2015 or before done. You cannot be prosecuted for anything you testify federally or statewide, immune, period. So if that's a concern, there is none because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything 2015, 5 years would have been 2020. Anything statewide is 4 years. It would have been 2019 finished. Your Honor, that's just not true. He's an unindicted co-conspirator in this case.
It sounds to me like they're talking about some kind of particular crime he might or might
They need
not
to
have
testify
committed that he
then.
might be testifying about, and whether it obviously wouldn't be murder because, as he recognized,
How do you know?
murder has no statute of limitations. But that sounded like it was a really particular crime.
You can't tell a person, I wouldn't tell a person, how about that? You can't be prosecuted because statute of limitations ran when you know he could be prosecuted in our indictment. The state is saying.
Agreed.
Yeah.
That appears to me to be talking about something very particular that they've had, like a particular crime they had conversations about, and not overall broadly, you can't be prosecuted for
Testimony.
anything.
I don't know.
Okay.
I don't read it like that.
All right.
So, on the next page, page 26, it's again, Ms. Hilton, line 2, you will not, this order, I don't
Can I
know
interrupt
if
you
you.
for just a second
Sure.
too? And I'm sorry, and I do want to hear, but is there anything else that Judge Glanville said that you believe is legally incorrect information?
Yes.
Okay, because I want you
We
to
need-
address that
We
as
need you
well.
to testify? Why do we need you to testify? That Mr. Copeland had to stay in custody till all 26 criminally accused have their case disposed of? That's not true.
Okay,
That's wrong.
Yeah.
A-
that is that's on page 36 of the transcript, lines 3 through, the discussion's kind of lines 3 through 9.
At some point, civil contempt becomes punitive. Civil contempt is supposed to make the person do the act. If the person's not doing the act, at some point, it's just not effective. So it has to be then given a date certain. You can't just hold a human being in custody until all 26 people, some of them don't have lawyers, forever.
Yeah.
That's what Judge Glanville said. That's the problem. So I'm just being transparent. We're going to have a situation where Mr. Copeland's testifying. At some point, I'm going to be able to ask questions. I'm going to ask him, was there a time on June 10th, 2015 that you found yourself in an office with a judge? Was this person who I'm pointing at there, he'll say, I believe no. But the transcript says, exactly, you spoke with Ms. Love earlier.
If we get to that, that may be something that you are able to examine him about. And I do think that, you have the transcript and I know everybody has said, oh, there was Brady in there. Y'all have got it all now. So it's not Brady anymore. If it even was before, y'all have it. You can use it at trial. I think you can appropriately examine Mr. Copeland if he decides to testify.
If he
On-
decides to testify,
But some, maybe all of the things that happen in there, that may be something we have to hash out a little bit more. But let's not get ahead of ourselves. So with regard to legally incorrect information that the judge gave to Mr. Copeland, the two, page 40, 41, 24, 25, and then the one that I cited that you mentioned about
36.
all of, you may have to stay in jail till all of the co-defendants'
Your Honor, say,
trials on page 36. Anything else?
we need you to testify. Nobody needs
Okay.
him to testify. I mean, he could do whatever, it's America. He could do whatever he wants. He could sit in a jail.
Okay.
He has to pay penalty of perjury, but that's what judge. And,
All right.
they also tell him how to testify. Judge Glanville tells the lawyer first, if you remember, I could get you the transcript. You remember, you're shaking your head. Judge Glanville tells the lawyer,
Yeah, if you've got a transcript cite, I think the more clear we are, the better.
okay. It's at the beginning when Ms. Love was there. Hold on one second.
guys, it will all come down to if there's a major issue on a specific
Be
ruling
told page 30,
today,
line 5.
certificate of immediate review, if that's granted or denied. That's the indicator on,
Okay, page 30, line
This
5
judge.
is Mr. Copeland talking.
Give me a second. Okay, so I start with page 8. Mr.
Page
Copeland.
8, Mr. Copeland's not there. Mr. Copeland doesn't arrive until page 23.
Right, and you asked where the former judge was asking questions that I'd like to
No,
know.
where he gave legally incorrect information to Mr. Copeland,
Okay,
which is what you put in your motion.
well, okay, and page 8, though, if you take in consideration, starting on line
Okay.
9, the former recused Judge Glanville is telling the lawyer for Mr. Copeland, now, to be fair, I think Ms. Bumpkus, as an advocate or anybody, has got to tell him, meaning her client, he's going to face some pretty significant cross-examination. And then Ms. Bumpkus says yes, or excuse
Was
me.
that legally incorrect? I would think, given this defense team that's been accumulated, that's probably accurate, even though it wasn't said to Mr. Copeland.
The judge, though, and the motion is, calling the judge and the prosecutors and disqualifying prosecutors, the judge has stepped out of his role as a judge. What judge tells a lawyer, tell your client, whatever the words are, you make decisions, obviously, but this is how I read it. Tell your client he's going to face significant cross-examination. And you know what else? The judge goes further. The judge starts telling him that the client, he's telling Mr. Copeland that the clients are guilty.
Mr. Copeland's not here at this
I'll
point in
get you.
time. This
I'll
is
get you
his
that.
attorney, Ms. Bumpus.
All right, let me get that for you. It's when the judge is saying, they, meaning the accused, know more about your criminal conduct.
Okay.
But let me find it. Okay, on page 26, Your Honor. Line 16,
Uh-huh.
Mr. Copeland should be there.
Yes.
I'm just following what the court told me, 23.
Yep.
The court said, so if you, I believe, Mr. Copeland, are worried about what the defendants may ask you because they may know your business. But if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. Why?
Well, I think because this whole thing has to do with the fact that there was a 507 immunity order granted,
But he can be prosecuted for this case.
which is not what the judge is saying there. Okay.
I don't know. I don't know any judge who gives advice like this. Then on page,
Well, if you are, I mean, if the topic of the meeting is to ensure that Mr. Copeland understands what it means that he just got immunity, which he certainly does not seem to at the outset of this meeting, and the nuances of that. I mean, that's a nuanced issue even for lawyers. It might be appropriate in the context of ensuring the client understands what could get him in jail for contempt and what the grant of immunity means, that he would explain to the witness, the potential witness, here's what it means. So, all right, I don't find anything improper about that particular one.
okay. On page 30, it's not the judge now, it's Mr. Copeland speaking. Page 5, I believe he's speaking about the district attorney, but in front of the judge. You told me before you went to the judge with whatever thing you called, went to him with, and I believe that that's the use immunity order.
Right.
You told me I can't, when I'm asked a question, I can say I don't recall or I don't remember, excuse me, I don't know. You told me that if I plead the fifth, I mean something. Why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do, and then you was like something. So to me, telling a person you can say you don't know, nobody should tell a witness you don't know. That's all the state wanted. I don't recall, so they could get in a prior. It's in front of the judge. And then with Mr. Talking about what the judge did or didn't do for cross-examination of Ms. Hilton and Ms.
Okay.
Love, that was Brady, as you said, evidence. Yes, I have it now. But why wasn't I told that? And I
So-
want to ask questions.
Okay, so Judge Glanville is off the case. That all would go to whether it's appropriate for Judge Glanville to be on this case. That has been
Brady
taken
disclosure
care
is the state's obligation.
My understanding of the law is the motivation for any witness to testify is admissible evidence.
of. Right, and you can certainly ask Mr. Copeland about that.
And I'd like to ask the judge on page 36, line 3, until the trial is over, until all defendants have been, I got these 6 that we have right now, then there's another 6. Ms. Hilton said, no, there's another 12. The court said, there's another 12 or thereabouts that are still outstanding for various forms or another, and they're talking about he has to stay in jail. And I'd like to ask Ms. Hilton, Ms. Love said the same thing, and Judge Glanville, why would you tell him that when that is not the law? You can't
Okay.
just hold a human being.
All right, so you can certainly ask Mr. Copeland about that.
Okay.
I don't know that the prosecution's motivations are relevant to the issues that the jury is supposed to decide. And with regard to Judge Glanville, again, he is not involved in this case anymore. So I'm definitely not going to permit you to cross-examine Judge Glanville in front of the jury because frankly, it's irrelevant. And he's been recused. So to the extent that, do you have anything else with regard to why it is you ought to be able to have Ms. Love and Ms. Hilton removed from the case?
Yes.
Okay.
So, and just go back to your answer, last question, page 44, line 22, it's Judge Glanville speaking. Mm-hmm. And he said, okay, so you testify about some aggravated assault or murder, they can't prosecute you on it because that's what the order said.
Okay,
That's
hang
just
on.
not true.
I'm sorry, where are you?
Page
I may be on
44.
44.
Line 22, Judge Glanville,
Oh, okay, I'm with you.
Speaking.
Yep.
he said, okay, this is Judge Glanville, so you testify about some aggravated assault or murder,
Okay, so I'm
They can't
actually not
prosecute
with you.
you.
Page 44, line 2?
22.
22, okay. All right.
Judge
Gotcha.
Glanville speaking. Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says on the order. And that's not true. They can prosecute him, they can't use his words.
Okay, all right, I will take all of that into consideration. I don't think that I'm going to make a ruling on this particular motion today. I want to take a full look at
Wants to
all of
reread the
it,
transcript?
in context, because I do think we have to consider it in context, but I will note that one down as well.
So let me then answer your question directly. So what's going to happen in my mind's eye is I'm asking all these questions to Mr. Copeland. He's answering however he answers. I am pointing fingers at the two prosecutors. That mandates that the jurors have to rate their conduct that happened outside the jurors' purview. I am saying that he was given, he being Mr. Copeland, was given erroneous legal information. He was encouraged by the holding of hands of Judge Glanville, Ms. Love, and Ms. Hilton, that they all intimidated, coerced, directed, encouraged, whatever the right word is, Mr. Copeland to do what they wanted him to do. It's in the transcript. We need you to testify, Judge Glanville said. Mr. Copeland will say, I don't know what he was going to say. But yes, I felt that. I felt that they were not going to let me out of jail. I can't then have, nobody should have, then lawyers stand up when the jurors now need to rank what they are doing in the case. Their conduct is at issue. I'm not making them witnesses. I'd rather they stay on, to be quite frank with you. They made themselves witnesses. And the reason is because they injected themselves in such a, my opinion, inappropriate communication with a court and a sworn witness who did not ask any questions. The gentleman was represented by known counsel. He said, and it's in here, I could give you the page, but there's no reason. Take me back to the jail. Judge Glanville said, do you want to talk with your lawyer, me, or the state? Why would a judge say speak with the state and go around the lawyer, even in front of the lawyer? So all of this to me is very at the heart of that gentleman's testimony, his credibility, and it invokes and puts into effect the testimony and credibility of Ms. Love, Ms. Hilton. I can't ask anyone on the earth. I have a transcript, but I can't ask Mr. Copeland, why did Ms. Love tell you? Or tell your lawyer, if your lawyer told you. And I'm not gonna, I understand I have to stay away from attorney-client privilege, but did you ever find out this statement? And if his answer is yes, because Judge Glanville said, remember Ms. Love told you, we just read that. I want to talk about that. And then at some point, I want to ask Ms. Love, why would you tell a human being that he's going to just rot, in my words, rot in jail until 26 people are gone, which is not the law? And Ms. Hilton, why would you tell him that if he lies, and you know he lies, you're not going to charge him? Why?
Okay,
And those promises were not given to us. They were hidden from us. And Judge, this did come out. Your Honor, this did come out. I got it now. I understand that. But if you look back at June 10th, 2024, about 11 o'clock in the morning, not the ex parte hearing, recused Judge Glanville comes on the bench. Please look at the transcript because I'm not verbatim. I understand that Mr. Copeland's going to testify. Mr. Copeland's put on saying, are you going to testify? He said yes, and we rolled into questioning. I don't know how it got away from the prosecution, Miss Love, Miss Hilton, Judge Glanville. By the way, he told us things that are specific on the case. He said in here, I could give you the number, I committed all these crimes. All these crimes include murder. He's asked about statute of limitations for murder. We don't get any of that. So for all those reasons, I'm going to cross-examine Mr. Copeland. I'm going to bring all that out. And the people who are at the heart of that conversation are witnesses as well. They should not have done it. Then they tried to hide it, which I'm bringing out as well. And then just, I don't know how, but by circumstance, fortunately, whatever the right word is, we did get the transcript. If you read the transcript, I asked Judge Glanville for the transcript. He told me it was privileged.
All right, so I think this is rehashing kind of old ground that's not relevant to where we are right now.
I want to bring it all up in front of the jury, though.
Well, we'll get there when we get there.
But this is not, I cannot call anyone else. It can only go in the mind of Miss Love. Why did she call the meeting? I don't know. Anyone else could answer. No one asked for that meeting. This is my understanding. And Miss Love stands up here and said, we needed to answer questions because Mr. Copeland asked questions. I don't see that. He's represented by a lawyer. I mean, I don't see that.
Okay, well, thank you. I appreciate it.
Anyway, that's the basis of calling. I heard what you said about Judge Glanville. That's the basis why I want to call Judge Glanville and ask why did he join the prosecution team. And I believe that that then dovetails into Judge Glanville saying wrongly that I was not prepared, wrongly that I was unprofessional. And then he later acknowledges that, but he says, I'm not going to instruct the jury. So the jury's never heard that. And I heard what you said, that you'll instruct the jury, but I'm going to argue that that instruction, that the judge has no role in the case except, it's not verbatim, but except to make sure that the parties, every party has a fair trial. I'm going to tell the jurors that didn't happen.
Okay, well, we'll see whether that's going to be something that is permitted argument or not if we get to that.
Okay, but that's my strong belief
All right.
that the jurors get to know that who the judge was for
All right,
18 months.
Mr. Sharp, you look like you want to say something.
So I don't think she knows that context of him testifying, then the meeting, then testifying again, then they have the inquiry.
And I'm trying not to focus on things that we're likely to
Okay,
discuss.
and yeah, remember that this is the motion to disqualify Ms. Love and Ms. Hilton.
Right. I would just like to stress one point that, Your Honor, I know that you have joined us and weren't there on June 10th. I think it's important to remember when we're talking about the potential to call the prosecutors as witnesses. My understanding, I know I didn't call an ex parte meeting. My understanding is that Kenneth Copeland did not request an ex parte meeting. My understanding is Caleb Bumpus nor John Melnick, who served as counsel for Kenneth Copeland, did not call for an ex parte meeting. They did not express any concerns. The state called for an ex parte meeting. And in the beginning of that ex parte meeting, with Judge Glanville explaining the need for the ex parte meeting, the state made statements to Judge Glanville that accused Attorney Melnick of violating his oath and of not fulfilling his professional responsibilities and representing Mr. Copeland. They strongly insinuated that myself and Mr. Steele were somehow in cahoots with John Melnick and were somehow, I guess, obstructing justice, tampering with a witness, intimidating a witness. They presented the judge, and mind you, this is an ex parte meeting where I was not allowed to respond. Mr. Steele was not allowed to respond. Ms. Love stated to the judge, well, Mr. Melnick sent Mr. Steele and Mr. Shard an email, and he may have inadvertently included us, possibly by mistake, and was communicating with them that Mr. Copeland would not be testifying. And we don't know what they have going on between them and I guess we were just lucky to be inadvertently included, CC'd. Judge, I have the email. I believe it's in the record. I can show you the email. The state's not CC'd on the email. It's to the state.
Okay.
So that was a misstatement. Convenient. There's absolutely no, the reality is the state was meeting with Mr. Copeland behind the back of his attorney. The reality is the defense was pristine in their duties in dealing with an attorney and not with a represented individual. And somehow the state in this ex parte meeting where we were not allowed to respond or even to hear the accusations, they suggested that the purpose of this meeting was based on this behavior by defense attorneys and Mr. Melnick, which was completely fabricated and offensive. And again, we weren't there. That's the problem with these ex parte
All right,
meetings.
well, I'm going to get a transcript. I have just typed a note to Judge Glanville's court reporter requesting the transcript of the request for the ex parte itself. So I'll find out what it said and I'll share it with everybody.
Okay, well, that's in the beginning of the transcript that you have. It's in the first 6 pages, I believe. In fact, page 3 to 4.
Okay.
Page 3 to 4, they talk about this email, and we have the email.
Oh, no. I know the email.
Okay.
I'm talking about, I'll get the transcript of the Friday request as well. But yeah, I've seen the
And-
email. It's made an exhibit, I think, to the ex parte transcript.
And just so we're clear, and the reason I say that's important, because again, why are they doing this? What was the purpose of the meeting? Because that couldn't have been the purpose, because their stated purpose was completely inaccurate. And I would invite the court, I believe it's in the record, but we can certainly provide a copy of said emails.
It's an exhibit.
Okay, because that's not an accurate rendition. And you know, I'd be happy to answer questions about what happened, but that was not accurate. And these are issues that now the state has injected themselves. As Mr. Steele said, we didn't do this. We didn't do any of this. In fact, we were excluded. We knew nothing about it. And it's improper, and the state initiated all of this. And it's not just what happened in the ex parte meeting, but why did it happen? And ultimately, there's only 2 people, I suspect 1, but we'll say 2, that really know why this meeting was called. Because it wasn't called by, my understanding, Judge Glanville either. It wasn't called by his staff. It was either called by Ms. Love or Ms. Hilton. And we have the right to cross-examine them or examine them about that.
All right, thank you. Response from the state.
Yes, Your Honor.
We go with love. Thank you, William. I don't want to talk over the argument, so I'm going to
And
bookmark your
Want
comment.
to hear what you have to say? I've got your response. That's your written response. It's pretty thorough, so let's highlight what
Thorough.
needs to get highlighted without rehashing everything.
That was my intent. Thank you,
Not
Judge.
to suggest that you would, but
Your Honor, I'd like to point to the court, McGlynn, MCGLYNN versus the state, 342 Georgia App, 170 at 173 through 174.
I agree,
McGlynn,
William.
The court notes, while Webb dealt specifically with statements made by a trial judge, this court has previously noted that either judicial or prosecutorial intimidation that dissuades a potential defense witness from testifying, or the defense can, under certain circumstances, violate the defendant's right to present a defense. However, such analysis must be undertaken on a case-by-case basis. Here, we note, as did the trial court, that nothing in the record suggests that the statements made by the ADA to the witness were legally inaccurate or misleading. In fact, the ADA's comments seem to have been confirmed by the witness's own attorney, who, unlike the ADA, is charged with acting on the witness's behalf and protecting his rights and interests. As we observed in Terry, the potential for unconstitutional coercion by a government actor diminishes when a defendant's witness has consulted with an independent attorney That these statements by the ADA were later perceived by the witness as threatening is wholly irrelevant to our consideration of this matter. The court has held that the state is duty-bound to inform the witness of the possible consequences of admitting under oath facts that could place the witness in legal jeopardy, including notifying the witness that the criminal law would be enforced to the full extent against those who violate it. And that's the court citing Murray versus the state, 157 Georgia App, 596 at 598. As of course the court has noted, we have included in our response the applicable case law that we believe is most relevant to the court's consideration of the motion to disqualify. In this particular instance, Your Honor, I would assert that the why of any particular proceeding is not a material issue, is not something that is relevant to the juror's determination of the guilt or innocence of either defendant in this case. It's not in any way. It's, if anything, it would be the effect of anything said on the witness themselves, and the witness himself could testify about that. In addition to the fact, as we stated in our brief, there were multiple people there as reflected in the transcript, and there's no reason to, there's no need to resort to an extreme remedy as disqualifying the prosecutors in this case, any more than we would have the right to cross-examine Mr. Steele and Mr. Sharp based on what they may have said to Adrian Bean or anyone else in this case. So we would ask that the court simply deny the motion for such an extreme step as disqualifying Ms. Hilton and me, and we would base our argument on what we've presented in our brief.
All right, thank you. You know, something that's tied up with this issue is the fact that, there's been a motion filed with regard to it, and we haven't gotten to it yet, but I think the defense is correct, and I don't think the state opposed the fact that everything after at least the 14th and probably the 12th needs to be redone, and that is all of Mr. Copeland's testimony, or virtually all of it. And am I correct that the state pretty much concedes, agrees that that's true?
After the point where the motion to recuse was filed by defendant Kendrick,
Okay,
we don't disagree.
all right, so, and that was the 12th?
I believe.
Yeah. So, you know, we may be having a really kind of an academic discussion about all of this anyway, because if what the court is going to have to do, and I invite y'all's input on exactly how to instruct the jury about this, if we're going to be redoing Mr. Copeland's testimony thus far, we're probably, unless y'all decide you want to stipulate to parts of it, which you certainly can, we're going to be telling the jury to disregard it anyway. And if we're telling them to disregard it, then we don't need to talk about what might or might not have been significant in it, because we don't want them considering it. So y'all keep that in your minds as well. And that may be something we don't get to until tomorrow, but we have to sort of think about that as well. All right, so I am going to take this particular motion under advisement, and I'll get you a ruling quickly, but probably tomorrow.
Actually, consider one thing.
Sure.
Thank you, Lord Vegeta.
Mr. Copeland testified hardly at all on the 7th of June 2024, but then did testify the 10th, 11th,
Right.
and then the 12th is what he
Right.
referred to. And I understand we'll take up that motion tomorrow, but there was a lot of exculpatory information. I'm not going to agree to strike all that testimony.
Okay, well,
want you to be
what I
aware.
mean that we'll get to tomorrow is how to and I'd love for y'all to get together on whether there are any parts of his testimony that occurred before, the testimony that occurred before can stay.
Okay, I misunderstood what
The
you said.
testimony that occurred after the motion was filed, if there are parts of that testimony that y'all can agree to, then that will be great because it'll save us time and we'll have better contours about what we're dealing with. So I want y'all to get together about that and we'll think about that probably tomorrow, maybe the next day, I don't know, but not today. But y'all after court today can think about that together with each other, okay?
The reason I stood up, though,
Yes,
I just want to make that introduction. The reason I stood up is the following. The state elicited testimony. Now, Mr. Copeland denied it, and they've done it with many witnesses before the Honorable Court took over the case. You've never had to testify in front of Mr. Williams, Mr. Huey, Mr. Kendrick, et al.,
right.
and you're intimidated, and that's why you're not testifying. I would need to show the jury that it's the state, and I have evidence now, and the judge that has been the person to intimidate a witness. So that's another issue when you're resolving this. Can the Judge Glanville, I heard what you said, but can Judge Glanville be a witness? Can the two lawyers representing the state of Georgia be witnesses? I need that in the case because.
Okay, let me ask you this though. Why can't you use the transcript to get that point across? I mean, it's right there in the transcript. What it is that you assert to be intimidation is in black and white in the transcript.
Because I'm intending to cross-examine or examine Lawyer Hilton and Lawyer Love.
I
The
know
other
you're
witnesses aren't in the
intimidated,
transcript.
But what I'm asking you, and I don't mean to interrupt you, but I want you to answer the question that I asked you, which is why can't you use the transcript to do that?
Because Mr. Copeland can't discuss. Why are you asking these other witnesses this? And what other witnesses, how'd you treat other witnesses? There's another witness named Miss Bennett who said basically the same thing. She was intimidated by the state. My point is, I can't ask Mr. Copeland what
But the
happened with these other
issue,
witnesses.
as I understand what you're saying to me, is that you want to get before the jury that the state and the court intimidated Mr. Copeland
Right.
into testifying, essentially. What you say is the intimidation is reflected in the transcript. Ms. Love's motivation for doing it, if she in fact tried to do that, is not the relevant issue.
But I have evidence of other witnesses who were treated not similarly, because I don't have any other evidence that there was some meeting between the judge and the prosecutors like there was in this, but that the prosecutors are doing the same thing with other witnesses.
Okay.
They are intimidating other witnesses,
All right.
and Mr. Copeland can't answer those questions.
Okay, but that you can argue because you will have, look, we see that it happened here. We've already heard that it happened from the mouth of XYZ witness. Imagine, it's every witness. I mean, that's the topic of argument. So I think that I'm going to look at all of it again, but
It sounds like she's going to say,
I don't
mention it
think
in
that's a
closing.
persuasive argument for why they need to be kicked out of this case. I think the transcript is what you need and what you have, but we'll take that up later, and I will think about that.
Thank you.
Okay.
Excuse me, Your Honor.
Yes, sir.
May I just briefly address something you said earlier? Well, I did argue with the court that everything after the afternoon of June the 12th is void and needs to be thrown out.
Right.
I do not, just for purposes of the record, I do not concede that this trial can continue.
I
that we can-
understand.
Okay, I just want to make sure.
That's a couple of motions from here.
Just want to make sure
so-
that's there, because you're asking us to meet tonight to go over what could possibly remain.
Well,
And I don't know that that's possible. Thank you, Your Honor.
Well, it's possible. I mean, unless I rule today that y'all have a mistrial that is with prejudice, it is certainly possible for y'all to meet tonight.
No, absolutely. I understand that. We'll follow whatever order
right.
that you give, Your Honor.
All right, thank you. Okay,
Let's go.
so the
That's why I think
next
it's like a
motion
compromise
is,
suggestion.
Mr. Nichols' motion for mistrial and objection to mid-trial substitution of
Bruce
trial
Harvey's coming up.
judge. And it is quite lengthy and detailed with many subparts.
Well,
Mr.
Judge,
Harvey, are there things other than what is in the written motion that you want to
Well, there
talk
is.
about?
There is.
Do you want to
but-
come up here, or, I mean, it's fine if you stay there and hold the mic, that's fine.
Well, what I want to say is, I think our motion was in seriatim. Number one, we joined the motion for mistrial.
Mr. Kendricks?
Yes. So
Okay.
I
Don't
think
start
that
with
needs
us.
to be- That needs to
Yep.
be addressed first. And then our motion was in the alternative, if you do not grant that motion, then we have a separate motion, which most of these defendants have opted out of.
Okay.
So I think that that would be the
Okay.
appropriate.
Fine
We're
with
gonna-
me. I kind of had a note that a lot of those two motions go together and kind of have to be considered together anyway.
Well, one, I joined theirs, they didn't join
Okay.
mine. So it's a
right.
second step.
That's fine. All right, so it's fine with me. We'll take up Mr. Kendrick's motion for mistrial first. And his motion asserts his motion joined by everybody else except for Mr. Stillwell, is that right?
No, I joined.
You did join this one. Mr. Kendrick's motion
If we're speaking about Mr. Kendrick's motion,
for mistrial filed July 23rd.
because we were so, I am, may I make my stance clear?
Yes.
Our stance, Mr. Stillwell's stance, is that this trial is completely broken. It's broken. There's error in this trial that would never survive appellate review. Illegal ex parte hearings have occurred. Our client's rights have been repeatedly violated. The defense has been mistreated in front of the jury by a partial judge. It's broken. We are also winning this case. We are put in an impossible position right now because our rights have been violated, but we do not wish to move for a mistrial. We are merely pointing out that this case is broken, and I filed a motion about that, and I will get into the reasons when it's my turn. But I am trying to be very careful to make it clear that I am not moving for a mistrial, but I have extreme doubts about the ability for this case to continue, and I am absolutely certain that my client's rights have been violated throughout this process. Of course, Your Honor, I'm just going to put on the record, this is your first day here, so I'm not insinuating anything about your performance here today.
All right.
Thank you.
Thank you. Okay. And, you know, it may or may not survive appellate review if it continues and if there is a conviction. That's not for me to say. Okay, so Mr. Kendrick's motion for mistrial, joined by everybody other than Mr. Stillwell, essentially asks for a mistrial with prejudice because the assertion is that the state wanted this mistrial, goaded the defense into it, and under those circumstances, if a mistrial is granted, and those are the actual facts, that any mistrial would be with prejudice without the ability to try the case over again. But the determination has to be made whether the state had the ex parte on purpose with the purpose of goading, to use Mr. Kendrick's attorney's word, the defense into making a motion for mistrial because the state thinks they're losing the case and wants to be able to do whatever with. I got the concept right?
Love shaking her head no.
Okay.
We're not losing.
All right, so this is also a lengthy and well briefed, well-written motion. I will hear what you want to add that's not already in your written motion, if anything.
Thank you, Your Honor. I have nothing to add to that motion.
Okay.
As a lawyer, I feel compelled to speak to it, but I will sit down,
Okay.
given that I have no additional information. I would like to respond if the state does have something to add. I did not see a filed response from the state to our motion. I
Yep.
was served a response, so I'm not quite sure. I'm not quite sure what that's about, Your Honor.
Now, sometimes they get filed, but they don't show up in Odyssey for a couple of days. Because y'all have been good about emailing the court when you file. I haven't actually checked Odyssey to see whether it's in there or not, but I would imagine.
Love is
that if
ready.
the state served everybody with a response, they also filed it. If not, they need to. Okay, so that is a part of this motion. And another part of the motion is, well, I think you say as well that we'll need to redo the, from 612 on.
Weinstein
part
said,
of this
hold on.
That is a part of this motion, Your Honor, yes, that there is a requirement that everything after 612 is void.
Okay,
And in that motion, we argue what I stated earlier, that I don't believe it's possible
That it's
to
not
erase
possible.
that information from the jury.
Okay.
Also, I'm happy to take any questions you may have.
Okay, I appreciate it. All right, so, yeah, so there are a lot of different grounds in here. There's the state sought it because they wanted the defense to ask for a mistrial so they could get a mistrial and try the case over again. That substantively speaking, the ex parte was a critical stage at which the defendants were excluded. And then the concept of, which we've kind of brushed over somewhat, that Judge Glanville's comments in the ex parte itself amounted to unconstitutional coercion of Mr. Copeland to testify.
Those are exactly my arguments. That's correct, Your Honor.
Okay.
There's three main issues, three main arguments that I put forward in that motion. The only thing that I can think of that maybe I did not sufficiently highlight is just the tremendous experience of the prosecutors and skill of the prosecutors in the state as both, in this case, as both attorneys and prosecutors. So I cannot believe that they would not have asked for this ex parte, conducted the ex parte in the fashion that they did it, unless they knew that they would be forcing us into a position to request a mistrial. As Mr. Shart has said, we are winning this case. The state's witnesses have not testified the way that I imagine they expected them to testify. And I do not believe that they should be allowed a do-over in this case, Your Honor.
All right.
But I'm not going to repeat what's already in
Okay.
front of you.
Okay,
Thank
thank
you.
you.
Again, if you have questions, I'm happy to
All right.
answer any.
And then also sort of in this motion and asserted in a lot of the defense motions are what we again touched on, that Brady material arose from this ex parte and y'all have it now, so it's not a Brady violation anymore.
And that-
To the extent there was.
And that's not a real requirement
Okay.
in order to grant our motion, Your Honor.
All right, I just wanted to make sure I covered that as well. Okay. Does the state want to be heard with regard to anything not already in their response?
Yes, Your Honor. Just based on Defendant Kendrick's representations to the court that, and others, that they're winning, and therefore we goaded them. If they're winning, then let's just keep it rolling, because the state vehemently objects to a mistrial.
Okay.
And I am unclear how we are arriving at the conclusion that the state, in conducting something according to the rationale presented to the court by the defendant so far, that the state never intended that they find out about in an effort to cause them to do something. I don't know how those two can be squared with one another. So we would ask that the court deny the motions for a mistrial based on the state, based on anything. I'd point out that this is not the first or the second or the
So
third.
she's gonna argue
motion
all the
mistrial.
motions
The state
now.
has objected every step of the way. We continue to object to a mistrial. Again, if they feel they're winning, let's keep it rolling. And we would ask that the court just deny it. Of course, the court is aware that the issue here is not whether anyone acted improperly, but what objective the prosecutor is trying to achieve. It does not make sense to assert on the one hand that we want you to not ever learn about it, and on the other that we are intending that you be goaded into an act by our doing it.
Okay.
So, thank you.
Okay, that was the
There
whole
are
argument
issues
for
here
all
as
of
to
them?
Whether people acted improperly. Perhaps that does not go to the goading, but I don't want to, it's clear in my motion that we are arguing that there was improper conduct by both the state and the judge that violated Mr. Kendrick's rights. He has been locked up in Rice Street for 22 months. I have done everything that I can to move this trial along. I filed a motion, I believe at the end of March or early April, to try to get this trial moving at a more deliberate pace. That motion was essentially denied. I have no interest in retrying this case, Your Honor, and we are winning, I think, by any measure. So I'm asking for this mistrial, but I'm doing it because I have absolutely no choice but to do that, Your Honor.
All right, thank you. And I don't know whether this was, I think this was Mr. Nichols' reply to the state's response. So I don't know if it was with regard just to Mr. Nichols' own motion for mistrial or also Mr. Kendrick's motion for mistrial, but I think it's, the argument is applicable to Mr. Kendrick's as well, so I'm going to address it right now. Mr. Nichols argues that the state says that the defense's characterization is a mischaracterization of what happened in the ex parte, but does not offer their own characterization, and therefore they essentially aren't opposing it. And I should just take as fact everything that the defense said. And I do find that the prosecution did, in fact, oppose the characterization made by the defense and posit their own characterization. In their response, they say, quote, "the hearing in chambers was proper," unquote, and then quote case law. So that to me is not the state saying, yeah, your characterization is right. That is them saying, no, we were not trying to get a mistrial here. We didn't do anything improper. So with regard to that issue, I'm not finding with Mr. Nichols. Now, I am going to, in the context of taking under advisement the other motion that we talked about before, take under advisement the concept of whether what occurred in chambers was coercive, and if so, was coercive to the extent that under the cases like, I think, Wynn and Webb, it requires a mistrial. Because I think the concept generally was before Judge Krause, but not in the kind of detail that it is right now. So I do think that that is something that I can take into consideration and will take into consideration, and y'all have both briefed it, and so I'll get the ruling to you. As with regard to the propriety of the ex parte itself, we've kind of already talked about. I don't think that was the actual basis of Judge Krause's order on the recusal, so I will endeavor to make a substantive ruling on that as well. So that's another one that I'll probably give you my ruling tomorrow. Okay. So, making myself a note. All right, now to Mr. Nichols' motion for mistrial, which, in addition to everything else that's in Mr. Kendrick's, essentially says that there are reasons why the mid-trial substitution of another judge makes this impossible. And
She was cited
Mr.
in it
Harvey,
herself.
I-
Whitaker was a footnote.
no,
I apologize. Can I interrupt you again?
yes,
Thank you. I do that with, a smile and a request for permission.
okay.
Again, I think there are several other mistrials with prejudice that have not been heard by you, and that would include Mr. Williams filed on July 10th of 2024, entitled in part, Motion for Mistrial Based Upon Judicial and Prosecutorial Misconduct and thus bar retrial. Mr. Shart, on behalf of Mr. Jackson, also has a mistrial with prejudice pending that I don't believe the court has heard. And again, I think in seriatim, if you decide on all of those, then I'll come behind these brilliant lawyers.
All right, I
and
appreciate it.
follow up.
So with regard to
I love
Mr.
Bruce.
Williams earlier, prior to the, July 9th. Honestly, I don't know that I saw a motion to recuse filed July 9th, but when we talked about all of the pending motions before, there was the July 10th motion for a fair trial and for mistrial on prosecutorial and judicial misconduct. That's one of the first motions I took up today. Is there another one? Yeah. Well, I did. That was one of the first ones. Is there another one other than that? Yes.
Mr. Williams is not asking for a mistrial. If you grant a mistrial, then that would be over objection in that if you grant, I joined in the goading. See, I think it's a two-step process. You grant a mistrial or deny a mistrial. If you grant a mistrial, then there has to be a conversation about a plea and bar. So I'm joining. If you grant it, it'll be over objection, then I'm going to file a plea and bar. So I was just upfront with the
Okay.
court. So
But
you are
with regard to anything, is there any motion for mistrial filed by you on behalf of your client other than the kind of, not really omnibus, but multifaceted motion you filed July 10th that was for a fair
Omnibus,
trial to get all the ex partes
multifaceted.
for mistrial based on prosecutorial and judicial misconduct?
on Friday, July 27th, I filed a response to the state's, you called it a gag order. And in that, the second part, I also filed an adoption that if you declare a mistrial, it will be over objection. And then I will be raising a plea and bar because it would be, the only reason to declare a mistrial is because the defense was goaded into it. So that is it. So
Okay. All right. So Mr. Harvey, I don't think Mr. Williams has another one. And then Mr. Shart, on behalf of Mr. Stillwell,
July 23rd at 3:07 PM, a motion for fair and constitutional trial. I believe I have a lot to say.
yeah, and
And I believe I'm similarly situated to Mr. Steele in many ways regarding that, because I do believe we're being goaded into moving for a a mistrial. I do believe that the case law supports that conclusion. I do believe that so much in this case has happened that has broken the case. I believe, and I'd love to be able to argue all of that, but I am not specifically asking for a mistrial unless jeopardy attaches.
Okay.
And so that's where I'm at. I'm happy to argue that. I'm happy to argue that before or after Mr. Harvey or Mr. Steele.
Okay, give me just a second. Sure. You know what? I need to find the motion that
We're getting a comfort
was
break?
just referenced by Mr. Shard. Anyway, why don't we've been going for a couple of hours. Why don't we take a 5 to 10 minute convenience
break.
break? All right, we'll be in
Convenience
recess.
break. Guys, we have a new term, convenience break. Okay, so I had put these on pause because I don't like to interrupt when they're speaking. I don't want to not hear an argument. But William Clodius, thank you for your super chat. William had said, the judge is making assumptions about the context. So this was going back to all of the conversations about the transcripts when Brian Steele was making arguments. Steele should note that such assumptions aren't necessary, and the facts can be clarified by examining Glanville, Love, and Hilton. And I think I saw a lot of similar sentiment in the chat. And I think ultimately at the end of that conversation, the judge did kind of concede, I need to look at the context. I want to reread, I want to parse through these transcripts again, because maybe. And it did seem like she was reluctant to agree on certain points, like, yeah, that the contempt holding him through all 26 defendants being tried, that was a little incorrect. That's not good. So she did concede. It did seem like a little bit reluctant to me. I'm not going to say it didn't seem reluctant. And then at the same time, Steele had come back up to kind of reiterate, like, look, there's a problem here because these transcripts don't answer questions about what the state may have done with other witnesses. You say that we're fine because we have the transcript, but we don't have transcripts for these other meetings. What about when the state was talking to Adrian Bean? What about when the state may have had meetings with Trontavia Stevens? What about any other witness that they may have intimidated or coerced, as we're defining it as? That this transcript that they've made available to us can't answer those questions. We would still need to question Love and Hilton and maybe Judge Glanville if he was also present. So I think that was a really good argument. I think it maybe could have been made right away rather than him coming back up to the stand to make. And I think the judge gave a suggestion. It's not her final ruling because she's still going to look at this and make her findings. But she gave a suggestion to Steele that kind of made it seem like, well, you can bring that up and just mention they've done this before. Which to me seems like because you have this one piece of transcript as a piece of evidence, you can suggest in your closing statement, well, you guys don't know if she's done this with the other witnesses. And make the whole closing statement shaped around you can't trust what these witnesses that are against what, or that are in favor of the state's argument, and trying to claim that my client or any of these clients did something wrong. You can't trust that they weren't coerced into saying those things. So you need to be super critical of those witnesses' credibility. Not because they meant any harm or they're trying to be dishonest on the stand, but because they may have been under duress, because they may have been coerced, because the state may have done what they did to Kenneth Copeland to these other witnesses. And if you can't trust these witnesses, what else evidence is there of my client's guilt? So go in, look at these charges, and find my client not guilty on all counts. Something like that. It seems like she was making the suggestion to rope that into your closing argument, which is not what Brian Steele wants. He wants to be able to get testimony, do more cross-examination, further probe into this. That way there's evidence about the individual situations, not just Kenneth Copeland. So I don't know if The judge might reconsider some of that stuff. Her suggestion to me seemed like a compromise suggestion, and we'll just have to see what she says tomorrow. And then Lord Vegeta. So thank you so much, Lord Vegeta. The way this judge is addressing this is rubbing me the wrong way. I'm not sure if it's the judge's demeanor or her attitude towards this. Feels like she's determined to throw out Bryant's argument no matter how legally sound, and maintain that finding that there was nothing improper about the ex parte meeting. I would add that in there, right? It might not just be to push aside Brian Steele's argument, but to protect the finding that it was a proper meeting. So, and then you guys seem, let's see, you guys are talking about don't let it be a more than 15-minute comfort break. Actually, let me pull up, we'll get some closed captions in. We'll switch over to the law and crime stream while they're on this break. And what do you guys think about the state's response to all of the motions? We have like one blanket argument that was like a 60-second argument from Love saying, we vehemently disagree with all of this. We don't think they're winning, and they keep asking for mistrials, and we just disagree. We don't agree with this at all. All right, so we'll switch over to law and crime. Actually, hold on, let me close my other tab, otherwise I'll have two audios again. And law and crime has closed captions, you guys, so we will be able to hear the non-microphoned attorneys in the back row, in the cheap seats in the back. Okay, so let's actually talk about this too. So Susan Davidson, I think Whitaker is wholly unprepared. I agree, but I don't think there's a practical solution to that. If you get what I'm saying, like, I don't think there's a way she could balance being prepared for everything she has to answer questions and rule on, while also not holding the jury forever and ever and ever and ever. So this is really where Bruce Harvey's argument comes into play. And Doug Weinstein argued it a little bit too, that it's just impossible. How do you do this? You either, on one hand, Doug Weinstein really focused on the jury issues, the curative instructions. How do you have the jury come back after this break and tell them not to think about Dumbo and not expect them to think about Dumbo? Bruce Harvey's like, there's no way you can make proper rulings and move this trial forward fairly on anything that's still outstanding, anything that was left open in the air, anything that we're asking for reconsideration on, because you can't properly revisit the entire record. It would be improper, and we don't have complete access for you to see the record in the way that you're supposed to be aware of it. So I don't think, and again, Whitaker's a footnote in Bruce Harvey's motion. She's a footnote for saying it's an impossible task. So I think Whitaker knows. I don't think she could have been prepared. It would just be impossible. And even if it was possible, it would mean at the expense of those sitting in custody, other cases not being tried, the jury having to hang out for however much longer for her to get caught up. It just doesn't make sense. Doesn't make sense. And then Kristen says, I see it as this judge is doing the same thing. Well, you can argue it. Well, is that why we're here today? Yeah, definitely a bit of that for sure. And remember, these arguments, this is a court hearing, it's on the record. So these things that Brian Steele might be raising, he could challenge on an appeal. And of course, that's not the victory, right? Because that's way down the road. You don't want to try to hinge on having to make an appeal, one, and then two, hoping that an appeals court agrees with you. But at the same time, arguing the stuff isn't exactly for naught. It's still on the record, and it could still be referenced for some kind of remedy further in the future. And Julie, I agree, maybe she could have been more prepared, but I mean, what if she had another case she had to be tidying up during this, and then she just gets a new court reporter, her court reporter just retired? We're looking at, really, she wanted motions filed by the 23rd. Obviously, responses were coming in after that, but then there were motions filed after the 23rd as well that should have already been filed. Like, I just don't see how there's a practical, I absolutely 100% agree with Bruce Harvey that it's just an improbable possibility that anybody could get caught up with this. And that bothered me. I don't think she really gave the transcript a good read. Do you guys think she gave the transcript a good read? And part of that could just be not knowing the context. I think she signaled that she didn't really understand that gap on June 10th, where Woody's good to testify, he comes back on the stand, he testifies for a bit, and then there's an inquiry. Where there really wasn't, and she doesn't want to come out and say that there was a disclosure issue. And she said flat out that Glanville's not at fault and he's recused, but really a Brady disclosure issue would fall on the prosecution. And she didn't explicitly exonerate or condemn either way. She didn't really address the prosecution not disclosing this meeting at the time that Woody got back on the stand. Which I think that's when she kind of said, oh, I'm going to look at the context more, and probably I'm going to have to get back to you tomorrow on that. As soon as she realized that little bit of information, I think she was like, all right, hold on. Let me pump the brakes at least a little bit. It might not be pumping the brakes like we might think that she should be pumping the brakes, but she did pump them a little bit. And then let's see what else you guys are saying. Everyone's like, no, 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 no. Yeah, she's assuming a lot. And that's the thing, you guys. If this trial keeps going, I do think the defense is winning. I think it would be better for the defense to have Love and Hilton continue on with this case. Because somebody else, if they redo it and they put someone else at the head of the case, it could be a lot stronger of a presentation. Or maybe the case would be worse because they wouldn't get some of the stuff in that, doesn't really tell the story, isn't really relevant, shouldn't really be admissible. Maybe it would go a totally different way. But I do think in this trial, the state has gotten to do a lot of what they wanted to do. They've gotten in a lot of things at the furthest extreme of judicial discretion. And they've been so loose with their presentation of it that I really doubt that the jury's following it. So I totally agree with Doug. Doug Weinstein's like, we are winning. And he goes away and he comes back up to the podium and he's like, I want to say it again. We are winning this case. So I agree. And if this keeps going and Woody gets back on the stand, I mean, that cross-examination could completely decimate the state's case. And notice that nobody's trying to strike the days of the testimony where Woody is describing, well, I tell them a little bit of a lie. I tell them a little bit of a truth. And I use that to buy some time to figure out what they really want to hear from me. Because I know if I tell them what they want to hear from me, I can say my piece, they think they got what they want out of me, and then I get to go home, I get out of there. They're not trying to cut out days 7 through 11. So that Friday, Monday, and Tuesday. They want to allow all that in. The state didn't object. So they'll be able to cross-examine, because cross-examination has to relate to the scope of direct. All of that stuff that we watched on that Monday and Tuesday. I guess most of it would really be that Tuesday, because Monday was mostly the inquiry, and Ashley Merchant and Alex Souser coming in. But on Tuesday, all that stuff would still be part of direct for Brian Steele to cross-examine on. He can ask, what did you mean by that? Why would you say something like that? Were you met with the prosecution before your testimony, correct? How many times did you meet with the prosecution before your testimony? Did they help you prepare for your questions, what you're going to be asked? Did they help you prepare your answers? Did they help you by suggesting that you could say things like, I don't recall, instead of saying you didn't want to testify? He can start asking all of these types of questions on cross-examination. And you really got to think about, if you were a juror and you were sitting there and you were watching this witness, that is really like the linchpin. He's the one tying everything that the state needs to introduce further evidence, lay further foundation. If you got to watch the defense attorney, especially when you've been off for like 2 months, and you come back and we watch some more boring videos, but then the first action you get is cross-examination after these long videos, and we're coming back. What would you think as a juror? Would it help you lean one way or the other?
The audience is that there's been kind of a lot of up and down and back and forth and in and out, and that is distracting. So I know there may be times when you need to step out for a particular reason, and that is fine. But let's try to minimize that, because if it gets too distracting, I'm going to have to ask you to step out until all your business is taken care of. Okay, so you got to go out, but then it can't be a up and down every 5 minutes thing. All right, thanks. Okay, so Mr. Short, yes, I saw your motion for a fair trial, and the reason I didn't register it as a motion for mistrial is because it's essentially not. It's saying if you grant a mistrial with prejudice, we're in on that. But otherwise, we'd like to, even though we think this trial has been a disaster, we would like to keep going because we think we're winning. So you asked that it be a constitutionally fair trial, and I guarantee to everybody, to the extent that is within my control, I want for everybody here to have a fair trial under the Constitution of the state of Georgia, the United States, and the laws of our state. Okay, that is why I am here as a judge, to make sure that that happens. So to that extent, it's granted.
I appreciate that. I guess my concern is that all this is not under your control, because you're taking.
And I can hear you fine, but I don't know whether my co-reporter can or not. You can either come up or you can pick up your mic if you're just a long way away.
I'm glad she's addressing the microphone thing. Thank you, Mark and David, for becoming members. And thank you, I was
guess
thinking.
my concern is that I have no doubt that you will do everything in your powers. I just don't know if at this point, if it's within your control to ensure that we receive a constitutionally appropriate and fair trial at this point, based on what's happened previously. And, you know, I do have cases regarding the concept of goading.
Okay.
But I'm trying not to step out of turn. I know that I am stepping out of turn a lot this morning, but I'm trying to not step out of turn. If you would like those cases.
Yeah, I'm happy to take into consideration anything that y'all want to offer that is on point.
Go.
And I was thinking, I think we might hear this more throughout
Can't
the
really
mistrial
get
arguments.
to me, but you can get to my staff who can hand it to me. Thank you. Oh, yeah, I've seen web-cited, and I'll take a look at Jackson and Wilson.
Oh, did I not give you Anderson?
No,
Oh, I'm sorry.
thank you. Okay.
And Your Honor, I believe that those cases stand for the general proposition combined. Each of them are a little factually different,
Okay.
but they stand for the proposition that the trier of fact can consider certain factors. Of course, the difficulty in determining if someone's goaded someone else comes down to intent. Typically, a district attorney or a prosecutor is not going to take the stand and say, I intentionally goaded someone. So you look at objective facts. And these cases stand for the proposition that you look at how basic the rule that was violated is, the experience of the prosecutor. In this particular case, you know, this is a big county. The prosecutors involved in this case are a chief deputy with the district attorney's office and a deputy with the district attorney's office are the two prosecutors that were involved in the ex parte meeting. You look at the evidence of the case, and I know that this is another area where you're hamstrung a bit because you haven't been sitting to hear the evidence. But I concur that the whole purpose of Mr. Copeland taking the stand was to impeach him. Mr. Copeland's testimony was not, well, at the time of this ex parte hearing, it's our stance that he was pleading the fifth, and the state was in a position that their key witness, and without him, the alleged murder of Donovan Thomas, without his past statements, goes away. And they were in a situation where their key witness was not taking a stand and was not going to allow himself to be impeached with prior statements. And our stance is that they panicked and they needed a mistrial. The trial was not going well. The previous witnesses that have testified has been again, I know you haven't been here, but we've had witnesses testify. I don't remember anything that happened in 2013. It's just been a parade of impeachment.
Have you ever
by
gotten in a car
inconsistent
accident?
statements
I don't remember.
and contradictions. So, and that's another factor that those cases look at is the how the trial's gone so far and the motivations for goading a mistrial. So I believe that those cases provide some insight and some guidance for the court to consider certain factors when we get to that goading question. And that's why I wanted to bring those to the court's
All
attention.
right, I appreciate it. Thank you. All right, so Mr. Harvey, you're up. I don't think there are any other motions for mistrial preceding yours that we have not discussed. And I am going to address a few of your issues really, well, I guess one I'm definitely going to address before you start your presentation, and that is that you assert in your motion that this court, meaning me taking over this case, has indicated it does not intend on familiarizing itself with the trial proceedings. And I have no idea where you got that from, because I certainly never said that.
When we were here last week, and I don't have a transcript of that, and if I've misinterpreted what you said, and perhaps it was in the context of you saying, I'm not going to revisit certain motions, or I'm not going to go back to hear those, that was in the context that I meant it. And I said it for a specific reason, because some of the motions, as I allege in our motion, Judge Glanville said, well, I'm going to deny your motion, for example, for a severance, for a 105 instruction at this point, but that does not mean we're not going to get to a point where I would consider that and grant it. So I meant that in the context of you understanding, this court, understanding the cumulative nature of what has happened and how it would factor into your particular decision at the next point in trial. That
makes a little more sense. I absolutely intend to familiarize myself with what has gone on in this trial prior to me getting involved in it. I've already begun to. Judge Glanville's court reporter is beginning the somewhat arduous task of transcribing everything that hasn't been transcribed yet and giving that to me, as soon as she finishes it. You all have, some of you have already pointed out, particular things that, while not the official transcript, I can review on YouTube, and I've done that to the extent it has been relevant to these motions. And I also believe that with the very capable defense attorneys in this case, that you all will be able to elucidate for me anything that I might not have been here present for at the point in time when you make a motion that to any extent requires considering the cumulative nature of anything. Okay?
So how didn't she know about
well,
the June
okay,
10th
yes and
partial
okay, no.
testimony?
Okay, yes, I understand that the court is going to make what I think to be an impossible effort to catch up to where we are at this particular point after 9 months or thereabouts, hundreds of witnesses. I appreciate the court's effort, and I understand the genuineness of the court's statements that I'm going to do it. But you know what? I just don't think it's possible. And that is the gravamen, that's the base of what we contend should be a motion for mistrial qua mistrial. I have joined in we've been goaded into it. But now the second layer of that is I am going to stand here. My team is going to stand here. Everybody in this courtroom is going to stand here and look at you and say, Judge, the state, I want a directed verdict of acquittal. The state has not met their burden. I believe you have to be entirely conversant with the record, with the way witnesses have testified, their demeanor, their voice, their actions, all of which may or may not be caught on YouTube. And there are a plethora of cases. There are many cases that say, you know, just reading a dry transcript is insufficient. Every court from the US Supreme Court down has said you can't necessarily make those kinds of judgments based upon a dry transcript. And I believe that to be true. There's a world of difference, and you know this. Every practicing lawyer knows this, that you cannot get the feel of a lawyer. You cannot get the context. You cannot get the understanding of a witness unless you're there to view that witness. So I start from the premise that no matter how hardworking you may be, and I think you're a very hardworking judge, I think that you will make every effort, but I think that it is impossible for when we get up and make our motions for directed verdict that you can assess the now going into the 9th month of trial testimony. That's essentially basis number one.
Okay.
More importantly, I think that should you erroneously deny our motions for directed verdict, that you then would be in a position to sit on our motions for new trial. And that's the so-called 13th juror. We have put that in our response, and it is without question. We have our courts, the federal courts, all say that there is a distinction between whether there is sufficient evidence to go forward, which is the standard on a motion for directed verdict, and a 13th juror motion for new trial. You can find, you know, I denied your motion for directed verdict, but you know what? I just don't think that this was either a fair trial or a trial in which, based upon what I have seen, what I observed, that should stand, and I'm going to grant it. I mean, it's entirely in your discretion. And that discretion is unreviewable, really, by the appellate courts. And they have all said, as we said and quoted in Wilkerson, that the discretion, the trial court must consider some of the things that she cannot when assessing the legal sufficiency of the evidence, including any conflicts in the evidence, the credibility of the witnesses, the weight of the evidence, meaning that the trial judge may grant a new trial on the general grounds, even when the evidence is legally sufficient to sustain a conviction. So I know that we're going to stand here and make a motion for directed verdict, that God forbid, if any of these defendants are convicted, we will come back to you and say, Judge, motion for new trial. sit as a 13th juror. Don't think he can possibly catch up to that extent. Nor do I think that, based upon the cumulative nature of Judge Glanville saying, I heard you when you want a severance. I'm denying it now, but it may come to the point later that I'm going to grant it. So 3 reasons that nobody else has argued to you, essentially, for a motion for mistrial or a severance as to Mr. Nichols. 1, the motion for directed verdict. 2, the 13th juror. 3, the continuing nature of the motions to sever in for a Rule 105 instruction, a limiting instruction, which the court said, you know, I'm probably going to give that at the end of the trial, but I don't think it's necessary to give it now. So,
Okay,
all of those.
I understand. And I don't really need to hear from the state on this one. With regard to the directed verdict issue, the standard, as we all know, is essentially an any evidence standard. It is entirely possible that just on what gets presented going forward, I will be able to rule on the motion for directed verdict, assuming we get there. But if not, I can and will ask for specifics from the state as to what the facts are supporting each count of this indictment. And it is not for directed verdict whether I'm convinced, it's whether there is any evidence from which a jury might be convinced. And so we'll take that up when we get to it, but I don't think that the fact that I'm coming in mid-trial is a basis to grant a mistrial in this case. With regard to the 13th juror, I understand that's a different standard. There are times, it's not routine, but it happens when a different judge from the trial judge considers the motion for new trial and considers the 13th juror issue. And the appellate courts have recognized that it is a somewhat less deferential standard when they're looking at it on review, when it is a different judge than the trial judge. So, you know, if and when we get there, I will consider whether anything ought to be granted as a 13th juror, if y'all ask me that. And if I deny it, then the appellate courts can consider it. But that is not anything unprecedented. It happens all the time that one judge does the entirety of a trial and then another judge considers the 13th juror issue. So that is also not a basis on which to grant a mistrial. And with regard to the severance issue and the cumulative nature of that, I'm going to rely on you to point out to me everything ought to be taken into consideration if and when you make that motion again. With regard to a 105 limiting instruction, I am happy to consider anything that you all think might be appropriate to give right now. Okay, so I invite y'all to submit something.
105 is this evidence might not apply to all parties, so don't consider it except
Make
for the
sure
pertinent
that-
parties.
My motions were also based on the underpinning constitutional rights, both federal and state. And I don't want the appellate court to say, hey, she didn't say anything about that. But I want to make sure that those bases are preserved. Although I disagree strongly with your ruling, I'm still here.
All right, understood. And it is so noted. And obviously it's to whatever it is that you have, any of y'all have set forth in your various motions. All right. All right. I think we all already sort of agreed that we need to redo everything that happened post recusal motion on June 12th and the details and logistics of that we'll take up probably tomorrow. But that motion itself is granted. All right.
That's reversing
A
to
lot of
June
what
12th.
comes next is evidentially specific. And before we get to that, I know that there are some outstanding bond motions. So Mr. Steele, on behalf of Mr. Williams, has filed a motion for bond reconsideration, but Mr. Steele, you essentially go back and argue anew all of the factors that I don't even know who took up the bond to begin with, but another court has already considered all of those, the IALA factors. And you don't present changed circumstances. You just essentially say this call was wrong to begin with and you should do it over. And I am not going to reconsider any bond issues that have already been considered and ruled upon by another court absent legitimate changed circumstances. So that motion is denied.
Can I address the court?
Do you have changed circumstances? So, okay, go ahead. There weren't any in your motion.
Mr. Williams has been in custody since the 9th day of May of 2022. This is in my motion. Or it should be in my motion. He has sat through unnecessary jury selection for months, bringing in over 2,000 people when the jurors were chosen from the first 511. That should not be on him. This is excess. He's now sat here for a month while the antics of Judge Glanville and Lawyer Love and Lawyer Hilton cause him to just wander and squalor in a jail. The case is, God forbid there's a conviction, going to be reversed potentially because these are serious issues and I've raised them. I've put them to the court. There are issues of confrontation clause violations, prosecutorial misconduct, judicial misconduct, not being present at a critical stage of proceedings. There is no reason to believe that Mr. Williams is fleeing. He would be crazy because if he flees, the case goes on because it's mid-trial and he waives his appellate rights. He has the strongest ties to the community and the backing of wonderful people, both near and far, who are willing to come. Those are my changed circumstances.
All right. Thank you. I do not, they are changed circumstances from, yes, things happened after the bond was decided to begin with. I don't know how I would have decided the bond originally. That's not before me. Those are not the kind of changed circumstances that speak to the IALA factors. And so I'm not going to reconsider the bond.
Well, let me ask one more then. There is a judge who joined the prosecution team. He said, we need a witness's testimony. He encouraged the witness, more than encouraged, to testify against Mr. Williams. I think that should come anew to the
All
court.
right. Well, that may or may not be a substantive error in these trial proceedings. I've got that under advisement right now, but that also would not be an IALA type change circumstance.
Okay.
So I appreciate you presenting this to me, but I'm not going to reconsider bond.
Okay. Even though potentially it was not done by a fair tribunal.
I don't, all right. There is nothing, and I'll make a determination with regard to that substantively, but I will note that Judge Krause, who had a lot of these issues before her in the motion to recuse, her finding, while I think dicta, was that there was nothing improper. She said, you know, maybe I'd have done it differently, but that there was nothing improper substantively with what occurred. So at this point, we don't have, and the basis of her recusal was not that Judge Glanville is biased. It was that he engaged too vociferously in setting forth facts and information when he denied the motion to recuse, and that was not what the rules require, and so recusal was necessary. But she even, I think, went on to say, but even with that, I don't, I think he could have continued on unbiased. It's dicta, but right now, that is your position in the litigation. It's not a factual finding. It's substantively before me. And if that is the case, then there will be a different ruling made that will impact this trial, that may result in a mistrial, that may result in a mistrial with prejudice, but that would not impact a reconsideration of bond. Now, if there's a mistrial without prejudice, then bond maybe could be considered then. That might be a changed circumstance, but right now we don't have that.
Then I'd like you to address just one last thing then. Judge and district attorneys come out after the ex parte hearing and not a syllable about Brady evidence. It all should have been spilled right then. That's an ongoing concern. So my point is, you have the same judge denying bond, the same judge hiding Brady evidence. So I'd like you to consider that.
All right, thank you. I understand. It's not an appropriate consideration, but I understand what you mean. All right, Mr. Huey has
Harrison
a
Matthews.
motion for reconsideration of bond with asserted changed circumstances.
They need to argue that their financial situation has changed. Their income is not the same as it used to
ex parte
be.
being a critical part of the
So they
trial
can't
that he was
necessarily
excluded
afford
from,
to run
and
away.
having been held longer than he otherwise would have because of the delay resulting from that. Do you have anything to add to that, Mr. Matthews?
Yes, Your Honor. Good day to this honorable court. Carrington Matthews for Mr. Marquavius Huey. I cite for the court Wimbush versus the state, 345 Georgia App 54, which is cited in my motion. When a court has previously heard a motion for bond, its ruling is not subject to change unless the court finds that the movement has presented new information, testimony, or evidence that indicates a change in circumstances. Wimbush, when it talks about new information, new testimony, or evidence that indicates a change in circumstances, I would like for the court to consider that the change in circumstances as it relates to this particular proceeding is that when the court denied the bond to Mr. Huey back in 2022, it determined that he did not meet the Ayala factors. This same court, in making that determination in 2022, the change in circumstances, the new information, the new evidence is that that same court that denied the bond in 22, that court indicated in or on June 10th, it had a meeting that this court has heard over and over again now with the state, right? With a sworn witness, right? And in the transcript, Your Honor, the court that denied the bond to Mr. Huey then, that court engaged in conduct which I believe influenced the witness, caused that witness to reconsider his position that he was not going to testify, talking about Copeland, caused that witness to, rather than say, I'll sit in jail, co-signed on the state of Georgia's recitation that, no, Mr. Copeland, you will sit in jail until every single defendant on this indictment is tried. So what I'm asking the court to do is look at what is the change in circumstance here. The change in circumstances, we want Mr. Huey. He wants an unbiased, a neutral referee to decide whether or not he is a good candidate for bond. I would assert to this court that that has been clouded because a neutral judge, a neutral referee would not have engaged in the conduct on June 10th, which essentially is why he has been recused. So I'm asking the court to say, hey, look, there has been new information, because that was not information that existed when the court decided that Mr. Huey was not a good bond candidate. That was not evidence when the court decided that he was not a good candidate. And we're looking at a judgment call here. The court has to be comfortable. The court has to be confident that when a request for a bond is made, that the candidate, based upon the change in circumstances, would be a good candidate for a bond. Now, Mr. Huey has been in custody since December 14th, 2021. It's a long time. Now, Judge, we have been out of court, out of session for over a month and some change and still counting. That delay, Your Honor, is a change in circumstance for Mr. Huey. He is on 23-1 at the Fulton County Jail. He's on lockup for 23 hours out of the day. 1 hour out. We don't have to go over and over what the conditions are at the Fulton County Jail. We know what they are. The news media shows us what they are. He tells me what they are. When I go visit him, I see what they are. So what I'm asking the court to do here is look at those change in circumstances. Now, here's another factor. How much, Your Honor, does it cost the taxpayers of Fulton County, Georgia, and the state of
Mr.
Georgia?
Matthews, that is not an appropriate consideration for bond.
I would ask.
Period.
Understood, Your Honor. I'm asking the court to look at the resources that are required to have Mr. Huey here every day. That's all I'm asking the
Not
court to
appropriate
look at.
consideration for bond. All right.
So essentially, Your Honor, I'm asking
Public
the court
interest is
to
kind
look
of a
at the change in
factor
circumstances that I
for
have
bonds,
cited in my
public
bond
safety,
motion.
public interest.
I'm asking the court to take that into consideration, that the decision to deny the bond for Mr. Huey in 22 was made by the recused court. And the change in circumstances that I am alleging were done by the recused court
All right.
based on judgment calls.
Okay.
So, Judge, I'm asking the court to set a reasonable bond with conditions. Here's what I'm asking the court to do. Put a number on the bond. I'm asking the court for a $50,000 bond. I'm asking the court that Mr. Huey be required to live at a certain residence here in Fulton County, that he be required to have 24-hour house arrest on a monitor, right? He be required to only come to court and only meet with his attorney for the duration or the rest of the proceedings of this trial, if it gets that far. Obviously, to have no contact with any other co-defendants in the case, and for any other reasonable conditions that this court believe would be meet and proper based upon our request. We believe in 2022 that the Ayala factors were met. The court has indicated, obviously, that the other court made that decision, and then this court wants to hear about the change in circumstances. I think I've efficiently been able to lay those out in our motion, support it with proper case law. And also, I would, just for the record, I would address the case that I cited with respect to the ex parte meeting, and that's Scudder versus the state, 298 Georgia 438, a 2016 case.
What was that site? Is it in your motion?
It was in my motion, Your Honor.
Okay.
And the Scudder court determined that a criminal defendant has the right to be present and to see and hear all critical parts of his trial,
Okay.
so forth and so on.
That's with regard to that substantive issue.
Yes, Your Honor,
Okay.
which we are alleging is a change
Okay.
in circumstances, a change brought about by the court and not by Mr. Huey. And we believe that that month-and-a-half delay where he's had to sit in the jail, we're asking the court to not only be a court of law, but to be a court of equity, which this court is. And we believe that equity and fairness dictate that a reasonable bond be set in this case. Otherwise, any other change in circumstances that are not brought about by Mr. Huey has to suffer the consequence. And that's what he's doing. He's suffering the consequence, Your Honor,
Okay.
respectfully.
Thank you.
Thank you, Judge.
All right. So that the record is clear, the basis for the recusal of Judge Glanville was not that he is biased, was not that the ex parte itself was improper.
Was he was
It
an opposing
that
party.
Judge Glanville engaged in an exposition on the facts in making his rulings on the motions to recuse. I understand the argument that the court who undertook the original bond consideration in the defense's view has become biased, but that in the same way that I said to Mr. Steele with regard to Mr. Williams, if I substantively end up determining that, then it may be appropriate at that time to take up bond again. Right now, it is not. And it is unfortunate that this case has lasted as long as it has. It is unfortunate that there have been delays in the case, but those do not, in this court's mind, amount to the kind of changed circumstances that make it appropriate to reconsider bonds. I am not going to reconsider or grant bond in Mr. Huey's case either. Mr. Kendrick also has a motion to reconsider bond. He asserts changed circumstances that essentially this case has taken way too long, which I
Your Honor,
don't
could I-
necessarily disagree with, but
I would ask you for Mr. Kendrick's bond motion, if you could defer ruling on that until after you rule on the mistrial.
all right, I will do that. I
Thank
think
you.
that would be more appropriate. Thank you. Okay. So the next thing I think that it would be appropriate for us to begin to undertake is some of the specific evidentiary motions. Mr. Stillwell has a motion for, it's entitled for reconsideration regarding certain hearsay statements. But given that we've all acknowledged we're redoing Mr. Copeland's testimony, it's not even really reconsideration. It's consider it anew as we go forward. So I'll hear you on that.
It's weird
Thank
that the
you, Your Honor.
judge relies on indicta versus
before I
not,
get started,
or actually a factual finding, but then leans
Could I
on it
hand
so
over
much.
a case It's actually the Scudder case that Mr.
Okay,
Matthews
sure.
referred to. And the reason I'm giving you this case, when you consider some of the issues that you said you're going to consider tonight, I never really, and I understand, I'm not complaining, but I never addressed my other motion, which may in fact not be a motion, but
For a fair trial?
yes.
Okay.
But in the state's argument against Mr. Kendrick's motion, they're relying on King. I
Right.
would invite the court to look at the facts surrounding this ex parte meeting. It's clearly distinguishable in every
Okay.
way from King when you look at the facts. And I would just remind the court that King was involving a request, giving the court background facts to show that granting immunity to a witness was in the interest of the public.
Okay.
That had already been done in this case the Friday before. So it's completely different when they had the ex parte meeting on Monday, and I believe Scudder is
Thank you.
more appropriate
All right.
to consider, and it's much more analogous and on point to what happened in this case. And of course, Scudder points out the problems with such a meeting and held that it was improper. Regarding this issue of Mr. Copeland, I appreciate the court correcting my label of what this really is. I agree that it's a consideration anew, and we had prior discussions about it. There was not a written order to this point.
And do you want me to take a look at the original consideration? If so, y'all need to point me to where I would
I
find it.
don't know where it is,
Or we
and
can
this is
just
not,
start over.
I don't mean to sound like I'm being a smart aleck here. It was discussed. Some of my motions were brushed over so quickly. I think I assumed that I had lost that motion in front of the prior trial judge, and I'm not sure if there was actually a ruling or not. I'm trying to, if I could go back to my seat for a
Okay.
second, I just.
Sure.
I'm gonna give you something else as well.
Also, thank you to all the new members. We had Mark Harris, David Liebold, Sea Travel, that sounds fun, Michael Dixon, Emmanuel McCrae, Gary Stone, Rod Factor with the $20 super set. He's cooking. I think you were talking about Bruce Harvey. He was. And then Emmanuel McCrae said Kat's followers are more familiar than the judge. I think there's a lot of people out here that, you know, even casual observers that caught recaps every day have word or wind of certain things that were going on. And she tried to act like she looked at more context than she did.
Cases to the court, and I've also provided copies to the state.
Okay.
Factually, what this is about, Your Honor, is based on statements made by Kenneth Copeland, out-of-court statements.
Mm-hmm.
I think the understanding where we are and the understanding of the facts is we know it, or the alleged facts as we know it, is that Mr. Copeland claims that he was in Mechanicsville on January 10th, 2015. This involves the alleged murder of Donovan Thomas, for which Mr. Stillwell and Mr. Kendrick are charged, and is part of this RICO indictment as well. He alleges he wakes up in the middle of the afternoon, is in Mechanicsville, maybe 300 yards from the scene of where Mr. Thomas was shot, at the Green Store, off of McDaniel Street, at the corner, I believe, of McDaniel and Glen Street. And Mr. Copeland tells the police that he is trying to find his friend Demekion Garlington, and trying to figure out where his friends are, because he woke up in the middle of the afternoon. And he allegedly calls Mr. Garlington and travels down to a McDonald's on Cleveland Avenue. In these pretrial statements, he claims that Mr. Garlington was pulling into the McDonald's as he was pulling in, and essentially in pretrial statements, he says Mr. Garlington and a gentleman named Mr. Demise McMullen, who's also known as Nard and is also charged with the murder of Donovan
Oh my God, I was
Thomas,
calling him Demise.
approached the car. Mr. Garlington gets in first, and quickly indicates to Mr. Copeland, before outside of the earshot of Mr. McMullen, they killed Nutt, essentially, and allegedly points to another car that is a white small SUV type car that contains, according to the story, Mr. Stillwell, Mr. Kendrick, I believe, Mr. Williams, Mr. McMullen was at one point in the car, and another gentleman. The point is, it's a quick statement, and it's they, and he points to this car, according to Mr. Copeland, out of court. And this was June 10th, 2015, when Mr. Copeland said that.
Yeah,
There were-
and I have listened to and read the transcript of that interview.
Okay,
So I'm familiar with it.
and just to add context, there were several interviews with Mr. Copeland prior.
Right.
And he never made mention of
This was
these
the
things.
fifth one.
So, and also to add context, Mr. Garlington is called in to an interview. He's subsequently interviewed. He denies making those statements. Also to add context, Mr. Copeland on the stand acknowledged that he made those statements to the police, but denies that they were true. And although he didn't specifically say it, he seemed to be alluding that he no longer has the same relationship with Mr. Garlington now as he had back then, because Mr. Garlington wouldn't lie for him. It wasn't directly said, and I'm sure will come up in cross, but putting the dots together, Mr. Copeland was in legal trouble, wanted Mr. Garlington to lie for him, to verify this lie that he was telling the police. Mr. Garlington wouldn't do it, and it foiled Mr. Copeland's attempts to get out of jail. That's the context behind all this. But the question is the admissibility of this statement, they killed Nutt, and to the extent any follow-up conversation about that incident that Mr. Garlington allegedly said to Mr. Copeland. Mr. Garlington is charged in this indictment. He has a Fifth Amendment right. He's not on trial with us. I have no information that suggests that he's going to be testifying in this case. So he will not be testifying. So the state is attempting essentially to ask Mr. Copeland about statements he made to the police of what Mr. Garlington told him, because there's no indication that Mr. Copeland himself has any firsthand knowledge or is a witness to any of this. Now, I have a separate concern about the way they're not laying the foundation for a prior inconsistent statement to play the videos, because Mr. Copeland is in fact acknowledging that he told the police. He's not denying making that statement. He's just denying the veracity of that statement. That being said, the statements themselves, how are they admissible? Because they're clearly hearsay. Garlington to Copeland, Copeland without firsthand knowledge. So the state has always taken the position, as I understand it, that these are statements by a co-conspirator.
I think the state has
They've
actually
always
prepared
taken
to
a statement
counter-argue
that,
on
they're
this.
Statements by a co-conspirator. In their filings recently, and I don't want to misstate this, they may have made this claim before, so I'm not going to say it was the first time to make this claim, but I noticed in their filings, they argued in the alternative that they're statements against penal interest as well. And they've provided cases, and I have just handed up my cases. Regarding co-conspirator statements, of course, and we're talking about hearsay and the confrontation clause. It seems to me their main reliance is on the Kemp case, where the Kemp case, as they want it to be understood, is that idle chatter or narrative of past events do not further a conspiracy, but narrative of past events are admissible if they serve some present purpose of the conspiracy, including statements made to solicit membership or participate in the conspiracy or to promote cohesiveness among or provide reassurance to other conspirators. And the reason I filed this motion is because in all prior discussions, the trial court completely glazed over the furtherance. I'm focusing on whether these statements furthered the conspiracy. Okay. The state's cases do not apply to this situation. The difference, and I'm referring to the Kemp case, United States v. Flores, which the state relies, United States v. Santiago, and US v. Holt, all in their filings. There's absolutely no indication in the record in these statements that the alleged declarant Garlington was attempting to solicit the membership of Copeland in the conspiracy in any way. And I understand the states in the case law, some of the cases indicate this, that, you know, you have a conspiracy, you got a small conspiracy and a large conspiracy, and statements in furtherance of a conspiracy could be furthering the large conspiracy. Okay, but soliciting membership, there's been no allegations whatsoever by the state. In fact, we've been talking about this ex parte motion ex parte hearing where they're saying that Mr. Copeland clearly had nothing to do with the murder of Donovan Thomas. They've fought to say that Kenneth Copeland had nothing to do with that conspiracy. So there was no solicitation there's no evidence of anyone soliciting his membership in the conspiracy to murder Donovan Thomas. In fact, that had already occurred at the time that these alleged comments by Mr. Garlington were made. And if the argument is, well, they were trying to solicit his membership into a larger conspiracy, the YSL conspiracy as a whole, Mr. Copeland, according to the state, from the very beginning, according to their expert, Investigator Belknap, according to everything they've shown the jurors pictures of Mr. Copeland, videos of Mr. Copeland from 2012, 2011, 2013, well before this date, where he's with these gentlemen, putting up hand signs, claiming YSL, all the rest. If the argument is, well, they were soliciting him into the larger conspiracy, he was already part of the larger conspiracy according to the state.
Okay, let me ask you this. So a part of the cases that the state cited, I mean, it may be that part of it was one way you can find this as a co-conspirator exception is soliciting membership, but another concept was to further the purposes of cohesion amongst, and I think they have gang cases, so a gang. So can you address that?
Well, they have the burden of proof by preponderance of evidence to show that this has been furthered. There's been no evidence. Again, we're seeing pictures from over the years. There appears to be complete cohesion. There's been no evidence that this was done, if it happened at all, which my stance is it didn't happen, but assuming that the statement was made by Mr. Garlington to Mr. Copeland, this brief statement, I think we're really stretching where the exception is essentially swallowing the rule. If we just say, well, a statement about past events with absolutely no indication that someone said, hey, this is what we need to do. We need to be quiet. We need to do this. We need to do that. There's no indication that Mr. Copeland was instructed to do anything. Mr. Copeland just drove where he wanted to go afterwards. Now, I will say, and I'm sure the state's going to point this out, that people on the street apparently thought Mr. Copeland was involved and began allegedly shooting up houses that he was associated with, but that has nothing to do with the purpose of the statement that allegedly Mr. Garlington made to Mr. Copeland. So there's absolutely, I mean, the record is just completely devoid of any evidence that supports that other than the statement themselves and just reading into the statement and just assuming, well, it must have been done for cohesion. But again, if we can just assume with nothing else, then what's the point of the rule to begin with? Mr. Copeland has never testified that anyone allegedly involved in the murder of Donovan Thomas has ever asked him to do anything. You know, the story that comes out through past statements are Mr. Treadwell takes a car somewhere to get rid of a car, to get rid of guns. You know, again, I'm not saying these are true statements, but that's what comes out in the discovery, and that's what comes out in other people's statements. Mr. Copeland has, it's completely devoid of anything that Mr. Copeland was asked to do. As far as also fostering cohesiveness, Mr. Copeland himself said that Mr. Garlington at the time was his best friend. So I'm not sure. In the United States v. Flores case, they talked about cohesiveness and cohesion within the group. And that was a situation where one individual, the declarant, was talking to another individual that didn't know. So you got the declarant, who ends up, and then another individual who ends up being the witness. We'll call him the third party. And then you have the defendant, and the declarant is telling the witness, hey, let me tell you about the defendant. He's a solid guy because this is what he did, and we're all one cohesive group. But the witness and the defendant were not close. They didn't really know each other. So the middleman, who ends up was the declarant, is kind of informing one person about the other and saying, oh, he's solid. We can be cohesive. In this case, Mr. Garlington and Mr. Copeland and Mr. Stillwell all knew each other very well. And that's come out in testimony. That they're, according to Mr. Copeland, they were the three best friends. So I don't understand how that falls under fostering cohesiveness, because there was already extreme cohesion between that group. So I think it's distinguishable in that aspect as well. US v. Holt, I'll just point out also, with all my other arguments, there's no indication in that case. It talks about keeping a co-conspirator abreast of the situation. There's no indication that Mr. Copeland needed to be kept up abreast of the developments at the time. Mr. Copeland was not summoned to do anything by the group. Mr. Copeland called Mr. Garlington wanting to find out where he was. So it wasn't a situation where the group, assuming these statements were made, called Mr. Copeland to bring him in. Oh, can you pick us up? Can you do this? Mr. Copeland reached out to them. And also I'll point out that US v. Holt was argued under or decided under the plain error standard because the trial attorney did not object appropriately. I have the 4 cases I handed up: US v. Blakey. Well, I'm sure the court will read the cases, but State v. Wilkins I thought was particularly informative. It's a Georgia Supreme Court case. Trial court made a pretrial ruling excluding incriminating statements made by the co-defendant had been tried earlier. Trial court held that while statements were made by a co-conspirator, they did not further the conspiracy, and the trial court did not abuse its discretion. And it goes through all these different statements that the declarant co-defendant made that were basically spilling the beans and did not further the conspiracy in any way. State v. Lane, same thing. And that one, it's interesting. The appellate challenges the murder conviction, and the trial court granted Lane a new trial. The allegation was, the appellee, the defendant, hired Stallworth to kill a gentleman named Mr. Perez. A witness named Thompson testified that Stallworth told her about the plans to hit a lick before the killing, and then afterwards said that Lane did not pay him because he killed the wrong guy. The trial court initially at trial let the statement in, but then at the motion for new trial reversed itself, saying that in no way, in no stretch of the imagination was this statement made in furtherance of the conspiracy. A statement merely spilling the beans, disclosing the scheme, or informing the listener of the declarant's activities are not a statement in furtherance of the conspiracy. The state points to no evidence that suggests that by these statements, Stallworth was seeking to solicit the help in conducting the scheme or concealing its existence when he made those statements to his girlfriend. So those are the cases that I rely on. I also provided Stafford v. State, which is a little different because that was made to law enforcement. It supports my proposition generally, but it's a little different because it was made to law enforcement. Would you like me to address the statements against interest while I'm up here?
Is that in this motion?
Well, no, I understood the state's reasoning for the admission of these
Oh, the
statements.
penal interest? Yeah,
Yes.
go ahead. Yes.
So I'm confused on how this is against Mr. Garlington's penal interest to say they killed someone. It's a hearsay statement that inculpates the accused is admissible if the declarant is unavailable. Okay, I can see that. The statement so far tends to subject the declarant to criminal liability that a reasonable person. Gotcha. I'm sorry. That would subject the declarant to criminal liability that a reasonable person in his position would not have made the statement unless he believed it to be true, and the statement is corroborated by circumstances clearly indicating its trustworthiness. My main objection is number 2, although I do believe that the statement is not corroborated either. But prong 2, it was not the type of statement that tends to subject the declarant, in this case, Demekion Garlington, to criminal liability. He said they did it. I don't know how that could be a reasonable person could, how it could be said that a reasonable person would feel that saying they did it would put that person in legal jeopardy. As we know, as the pattern charges tell us, knowledge of a crime, mere presence, but certainly knowledge of a crime is not enough to convict anyone. And again, he did not say that he had any part in it. He did not say he played an active role. Additionally, Your Honor, I would point out the Williamson case that that I provided. And the Williamson case is, I believe it stands for the proposition that when there's, if you find any part of Mr. Garlington's statement to be self-inculpatory, which I don't believe it is, Williamson dealt with a situation where within a statement, there's inculpatory and exculpatory segments of the declarant statement. And Williamson says you have to deal with the pieces of the statement individually, and you just can't say, well, there is some inculpatory parts of this statement, so therefore it's all allowed in. You have to excise out the self-exculpatory areas within the statement and the neutral areas within the statement. It says 804B3 only extends to self-inculpatory statements and not self-exculpatory portions of a larger inculpatory statement, or to aspects that are neutral as to interest. Self-exculpatory statements are exactly the ones which people are most likely to make when they are false, and mere proximity to other self-inculpatory statements does not increase the plausibility of the self-exculpatory statements. And for the record, that's Williamson v. State 512 U.S. 594, 1994. So
one of the problems
if
here,
there
she
are,
has
which I don't
not
believe
looked
there are,
at
any
severed
inculpatory
co-defendants, including
parts of
Garlington. She's
Mr.
not aware of any of that.
Mr. Garlington's statement, the exculpatory or neutral aspects of that statement need to be excised out. And I'll point out that if you listened, and I know Your Honor did listen, but I mean, I've listened to these statements 15 times, 20 times at this point. It's very unclear to me where the source of some of, we're assuming a lot of it's coming from Garlington, but it's really unclear where Mr. Copeland is claiming to have received some of his information and when he received some of his information. So that makes this task difficult. I think that absent a showing that the state can meet their burden under 801 D2E or 804B3, that none of it should be admitted. But certainly, if we were going to admit some of it, we would have to excise out the parts that are not self-inculpatory, including, but not limited to, the part where he's pointing at other individuals and say they committed a crime. So those are my objections. I think if they come in that it violates hearsay as well as the confrontation clause.
And what's your confrontation clause argument? Because we haven't really touched on
Well,
that so
because
much.
Mr. Garlington's the source of the information, and he's not going to be subject to cross-examination. He's not testifying.
All right,
So thank you.
thank you. Who's arguing this for the state?
So this is all about admissibility of what Kenneth Copeland is reporting that Garlington had said, plus whatever Garlington may have said during interviews, but cannot be called to testify to because he's still charged. He's got an open case. He's severed from this case. So that's why that language of him being unavailable,
Judge,
Chart was like, we
will,
know he
of
is.
course,
He's unavailable.
stand on, not stand only on, but stand on the response that we have filed. I would point the court's attention starting off to page 3 of our response and the second full paragraph on that page, Your Honor, where we are giving some facts of the case wherein it's already been shown at trial that a few days before the murder of Mr. Thomas, Mr. Copeland said that he was with Defendant Williams when Defendant Williams rented an Infiniti from a rental facility at the Atlanta airport. That same Infiniti, we allege, was utilized in the murder. Evidence at trial has already proven that Defendant Williams did in fact rent an Infiniti Q50 on January the 7th and returned it on January the 11th. Testimony at trial has already revealed Mr. Thomas's participation in Mr. Thomas's standing as a high-ranking rival Inglewood family blood gang member to the YSL criminal street gang. The week before, as Mr. Thomas was murdered, Mr. Copeland was physically assaulted at Club Crucial by Mr. Thomas's brother, Kelvin Watts. And in the early morning hours after the murder, multiple YSL gang members, including Mr.
Slow
Copeland.
down.
I apologize.
And
Including,
y'all start reading instead of talking. Speed up. All right, go ahead. So in
the early morning hours after the murder of Mr. Thomas, multiple YSL gang members, including Mr. Copeland, Defendant Williams, Mr. McMullen, Demekion Garlington, Diamante Kendricks, and Shannon Stillwell fled to Miami, Florida. And after these members of YSL returned to Atlanta, there were a number of retaliatory shootings between YSL and IF gang members. So just to sort of encapsulate that, all of that, when Demekion Garlington alerted Kenneth Copeland that they just killed Nut, he was alerting Kenneth Copeland to the fact that a rival, a high-ranking rival gang member has just been killed by our guys. And it's important for us to now prepare, protect ourselves, and flee to Miami.
I apologize.
Yeah, interrupt.
A lot of this is not, and I put in writing, I'm objecting to any proffer of Ms. Love. A lot of this is her theory. It is not what the evidence has shown or will show.
okay. So you, Ms. Lever, presenting
Shart was
this
ready too.
as what the evidence has already shown.
Part of it, not
So-
the part that I'm saying now. I specifically say when I mean to say that the evidence has shown.
Okay, so the evidence has shown that Thomas was a high-ranking
Yes.
person in a rival gang.
Yes.
That the week before Mr. Copeland was assaulted by Thomas's brother,
Yes.
that in the early morning hours after the murder, Mr. Copeland was amongst the people who fled, the group of alleged YSL members who fled to Miami. That's established already?
No. So that will be established.
Okay.
I did not assert
Push back.
that testimony at trial has revealed this, but I am
Okay.
asserting that it will be.
It was in her
established.
motion. She's basically
all
reading her
has-
motion.
It matters, it was not in the early morning hours. Mr. Copeland's phone records, if you go by phone records, will be several days later.
Okay. Thank you.
Excuse me, Your Honor, I object to the language of it's already been proven in here. I don't mind if she says that there's been evidence that's been submitted, but
Okay.
already been proven, I think is too much.
Noted. Agreed. That's not for us to decide. That's for the jury to decide.
And
So,
the 13th
Ms.
juror.
Love,
Our position.
That's fine. Our position is fine. But what, so is your evidence going to show that Mr. Copeland went to Miami in the early morning hours after the murder, or is it going to show that several days later? he
Not
went to
several
Miami?
days later. I believe it was actually, I know that, was it the next day? I think it was the next day that
The murder was,
January 10th.
okay, and he went to Miami.
And then he was in Miami.
She's basically reading her motion, but needs to fact check something that's a critical point of her case. This counter argument to Shard is one of the things she actually put a lengthy response to. It was like 9 or 13 pages, I forget. Because it's critical to her theory of what happened. But she can't get the date right. And she probably is shocked that she got pushed back right now. She's not used to that.
January 6th is the alleged beatdown.
Okay.
Mr. Copeland, who wasn't a week earlier. January 10th, it's going to be January 6th. It's at the
Okay. Thank you.
Crucial. It's a compound.
It was the Sunday before, Your Honor.
Okay.
And so the murder is January 10th in the evening. Some YSL members arrived in Miami on the 11th. Mr. Copeland arrived in Miami on the 12th. So the departure from Atlanta by some was hours after
Okay.
the murder. Mr. Copeland gets there on the 12th.
Okay. And do you have evidence that they all congregate together
Yes.
in Miami? Okay. Okay. And does he go, does your evidence show that he is with anybody else on his trip to Miami? I'm just curious.
Just one second.
Probably don't want to say the answer here.
Testified after the recusal motion, that he traveled to Miami with his girlfriend or the mother of his child
Okay.
and his baby.
All right. Thanks.
And also, my understanding, and I believe it was testified to, it may not have been, was just to, when we're using the word fled, is that Mr. Williams had a show in Miami.
Okay.
Thank you.
So, Your Honor,
Mm-hmm.
Mr. Copeland, I believe, has testified already that they were collectively in Miami.
Okay.
Regarding the court-specific question of who he went down there with. We don't
That's
assert
okay.
who he
They were
specifically went down there with.
Together once down there. And when did they come back?
They came back at different times. Our phone records, I'd have to look at.
Couple of days later? I mean, just give me a ballpark.
Some, they came back at different times.
Okay.
Different times.
All right. And was there a show for Mr. Williams down there? Some kind of a music show, I assume?
That's an assertion
Okay.
that we.
It's an
haven't-
assertion that we haven't looked at because we
that's
didn't
not
look at
evidence
things that
we
look
have,
better
but
for the
we will-
defense.
We have put in. It's not evidence that we have.
All right. Well, that might be.
You don't have
some-
evidence that there
And
was a show?
There was, so just to also clarify, this vehicle that was rented, it was rented for a certain number of days. It was
You're
supposed to
changing
be
the subject
returned,
instead of answering.
I believe, 3 days after it was returned. So they returned it early. They returned it on the 11th. Instead of returning it later in the month, as it were. I think, as I said earlier, I believe it was returned about 3 days early. If there was a show, Mr. Williams was aware that he was going to be attending at a particular time on the 11th. The need to keep the car, unless they intended to drive the car to Miami, I would assert should have reflected itself in the way that he secured the rental. If he intended to be at a show,
All right.
then
What date did he rent it?
he rented the Infinity on January 7th, I believe it was. he returned it on the 11th.
All right.
And the already admitted at trial is the rental agreement that shows that it was due to be returned later after the 11th.
So it was probably a week rental,
Actually, Judge,
maybe? Okay, whatever. You said a
I
few
mean, that's a
days
good
early,
question
which-
because you can rent in
Okay.
different time frames.
All right, so back in the Atlanta area, there is a series of retaliatory shootings. Is that in evidence or is it going to be in
that
evidence?
has been already put in evidence and
Okay.
additional information regarding those.
And is there any evidence that Mr. Copeland was involved in any of those shootings?
Yes.
Back and forth, okay. Between YSL and whatever the gang is
This
that
gang.
Mr. Thomas,
IF,
okay,
yes.
all right.
Specifically, if I may, there were instances that were testified about regarding a particular shooting. So right after the murder of Mr. Thomas, there were a number of shootings that Mr. Copeland was very concerned about and spoke about when he spoke to police in the early morning hours of the 11th, when he himself went down there. He essentially said to them, and I believe that the court has the recording of Mr. Copeland's first interview, they're shooting at me. They think I did it. They being Ifke, they think I did it. And so his girlfriend's father's house was shot up. His brother's house was shot up. Mr. Williams's father or stepfather's house was shot up. There were a number of shootings that have already been testified about.
All right. All right.
So just to start with the assertion regarding cohesiveness, that it's not so much a situation where we're asserting that someone is trying to bring Mr. Copeland in to the fold. He's already a part of it. And in alerting him to this happening, this event, he's including Mr. Copeland in on what's going on with the gang. This is our position, so that Mr. Copeland can comport himself appropriately.
All right.
We have noted in our response that when we are talking about a conspiracy, it's not just the conspiracy, it's not regarding the conspiracy of the murder of Donovan Thomas only. The conspiracy is the wider, broader participation in YSL, and the criminal conspiracy is alleged in count 1.
And Ms. Love, is it correct that Mr. Copeland also said to police that after the first revelation that they shot Nutt by Mr. Garlington, that, and that was in the McDonald's parking lot, that either they did or they were then instructed to follow
They did follow them too.
the car that had apparently been involved or allegedly been involved, follow that car to
Candor.
another place where they all spent the night,
Hold on just one second.
and that he did so?
Okay, we're trying to make certain that the court is hearing that it's Mr. Treadwell's vehicle, not the Infiniti,
Okay,
that they are following to the same place.
okay. But the vehicle that Garlington apparently indicates when he says they shot Nutt
Pointed to the white,
means the people in that car.
yeah, the Nitro, yes,
Nitro, okay.
yes, the
sorry.
Dodge Nitro.
Okay. And they then,
Followed the Dodge Nitro.
Mr. Copeland follows the Nitro.
Yes.
And is he directed to, according to him?
I don't know that he says that he's.
Okay, well, anyway, he follows the Nitro and they all spend the night together at an apartment that Mr. Williams
It's
has in
important if he's
Midtown?
directed,
I don't
because
know if
that's
they
the case
spend the night.
law.
They end
Was
up
he
at
summoned
Midtown.
I don't
to
know whether
act?
they did either. I'm asking what Mr. Copeland said happened.
That they all go to the
Okay,
home of
Okay.
Mr. Williams.
okay.
I can assert what I expect other evidence will show that is not yet been shown, but other persons that we expect will testify during the course of this trial will also say that they met at Defendant Williams' condo. And as reflected in some of the factual acknowledgements of some of the persons who have already entered negotiated pleas in this case, they were given money to lay low. Members of YSL were given money to lay low following the shooting of Mr. Thomas.
Okay. All right, and so your theory is that,
In alerting
go ahead.
Mr. Copeland to what just took place, it furthers cohesiveness. It lets him know about a significant event that just took place that involves members of the gang itself that he needs to be aware of. He needs to be alerted to so that he can act accordingly.
All right.
And they do act
What's the instruction?
accordingly.
What's the direction?
Okay.
They acted accordingly to do what?
All right,
Not
what
direct to
about your
follow the
statement
nitro?
against penal interest argument. I mean, I think that Mr. Sharp raises kind of a good point that how can it be against Mr. Garlington's penal interest to say somebody else did the shooting?
It wasn't just the shooting. He also, Mr. Copeland, that he has also talked about Mr. Garlington's words to him regarding his presence and his knowledge of who it was that participated in the Lil Wayne bus shooting as well.
Okay,
And
so this is an entirely different shooting.
there were two, yes. two
Right,
different ones.
so let's focus right now on what he said, the hearsay about the Thomas shooting.
Okay.
How is that against Mr. Garlington's penal interest?
It's, Mr. Garlington, as we said, is providing information about we argue, a gang-motivated crime committed by members of the same gang that he is a member of. So in saying what he did, he is talking about actions committed by, I would argue, co-conspirators. He's a member of the same criminal conspiracy as those that he's called murderers and shooters in the Lil Wayne incident. He is, given the context of his relationship, his being Garlington's relationship with Stillwell and the other YSL associates that he names as having killed Mr. Thomas, he had no reason to lie about the murder or the shooting. He would not be privy to the information that they just killed Nut had he not been a part of that same gang that these persons that he alleged have just killed Nut are also parts of.
All right, so is your theory then that when he says this, it reveals that he's a part of this same gang and therefore he can be charged under a gang count?
No, he has he's, because of his involvement, so it's not just that, it's not so much that he can be charged under
Well,
a
a
gang
statement
count.
against penal interest would require that what you say could get you arrested and
chargeable.
convicted of a crime, right?
Correct.
So how is what he said going to do that?
It is evidence of his
Rico.
membership in a criminal conspiracy that is YSL. The act that they have committed is evidence that this enterprise commits criminal acts. It subjects him to punishment under count 1 in our indictment.
So
Rico,
as
Rico.
a RICO charge, not even a gang charge, a
Well,
RICO charge.
a RICO charge and a gang charge, to be clear, because in our case, the RICO charge is involving the criminal enterprise that is YSL, the criminal street gang. Mr. Garlington is a member of YSL, the criminal street gang. Part of what is necessary to prove a criminal street gang even exists is the fact that members commit crimes to further the interests of the gang. He is acknowledging that a group that he is a member of commits these type of crimes that he is talking about. That acknowledgement can subject him to punishment for acts that he commits as part of or in furtherance of the
Yes,
criminal
for acts
street
that
gang.
he commits. He hasn't, by this particular statement, admitted to committing any acts, right? He's saying somebody else did. All right,
That's as it relates to the shooting, he didn't do that.
okay,
Yes.
all right. Okay, anything else on this issue?
Just 1 second, Your Honor. And Your Honor, the fact that Mr. Garlington is alleged to have been, according to the statement, with them when they drove by and saw Mr. Thomas before the murder.
Okay.
Also reflects his involvement in the gang itself.
Okay. All right. Sure.
And Judge, if I
Hang
may,
on,
before
she might
Mr.
not be done. Go ahead.
Apologize.
That's okay.
I would cite the court to United States versus Padilla, P-A-D.
Is this a new case that's not in your response?
It's
Okay.
not.
Okay, all right. USV Padilla.
Yes.
What's the site?
Candace!
It is.
Jolly Rancher is the
2000
proper descriptor.
US
Thank you.
APP
And while wearing
Lexus.
red,
1843 at
Atkins with the save. Hey, Love is part of YSL now.
at Penn site 5.
At what?
5, page 5.
Okay. All right, 2000 USAPP Lexus 1843 at 5.
Yes.
Okay. All right.
Wherein the court says that we reject the arguments of Padilla and Rodriguez that the district court erred in admitting plea allocutions of 5 co-defendants. The district court found that all of the co-defendant statements being admitted into evidence were self-inculpatory, involving inter alia admissions of membership in the named RICO conspiracy, and the court declined to reverse the district court's finding as an abuse of discretion. So in his statements, we would argue inculpate him in the RICO conspiracy that we have alleged in this case.
Okay. Thank you. Mr. Sharp.
John, I think it's clear that this is not a statement against penal interest. You know, it's what a reasonable person would believe. And, you know, to come up with these theories about RICO conspiracies when you haven't done anything wrong, I just don't see that as falling under that exception to the hearsay rule. Regarding the statements, whether they're in furtherance, you asked, was he directed? The answer is no. He called Mr. Garlington. Mr. Garlington said, hey, and this is before making any statements about the alleged murder. Apparently, he said, you know, can you come pick me up? Sure. He went down there. A statement, we say it was never made. Mr. Copeland now says it was never made. But regardless, the statement, if it was made once Mr. Copeland gets down there. He's never directed to do anything. He just goes and follows people that he knows. The state is arguing that narrative events given so someone can comport themselves appropriately makes a statement in furtherance of conspiracy. And if we just logically think about that, that would mean that any time there's a declarant and someone else and a witness who are allegedly involved in the same conspiracy or in the same gang or anything else, anytime a statement of narrative events is made from declarant to witness and they're linked together in any sort of alleged gang or conspiracy, by definition, it would fall under this exception. And that's just not the case. The state is saying so he could comport himself appropriately. They have no evidence of that at all. That's just their theory. And it's just a blanket statement to say that it fits under these cases, but it's not backed up by anything. And, you know, if we were to just allow those spilling the beans statements in under that just imagined alleged basis, then the rule really doesn't even need to exist, and the exception would swallow the rule. So it doesn't fall under either of the exceptions asserted by the state.
All right, thank you.
Your Honor, may I add one thing briefly?
Yes.
I just point out that the cases that were cited by defense in support for their position, those were not gang cases. Ours specifically, the cases that we cite are gang cases. We cite a plethora of gang cases. And in doing so, we express how here there is a distinction between the case that we have and the cases that they are citing, and that we are specifically talking about the criminal conspiracy of the YSL street gang. The argument that any statement made for a narrative purpose would be admissible is inapplicable here, where the statement that was made was not just any statement for a narrative purpose. It was a statement about a criminal act committed by a co-gang member, a co-YSL member or members of the enterprise that this young man, Damikian Garlington, is alleged by the state and we believe can be proven to also be a member of. Additionally, we will be at trial later on presenting evidence from other sources of what took place at that condo, which further show what we are arguing here.
All right. Let's break for lunch. We're probably a little bit on the late side for breaking for lunch, but it is 12:35. Let's come back at 1:45.
Well, you guys.
Mr. Steele, I'm going to give you your copy of that transcript back. Thank you for loaning it to me. Thanks.
All right. Well then, I have so many notebook pages. I am blown away by, look, I've said in this stream, oh, she's not that familiar with the context. She kind of stepped back a little bit when she was alerted about June 10th and Woody gets on the stand and then the inquiry happens. And she said she familiarized herself with the context of that, and maybe she didn't. But then we're hearing about everything that went on with the killing of Donovan Thomas. And she certainly, as the chat seems to be pointing out, seems to know a bit more or at least have the right questions to ask about the specific details that the state is asserting are relevant, but the state can't provide the details for. So what is the time? Whose head is in the camera? Whose head is that? So the state is struggling to figure out the time frames of when all this happened. They don't want to answer the question on if Woody traveled with anybody else, which is weird because if he traveled with someone he cares about, why not argue he was trying to protect them too? So why would you, either you're just not aware of the facts of your own case, or like it just, or I don't know. I just couldn't make sense of that. I really couldn't. The car rental thing, it's important to know and we had 2 days of testimony about these car rentals. You might rent a car and return it early. You might rent a car for a week knowing it could be cheaper to rent that way. You might rent a car for longer than you think you need and return it because you don't need it anymore. Especially if they're renting from an airport where they're hopping to fly in and out of. You know, I doubt that if Woody was going a day later, he could have taken a flight down there. I don't know these things for sure. But at the end of the day, the judge has these questions about the specifics, because all of this would go to, is it a theory of the prosecutor? Or is it something that she actually does have evidence she plans to bring in to prove, to show that there's demonstrative evidence for, not demonstrative literally what demonstrative evidence means, but something besides just her theory in her head that says this pattern, the reason these statements should come in, even though there's layers of hearsay, it should come in because it was told to Kenneth Copeland, and Kenneth Copeland thought he had to act a certain way. He was summoned and directed to act a certain way. And he did so in furtherance of the YSL gang, to promote cohesion of the gang. So if you can't lay out these details that are supposed to support that, because there's supposed to be other corroborating evidence to back these hearsay statements for them to be argued that they should come in. So they're arguing these car rentals because they're saying that the dates would line up and that one car followed the other, and there's testimony about that. But she can't come out and say that Copeland was directed to follow the other car back to the apartment. Oh, and there's also evidence they all go to Miami, and they did that because they were afraid. She doesn't want to tell the judge that there was a show. Max Shard has to get up and say it. And to me, it honestly seemed like Judge Whitaker already had some awareness of that in mind. She was waiting to see if Love would say it, and I'm sure she knew the defense would say it. And Max Shard gets up and says it. Oh, well, did he travel there with any family members? Did anyone else go? Shard has to get up and provide that information as well. Why can't Love provide it? Like, is there evidence that they congregate? Well, if they congregate because there's a show, and what they do to work together is to make money out of the artistry and the music business, is the congregation necessarily proof of cohesion of gang activity, furtherance of gang activity? It's just, it was exhausting to listen to. Honestly, that last argument took the wind out of my sails. And I know Max Shart, he speaks pretty soft, he speaks pretty slowly. It was interesting that the court reporter asked him to slow down. You guys are like, I'm falling asleep. But Shart was really trying to tackle two issues of admissibility of the evidence. I mean, we heard a lot about the furtherance of the conspiracy. So there's an exception to hearsay where if things are said in furtherance of a conspiracy, if the state can meet their burden, they bear the burden here to prove that it should be admissible. They need to make the argument. Well, if something was said to another maybe member of the gang and it's done to create cohesion, then it could actually come in even if that original party isn't available to come testify. Then the penal interest issue, you guys heard me note, I tried to blurt on microphone during a moment of silence. You know, Judge Whitaker earlier, very early in the beginning of the stream, had mentioned, look, I didn't look at the other stuff with the other defendants. I'm only looking at what was enjoined here, these 6 that were enjoined here. So Garlington has his open case, and the state is trying to use his gang affiliation to assert truth behind their theory that what Garlington may have said to Woody should be admissible as something, in furtherance of the gang activity. But his case is separate. So there's a small problem there where his case is coming second. His case hasn't started. We can't call him to testify because it would force him to incriminate himself possibly, because he's also going to be on trial. But we also can't have a conclusion for sure that a jury has found that he is in fact a member of YSL. So we only can rely on what would be admissible from, statements, interviews, whatever the judge decides to allow through hearsay. And I thought Shard was making a good effort to lay out a bunch of the different details, a bunch of the different bullet points to get all of that on the record, maybe for the sake of an appeal, but to make sure that these are all things that Whitaker has to consider. Whitaker might not be familiar with the circumstances of the enjoined, why these 6 are together, why the others are not. And now she's putting those details together. And I do think she's listening to these details more than she listened to details about the ex parte and everything right before and after that. Yeah, and you guys are saying you did fall asleep. You did fall asleep. And that's okay. And I do want to stop before I forget, because I'm not very good at paying attention to my phone. But I did get a $25 Cash App, which I thought was super sweet. Let me read it, because it had a message too. It was from Cavell. It was from Chevelle Leathers, who said, "The judge is tainted by the Fani gang." And this is at 10:23 a.m. So thank you so much, Chevelle. That was super sweet. And I've seen a lot of comments flying, a lot of commentary about Fulton County in general. And, that's another thing, and we're still stuck on this argument about the admissibility of hearsay statements that are trying to come in as told by Garlington or Demise to Kenneth Copeland, for them to come in through Kenneth Copeland. So, obviously there's multiple layers at play there. Can we trust Kenneth Copeland? Can we trust the initial witnesses? Should it come in if those witnesses can't come testify themselves? I don't want to beat the dead horse with that description there. But we have this reliance on this RICO statute for all of this. It's woven in every time an explanation needs to be given in this last hour that we watched. Love is like, gang is gang, RICO is RICO, sometimes it's gang, sometimes it's not gang, sometimes it's RICO, sometimes it's not RICO. And she never really fully explains when or why, except that it's this right now because that's the argument I need you to accept. And the idea, we heard Max Shart say, the exception will swallow the rule. So there are many exceptions to hearsay. The rule is, there shouldn't just be a blanket admissibility of he said, she said. There are exceptions where sometimes he said, she said can come in. And what Love is trying to do is say, well, Judge, you need to consider that if you don't think this was said in furtherance or to build cohesion for this RICO conspiracy involving, or for this conspiracy to murder Donovan Thomas, then it needs to be considered in the even broader context of YSL gang activity, in furtherance of YSL. So they're bringing RICO in to say, basically, there should be no hearsay exception for anyone that we think, whether indicted or not, could be affiliated or doing something on behalf of YSL. Just give a conceptualization. Take a moment to conceptualize how broad that range of application would be, if that's allowed. And that range of application has been applied through all the prep work to put this case together. The investigations, the reports, the latitude that the prosecution's taking with who they're choosing to prosecute, who they're choosing to give deals to. And their argument to the judge is, use the broadest latitude you can. If we tell you that we think someone is either a YSL member or they're working at the direction based on our theory of what direction means, whether that means following someone because they're told to drive behind somebody, to do something in furtherance of creating gang cohesion and bonding, or if they're just following because they're all going to that house to go drink. It doesn't matter. Just consider that all doing something as YSL. And anything they may have said, anything that we may have heard about that time period, it should be admissible. Think about how crazy that is. think about what would actually be excluded. If the judge accepts Love's ask, how could something be excluded? If they want to use anything that they think that any of these people have said since 13, they're arguing that we should be able to bring it in, even if we can't bring the initial person who said it in to testify to it themselves. It's the ultimate exception to the hearsay rule. It's a blanket exception. And I really think that I'm interested to see how she weighs on this, because if she is gunning for, she wants to aim higher than the seat she's in right now. If Judge Whitaker wants to sit on the Supreme Court of Georgia one day, you can't just abuse something like a hearsay rule. That's a rule that comes up in literally every case multiple times, every criminal case, even civil cases. But, in the context here, we don't really have the gang exception when it comes to civil case considerations. But think about if she has these aspirations, this is why I think Whitaker's more stuck on this, especially if this trial goes forward. This is critical for the state's case. Honestly, if some of this stuff can't come in, it kind of, I really doubt we'll see a directed verdict in this case at all, but blocking testimony relating to Garlington and what Garlington said to Kenneth Copeland, and now Kenneth Copeland is being introduced through Kenneth Copeland. If we block that, you have a bigger argument as the defense for sufficiency of the evidence. Has enough evidence been presented? Just legal sufficiency that could prove the charges in this crime, in this indictment. And we know Whitaker asked the state earlier today for a list of all the charges and what's underlying each of them to support them. So really think about what Judge Whitaker is looking at. I'm not saying I don't know what she's going to do with these mistrial motions. She's kicking that can until tomorrow. And tomorrow will be the day if she rules on that. If the defense attorneys ask for a certificate of immediate review, will we see her grant that? I think that's important. Whether she decides to grant a mistrial or not, more importantly to me is, will she grant a speedy review where they can take it right to the Supreme Court? I think that's the more important question for me. But really thinking about this issue of admissibility of evidence. This is something that we've seen Glanville shut down or tune out. I think sometimes he did Max Shart did a lot of arguments on this regard, but he would let them talk and then just be like, all right, I'm going to make my ruling, and it is what it is. But let's go over to the chat and see what you guys think specifically on this issue of hearsay, of admissibility, and the relation to the RICO statute being used to broaden it. And in the meantime, oh my God, it's Future Miss Martin 2.0. Hi. It's so good to see you. Thank you for the gifts. Everyone drop an FMM in the chat. Now, Future Miss Martin I'm going to call you a hybrid content creator because I see you go on a lot of panels. You're with Excited Utterance a lot. Also a great channel, you guys. If you want to look at the Sarah Boone case, there's a few streams that I think one of them, you may have guessed it on, Future Miss Martin, with the Sarah Boone. Excited Utterance, Salvador Dali talks, and then the big name, potentially criminal, that's Sean Martin. Future Miss Martin floats between the channels, gives great insight. I think I've seen you holding it down, running an entire stream when others were unavailable. So it's an honor to have you in here. And thank you so much for dropping 5 gifts to the chat. You guys say thank you in the chat. Look at all the love. Look at all the love. That's what's up. And let me see. Let's share some channels here. The reason I thought of Excited Utterance, guys, she did a graphic redesign of the poster Sarah Boone made looking for a new attorney. So that was hilarious. Let me get some channels. We're going to drop some channels in here in case you guys need to find some content to watch. Future Miss Martin, I don't have your channel link and it doesn't come up when I search for you. So if you want, I'm in the Discord. I'm in the Potentially Criminal Discord. If you want to message me I can drop it in here. You can find Excited Utterance. We will drop Potentially Criminal. So Excited Utterance, you guys, Australian. Super awesome accent to listen to when she speaks about law. We'll do potentially criminal. And also, you guys, predictions on this comfort break, this convenience break, is that the new term for it? This is potentially criminals chat. And then this third one I'm dropping is Dolly Talks. You'll see them on panels together. Oh my God, it's so hard to find his channel because it's everything Salvador Dali comes up. If you guys were paying attention to either of the Rush trials with Alec Baldwin or Hannah Gutierrez, Dali did all of the records requests. So he's been going through the text messages between the armorer and other staff members like Seth Kinney. He also has Alec Baldwin's text. So you can see him texting with the detective in advance, trying to find out if they're going to charge him with anything. Just really, really stuff to look through, kind of like behind the scenes evidence that didn't come in during Hannah's trial and didn't come in because we didn't get to see a full trial for Alec Baldwin. There we go. Finally found Dolly. Let me share that and then we'll be caught up with channels. There we go. This is Dolly Talks channel. And yeah, Future Miss Martin, I don't know your channel. But seriously, if you have an actual channel, because I've only seen you on other channels, we can drop your channel too. And then Blue Skies, what the heck was Love trying to say in the last argument? Really, her argument, guys, is broaden the scope of what this RICO should cover, right? We've criticized Fulton County for using RICO as a broad-stroking way to bring charges against people, to indict people. Here, what we're seeing argued is at the court level, now that we're at trial, using the same RICO statute as a way to broaden the hearsay rule. There should be this broad exception where anything we want to come in that involves anybody that we think has anything to do with someone that we think is in a gang, a criminal conspiracy, it should come in. That's what her argument boils down to. And then Arminus, thank you so much, says, great job, Kat. The state is scraping for evidence that does not exist. Well, and I think you can probably work with a car rental being present at the same time, being around certain people. You can work with that and try to present it and let the jury decide. But to try to get something admitted by either characterizing it without evidence to substantiate what you're characterizing it as, they all went to Florida to flee. No. You say that we plan to present evidence that suggests these conspirators fled. They were in fear. Maybe we have text messages that suggest as much. Maybe we have a witness that says we returned the car rental because we wanted to switch cars. We didn't want to be seen in the same car. Like, where is that stuff? I'm not saying that stuff exists. I'm saying if that is what the state has, if anything, this would be the time to say, look, Judge, we want all of this stuff to be admissible because there is some corroborating evidence to back up what Copeland told police officers that Garlington had said. So there is some corroborating evidence to these hearsay statements. So based on this possible exception and the fact that it can be partially corroborated, it should come in. It can be more probative than prejudicial. And they're just not doing that. They're like, Love just kept asking for Atkins to give her the dates to refresh her recollection on her own case. That's what we got. Oh, and then do we have Nik Starow in here? Oh my God, if you want to come up, Nick. Honestly, Future Miss Martin too. Duh. So Future Miss Martin and Nik Starow, there is a StreamYard link in the chat. I will ignore you if I don't know who you are and you just pop in, but you can hang out in here, I guess. You just won't be brought on screen. But if you guys want to come up, you can come up. And yeah, I saw the Vices raid earlier. I didn't see Vices come in, though. If Vices is here, he can come up, too. Vices will have a good time trying to pronounce Fanny or Fanny Willis. Oh. Oh no, guys, my phone has been. Oh, he's here. Oh, there we go. Hello.
How hard can I curse?
Go ahead. We're like a million hours in.
What's going? I don't understand how Judge Whitaker could get to the judge not being biased during the trial when he was yeeted because of conduct he did during the trial.
Well, and we didn't get a discussion really, and I maybe I missed a defense attorney bringing it up, but we didn't have anyone underscore that in Krause's possible indicta statement that we relied on to make further decisions.
Yep.
So it was indicta, but it was also we're relying on it. But nobody underscored it probably should have been held in open court. Probably should have been an open hearing and not in chambers.
Yeah, and that's the difference between all the potential case law the state brought forward in there. No, just no. I don't get it. And I was so disappointed. Now, I hope that I think the motion we heard now before lunch is quite crucial on how we can see this trial going forward. Because if she allows that in that pile of garbage by referring to, she lied to the court 3 times.
Yeah.
Ms. Love.
And I'm glad she got some pushback today on it.
Yeah. Because she cannot say, we have proven that, and then say a bunch of stuff that might not be allowed in because this statement isn't allowed in. She can't go that far ahead if there's not a ruling on this specific statement. Now,
Yeah, this is a huge logistics question.
Yeah, I got the notion from Judge Whitaker that she tried to reel Miss Love in. We are talking about this, not that. And Miss Love, as per usual, procrastinated and filibustered until they found this completely new case that nobody has heard of before. And I don't know anything about that case. I assume the defense attorneys will go through it during their lunch. And this is what she's done all the time with surprise things. The defense has always, these are our case law. If the judge asks for more case law, then we can bring it. Ms. Love just nags and nags and nags. Oh, by the way, here's this as well. Hopefully, this doesn't work on Judge Whitaker. But
I think she's paying real close attention to this motion on the admissibility of the hearsay stuff coming in through Copeland about Garlington. I think she's paid more attention to this than some of the other stuff. And it is foundational. This will determine all the other logistic issues that she said we're gonna look at the logistic stuff later, but know that we're going to look at that. I mean, if this is admissible or not admissible, it's going to change the entire course, the schedule of the rest of the case.
Yeah, because if this statement doesn't come in, because that is this statement is more or less the very foundation to why Mr. Copeland is even on the stand. Without this statement, there's no connection between Copeland and anything that happened, because Garlington is that middle man. That statement is the middleman that actually connects the defendants to the homicide. But I still argue, because I have looked at that damn drive-by film, that light-colored car. The grille of that car is not the grille of the Infiniti or the other car that was shown by the state.
Well, and the other thing you gotta think too is if I lived in Atlanta, I would have that same question. Like, I don't really think I see that many Infinities around where I live, but you would see a lot of Infinities driving around Atlanta. So identification of the particular vehicle, if the grille is different, it's different, probably a different year.
Casper goes, the Pontiac grill. Now, I don't remember which one was. The Pontiac grill is either horizontal or vertical. The grill of the drive-by car is the other.
Yeah, it's the opposite.
It's the opposite. And it can't be the Infinity because the grill is just the mark and the rest is dark. So there has to be an actual grill, either vertical or horizontal. And the Pontiac does not. I need to check Pontiac grill.
Yeah, but let me know. We can pull it up.
Well,
And I think
yeah,
also the
what was
show with
the
Miami, the defense will have an opportunity to respond. I know what we heard Max Shard saying. He was kind of like jumping up as like
Yeah.
an objection, but we're
Yeah.
gonna hear a rebuttal to what Love is saying right now.
Pontiac
This
Bonneville.
could take the rest of the afternoon. Well, unless she goes till 6. I think she said she wanted to go till 6, right? Yeah, right? Get Nik on the case.
Why does it show pictures of Pontiac's 1958?
Google's gotten pretty crappy since they did a few updates. Like they just
Yeah.
show whatever now. A bunch of like SEO, like AI generated blogs trying to chase SEO that aren't accurate.
I have to. I'll do Uncle. I will find it somewhere else. Dun dun dun. PP Pontiac Bonneville 2015. Was it a 20? Was it a Pontiac Bonneville?
That's what I think. Yeah. Look at the chat.
No,
The chat knows.
Pontiac was the latest is 2005. Oh, it's a 2000 and 2004. Thank you. I was wondering here. Thank you. I like the chat. I like the chat.
They're so good. Chat is smart.
Dun, dun, dun. Okay.
I heard when you rated, people said you had work to get to. You got hit with work.
No. It's
okay.
just that
I think maybe
I don't have any. I didn't have anything else to say, so I
For the
might as
break.
well throw them to you because you.
Are you doing an afternoon part?
Tomorrow morning?
Yeah,
Because
tomorrow.
yeah. Oh, for crying out
Good to
loud.
know. Because I told you my job, when I tell you I have group chats, different group chats from different people from one of my clients, 2 calendar meetings that I rescheduled yesterday, worked yesterday to be able to cancel. One wants to reschedule to follow up on something. I'm like, guys, I just told you I needed Tuesday. So when they said that they thought someone said they thought you had to work, I was like, that's how it goes. As soon as you're covering something.
Okay, here it is. 2000 Pontiac Bonneville. Can't believe it was
Wait,
that one.
okay.
Yeah, you see, there is one
One little
vertical.
separator.
Yeah,
And you'd see that in bad lighting. That's something apparent that you could
Yeah.
see.
and the drive-by car horizontal. I believe you can even see it's 3 bars, 3 bars in the grill. And for me, and the infinity, let's see if here.
I just can't imagine the logic of someone doing a drive-by in like, I don't know, is that technically a luxury? It's like above economy class rental. Like,
Yeah.
what are you gonna do? Return it if someone shoots back?
This is a 2014 Infinity. It's just a mark in the middle. No bars at all. In my opinion, they should take
The side by
a
side.
still from that drive-by when they see the grill and just compare. It's not the same.
I wonder if they'll. I mean, I really wonder what the final responding thoughts from the defense counsel will be. I mean, obviously, Shard's going to have something more to say, but I really hope some of the other defense attorneys have something to say about the way Love is trying to argue this. The idea that we can just extend this exception to anything that anyone that might be affiliated under our belief as being affiliated with someone in YSL. Anything they say ever, even if they're not coming to testify to it themselves, should be admissible. It's just insane. How do you ever prove your innocence if we can call anyone to say something ever?
Yeah, and it is like, as Mr. Shard said, if we in the scope of RICO accept, hi, lead attorney, come on my show or have me on yours.
Yeah, come on up, lead. Where are you today?
Yeah.
Where are you today, lead?
Oh.
I was like, they're not streaming?
Hello. Yes, Mr. Jingles.
I got two cats on screen.
Hey.
See, but the problem is I don't
Look
have the Mr.
Look how
Jingles
happy
emoji.
he is. This is a happy cat. Aren't you so happy?
I need to like borrow a member emoji just so we have one when you come on the channel.
Now, where were? Yeah, if the scope of RICO allows all this garbage in, then there's no rule. Then there's just the exception, and if the exception circumferences the rule, we have no rule. We have no hearsay rule anymore.
I love that the exception swallows the rule.
Yeah, it is. It is infuriating because I've said this for over a year. Once I started to read the Georgia RICO Act, it is so broad and so vague.
You get a RICO. You get a RICO.
Yeah, exactly. You can argue that Fannie Willis, Nathan Wade did this in furtherance of earning money, which is RICO. But some of the examples which is in the statutes is that the affiliation, to prove the affiliation, it can be both spoken and unspoken. I mean, that's now you're not even in gossip. Now you're not even in theory. Now you're just guessing. But that is what the Georgia lawmakers wanted when they made the Georgia RICO Act, which is different from the federal RICO Act.
What's your take on if Judge Whitaker has higher aspirations for maybe a Georgia Supreme Court seat, on why she might be looking at this issue so intensely?
Yeah. Well, can you ask that again?
So when it comes to this admissibility of these specific hearsay statements that are coming in through Kenneth Copeland, could part of Judge Whitaker's interest be that she has higher aspirations for a possible Supreme Court of Georgia seat in the future?
Well, yeah. She, of course, she knows Supreme Court decisions that she agrees with or disagrees with, because without that, she's not even on the short list. And so, yeah, the reason can be just as Mr. Shard argued.
if the exception swallows the rule, there is no rule.
Mhm.
So it might not be for her to save the rule. It is to save the exception. Because if this goes up to the Georgia Supreme Court, they might find that this has gone too far. We're going to rewind it longer than this ruling. So there are two aspects of that.
Yeah, and I didn't know that she'd already gotten a nomination for it. So thanks,
Oh,
Wolfie Wisdom.
she was on the short list last time. She's continued. She's nominated every time, more or less.
Okay. So she's, I mean, you know, if she wants it, that's something that's probably sitting in the
Yeah.
back of her head.
And that is worrying also, since she concluded that, well, concluded, not yet at least, about Judge Krause making that small passes. I don't find anything wrong with the ex parte. Well, she did. She said it should have,
be an
could
open
have,
court.
and what should have been an open court. So
yeah, we didn't really hear that mentioned today.
Yeah, we
And
did hear
I'm
that
struggling
mentioned
with
at least.
indicta. How is it indicta, but we keep referencing what Judge Krause said? So is it indicta? Do you really think it was indicta? Because you keep leaning on it. And we do have some outstanding motions, you guys. They haven't all been denied. She's looking at some tomorrow. And remember, Doug Weinstein stood up and said, can we defer on a ruling for the request for bond for my client until after you rule tomorrow on these motions for mistrial? Put it after those.
Yeah.
So we
because
do have some stuff that's open. They're not all closed
because
up
she
and denied.
denied those, but Doug made it completely correctly. Refer it forward, because if she finds somewhere a mistrial, then the circumstances have definitely changed.
Yeah.
Yeah, but Judge Whitaker go aspirations of the Georgia Supreme Court with this notion that ex parte meeting, according to Judge Krause, had no issues. For me, it seems like Judge Krause did that decision because she knew she had no choice when recusing, because the rules are so specific, so clear, she had no choice. But in order to save the rest of the trial, she had to make a finding about the ex parte meeting, which is absolutely horrid.
Yeah, and I think Judge Whitaker was a little out of the loop on what took place on June 10th. I don't really think that she understood that Brian Steele didn't run up and make his inquiry before anything happened in the courtroom. So, because Love kept saying, well, they know now, it's fine, what's the problem? Well, the issue is, the counter argument is that you tried not to let us know. You weren't going to tell us. We found out a separate way, and we got in trouble for finding out that separate way. You tried to hold us in contempt, so there was a moment today where Whitaker was like, look, I guess I'm going to go look at the context surrounding this. Because she didn't seem to know that Copeland had gotten back up on the stand in between the meeting and the inquiry.
Let's see here. I see people who claim that it's clearly Let's see if I can find part of it here.
Okay. And 2005, possibly. Are we back in 3? I have the screen sitting up. I just don't have it for you guys because it's just looking at a wall. But I do have it up that we can toggle to. She did say 1:45 Eastern. So, and she started right on time, you guys, this morning. If you were late to join and catch up with what's going on, she started right on time. Right on time. Yeah, you guys are saying the same thing. Not an infinity. Oh, man. If you guys watch the Karen Reed trial, every time that the court was in recess, they just had the fan showing on the ceiling, just spinning. Tayviz TV, good to see you. You're not streaming this today? Or are you doing split? Are you doing morning and afternoon? Yeah, everybody was excited about the punctuality this morning. It's refreshing. I think it's important. I mean, look at how much, even though we might have our, moments where like, yay, she's not going to restrict extrajudicial statements that the defense wants to make. And then we're like, oh, she doesn't want to do this. We're all appreciative that she's getting a lot accomplished. She's done a lot today. Like, think about how long it would take Glanville to get through these same things. Most of it would be deferred indefinitely. And I really don't feel like I'm exaggerating. How many jurors are watching this? They're in the law and crime chat. They're like, oh, we watched it, but not with commentary. Isn't that crazy? Everybody's getting stuck with work things. I'm like ignoring.
Yeah, I can't find the exact clip now of the drive-by.
How many motions? We've gone through the extrajudicial statements. We have, which was denied. We granted the motion, I think it was multiple motions, for like rewinding the clock back to anything that took place after the June 12th motion for recusal is out. The state didn't object. It seems like at this point in time, Woody's testimony, though, isn't completely stricken from the record, right? Did I understand that correctly? They're keeping 7, 10, and 11.
7, 10, 11. And
so we're keeping those 3 days.
On the afternoon of the 12th, there's a risk that the 12th is also.
So, okay. So the timing of that.
Yeah, so it depends on the timing of that.
Which I personally think is helpful to the defense. If you ask me, that's helpful to the defense.
Yeah, but for me, I mean, even the filing of the motion regarding recusal, since it doesn't seem to find anything wrong with the ex parte meeting, we will just hear the same crap all over again, maybe with different rules, because remember, they were in the middle of arguing about these 15-hour interviews and 3 hours of jailhouse calls when they put in the stay. So, but they still heard 3 or 4 days of testimony after the motion to recuse was filed.
I had a hard time listening to those jail calls, and the state, in my opinion, didn't do a good job of stopping to ask questions about certain key moments to bring the attention forward and to highlight stuff. So, I don't think that was helpful to them. I don't think that was helpful to them because it was just like, here's a big blob, figure it out, and barely be able to hear what's happening. And then staying out the way says that Miss Tasha Diamante Kendrick's mom was just on Kayla Bumpus's live. She was telling people to give the judge a chance, and that is just the first day. Which you know.
Yeah, I'd have a bad feeling about this. She might be better in the pacing. She might be better at reeling in the prosecution going forward. But as I said on my stream earlier, her being there does not make this a fair trial. Because this is like previous with Judge Glanville, it was a bucket of crap. Judge Whitaker is a glass of water. If you pour that glass of water in the bucket of crap,
you can't clean
dirty
dirty
water.
water.
Of crap.
You just make more of it. You just make more dirty water.
Yeah, more dirty water. And you, my channel's motto, and I don't understand why I keep getting all these trials. You cannot unfuck a clusterfuck. You can't shovel the shit back into the horse. You cannot put the toothpaste back into the tube. I mean, you
and
just can't.
It's crazy the amount of times I've heard, not the particular verbally crass ones in open court. When I hear other attorneys or sometimes the prosecutors object to something or complain, like, well, they said it and you can't put the toothpaste back in the tube.
Yeah.
Compared to how I feel about this, those arguments are always raised about what seems so minuscule.
Yeah.
And they're not minuscule. They're not minuscule issues. A lot of the time they bring that up. Someone gets chastised in court. Something can't come in all of a sudden. There's some type of relief granted to one party or another because someone said something they shouldn't have said. Well, here we have a whole meeting. We've got a whole bunch of bucket being diluted by this water now. And we're just like, all right, doesn't matter that we can't put the toothpaste back in the tube. We like cleared out all the toothpaste of an aisle of Target, and oh well, it's just on the floor now. It's fine. We're just gonna keep going.
Now, folks, if you want your own coffee mug with "You can't un-F a cluster F," it's in my merch store. I think I have it on a T-shirt as well.
Well,
Don't go to court with a T-shirt that reads "You can't un-F a cluster F."
David, if you've been watching, so MLS God of Law, if you've been watching this morning and you have like, give us some devil's advocate perspective. There's a StreamYard link if you want to come up. If you're not, you're always working too. You're doing
MG Law
something in the
was
shop.
popping in and out of my chat as well, and he was quite furious.
Good.
Yeah.
We'll get a rant. Come bring the rant.
And I mean, I have a bad fear, but at the same time, she keeps trying to wheel Miss Love in. We are talking about this issue now, not that issue or what might happen going forward. What this issue and this issue alone. But she's not putting down the foot. And I would be so happy if she did that, just because this is the first hearing. The more Miss Love gets the chance to rant, she will. And she will continue. Because at the beginning of this case, she didn't rant this much in the first few days of the actual trial. But the more Judge Glanville allowed her, the more she spoke and the more wild it got. And we know what happened. Midway, I mean, a couple of months in, she lied to the court without a second thought.
Yeah, I mean, we got the objection for the mistrial, right? An opening statement. I think it's hilarious today she's wearing green and red. The chat pointed that out. Like, I was like, those colors clash. And then someone was like, well, the green, she's part of YSL now. And the red, she's part of the Bloods.
Yeah.
Like, I guess she's an unindicted co-conspirator for both.
Well, it was so funny when they had this gang expert. If I don't remember, it might have been Belknap. He was talking about how much red it was, and this and that, and this means this and that. And both Hilton and Love was wearing red. And nobody batted an eye to it. But I can almost guarantee that somebody in that jury saw it.
And well, yeah. I think the outfit coordination has been interesting. I think today they all have very strong shoulders on their jackets. like very strong shoulder pads. And someone noted that because Atkins is wearing like a grayish beige, that they look like they're doing the red, white, and blue theme. Speaking of red, white, and blue, I forgot that some people, because you've been the king of covering from gavel to gavel with this, but there are people that don't know your channel, don't know where you're from and what you do. So if you want an elevator pitch.
Hey, folks. I'm Nik. I've been doing labor law for over 30 years. I do exclusively labor law. I'm contracted by a union. And this is my channel, Nik Starow's Trial Watch. And I started almost 2 years ago. This seems like fun because I saw a bunch of trial streams and some were amazing, some were great, and some were not so great. And they had amazing numbers. Why not me? So since then,
a year later.
Yeah. So I gave myself 2 years to get monetized. It took 16 weeks. And I'm on that route. And of course, the Young Thug trial, I started covering that in the end of May of last year. I also covered the Adelson case in Florida, where Donna Adelson will now be on trial in a couple of months. And also the Andrew Tate case in Romania, I cover that, and a bunch of other, when I get it, the Delphi case, of course, the Delphi case.
That's
Why do I
interesting.
cover the Delphi case? Well, it caught my attention when the defense argued that the real killers are Odinists. Now, as you might have seen behind me here, I might have a slight interest. First of all, because I'm Scandinavian. Second, because I can actually trace my lineage back to the 12th century. So, yeah, this is the successful 1,000 years of inbreeding. So, yeah, so I started covering that case. And what I have to say about that case in a few short words: you can't throw sticks on a body that lands in that way.
Well, I think it's interesting. It's the camera issue. They don't want cameras in that court, but the judge used to be an advocate for cameras.
That
and it's
is
just kind of
because
like,
Judge
how do you explain it?
Me? I can't. I think Judge Gull makes Judge Glanville look like he is almost the Jesus of judges. Judge Judge
Something. Judge G.
Gull, Gull,
Gull.
is absolutely. She's already been slapped on the wrist by the Indiana Supreme Court for disqualifying the defense attorneys. Then she appointed 2 new defense attorneys. They went through the case, visited the Mr. Allen, came back. We agree with the previous defense attorneys. Her hand-picked attorneys agreed with the previous one, and then the Indiana Supreme Court said, "No, Judge Gull, you cannot disqualify defense attorneys just because you don't like them."
Good. I mean, it would be a huge issue. I mean, judges shouldn't want to disqualify attorneys lightly. It's not, an attorney can't just say, I want to withdraw without having a reason. They might have to find, like, if they have a serious reason, they might have to find a way to approach what that reason is so they don't get into attorney-client privilege.
And
but
that was
you don't want to leave someone without representation, because that's an easy way. If you don't do it right, if it's not forced, it's a major appeal issue, one that is considered harmful in most cases.
And that was the only time when she disqualified them, and when she claimed they recused themselves. She gave them the option: either you recuse yourself, or we go out there and we hold this hearing where I will actually disqualify yourselves. That is the only hearing in this entire multi-year case where she allowed cameras. She allowed cameras the only time.
She said, meet us at the flagpole at 3 p.m. after school, and we'll televise that.
Yeah, yeah.
All right, so we do have a question for you. Jay Capo wants to know what you think of Harvey's argument. Probably the oral arguments today, maybe all encompassing of the written too.
Let's see here, because I just read the reply to the response. I believe Harvey, first of all, he's a legend. I really, really like the guy.
He was really polite too.
Yeah, really polite. And he schooled Ms. Love in her response. Sadly, that didn't come through in oral argument as it did in the written one. And it seems like Judge Whitaker took a bit of offense of him claiming that she wasn't to familiarize herself. But she actually said that last week, that she doesn't intend to go back and review.
And she opened by saying she didn't look at anything with anything that would involve the other codes, like the non-enjoined, which is important. I mean, that's everything we're talking about today with Garlington is someone that is one of those other co-defendants. So if you don't look at any of
Yeah.
the stuff that led to where we
Unindicted
are,
co-defendant. But I'm still waiting, and I will. Hopefully, there will be a mistrial with prejudice before that. I want to hear when YSL Mondo takes the stand for the defense. That is the only reason why I want this trial to continue.
and I think Mondo will come off as likable to the jury.
Yeah.
He seemed like, when I saw like some of the interviews with him, he's like faithful, he's sending praise to God, and if he puts on, I'm not saying put on, if he comes off that same way to the jury, and he's supposed to be a co-founder,
Yeah.
and he's not being tried, but he says good things about his circumstance, his opportunities, is the jury going to walk away thinking like, okay, these guys got together and founded a criminal gang?
Yeah. And he can testify to what he told Fani Willis, which I believe puts it on its face that and I've said this before, I think I said it, I don't know if I said it on your stream or when we co-streamed, but I believe the basic information that led to this RICO charge is information Fani Willis got from YSL Mondo when she represented him, which makes it information she got and developed in violation of attorney-client privilege.
Yeah, there's a lot here. So Hi
Daily
thinks
is in the
that
chat. Hey!
he doesn't think that he's taking the stand. Nini says, is Mondo prosecution's witness? And
No.
then Thugger Daily says Mondo's constant shots at Gunna for snitching is going to be damaging if it's brought in, but don't know if it's relevant enough to be admissible.
Yeah,
especially with this judge.
It might be that the defense brings him in only to testify because he can take away the privilege. Only him. What was said between him and Fani Willis. So if the defense, and that would be my tactics from the defense, only bring him in there. Are you also called YSL Mondo? Yes. Do you consider yourself a founding member of the YSL? Yes. Are you in any way indicted in this? No. Was your defense attorney at one point in time for District Attorney Fani Willis? Now that will be objected to Kingdom Come. And that will be interesting.
We're not back yet, but I'm just pulling this up because I see, the clerk is returning to her seat and we've got some motion at the desk. We don't have the judge back yet, but we'll keep this up here so I don't not have it up because I'm bad at that. I'll be like, sorry, we're late, but we're back.
Now, you can put me down in the cellar because I need to go eat something because it's 7:37 p.m. here and I got home at 1 p.m. and I haven't eaten yet. And as you can see, I'm really starving.
All right, I will pull you down. I'll keep you, when you come back, just put a private chat message so I know you're back because I'll keep you muted. There we go. Now, you guys, we have, let's see, we've got like 8 minutes. I do want to shout out, I got a cash app here from Terrence who said, beautiful and smart, I would hire you as my lawyer, which is really, really sweet. I appreciate that. That's very kind words. But you don't want to hire me as your lawyer because I am not a lawyer. So I don't think that would go over well, but that's really, really sweet of you to do, Terrence. I would help prepare. I would love to work, guys, I would love to work for the Innocence Project, like helping them research and raise awareness about certain cases. The Innocence Project can be limited in the cases that they take because they do look for cases where there's DNA evidence that hasn't been tested, that hasn't been looked at, that could potentially exonerate somebody. And if they'll pull the resources together to do that testing that might not ever have been done. And then if they see something that is exculpatory towards someone that's sitting with a life conviction, maybe even death penalty conviction, they will go back, look through all the case files, all the appeals, and take on that huge, huge fight. So You might have heard a lot of buzz recently about a man in St. Louis, Missouri, however you want to say it. Don't make fun of me. But he's facing death. He's facing execution on September 24th. In 2017, he was about to be executed, and with less than 60 minutes to go, I think the governor stepped in and issued a stay because they wanted to present evidence of his innocence. So they stayed the execution. That governor ended up stepping down. The attorney general was like, all right, we're going to keep moving forward. We're not going to look at some report that the government ordered to look back at findings and see if we should do another hearing on this man's conviction. So flash forward from 2017 all the way to 2024. The Innocence Project is still fighting for this DNA evidence to be heard for the very first time by any finder of fact. So a trial judge or a jury. So in this case, they want a judge to hold a hearing to hear this DNA evidence that exonerates Marcellus Williams. He was saved from execution at the final minutes in 2017. And only in August of so next month, I think the 14th, so 2 weeks from now, is someone finally hearing it. Like, just crazy. And the only reason I think it was stayed the first time, his execution, he could have been dead at this point in time. You may have been on Twitter back in 2017. If you remember his name, it was trending everywhere. Everybody was talking about it. It was social media that got the governor to step in and intervene. His name was, Twitter used to trend only things that were trending by volume. It didn't just used to trend things that it thought you liked, things that you were interested in, even if it only had like 1,000 tweets. It used to only trend things that got the quantitative numbers, regardless of what your topical affinity for anything was. So many people were outraged and tweeting his hashtags and his name. The governor came out and stopped his execution. So when I say I want to work for something like the Innocence Project to do research, raise awareness, that's why. That is why. Because the outcry can make a huge difference if there's awareness about stuff. It's just crazy, crazy, crazy to think that a whole organization has tested, found DNA that points to someone that is not Marcellus Williams. And he couldn't even get a hearing for someone to hear that. I think with that DNA evidence, Greg Campikian has had they had like 3 different DNA experts and the reports since 2015. So they've been trying for close to 10 years. We're approaching 10 years for someone just to hear it. And that's just crazy to me. That's my spiel on that, you guys. I also want to drop Thugger Daly's Cash App here in the chat. It's a URL, but it's Ben Jesus, Ben with 2 N's. So if you want to show Thugger Daly some love, because, I mean, that's like, he's basically doing a job within his job or her job, I don't know. But Cash App is right there for you. And then Thugger Daly also, older Twitter trending was way better. Yeah, sometimes the algorithm on X thinks that I'm interested in something, and then my recommended stuff is like stuff I have no interest in. But now my feed just is filled with it. And I'll try to signal I don't want to see it. It's boring. I don't care about, like, I get roped up a lot in like stan culture, like pop music and battles between different artists and how their albums are selling. And I don't care about any of that stuff. But I think because maybe talking about Young Thug and other trials that involve celebrities, they think I am interested. And I'm just like, I don't care how many streams someone has. I really don't. And I didn't used to have that problem. No, I am not a paralegal. And then, so Manifest Love says, I'm not in support of any of these people involved in criminal activities. I don't even listen to music. I'm just furious with how people of authority and in the so-called system, and I think you might continue. So let me see if you had a second comment. But with everything you said there, I'm agreeing with your sentiment. It's one of those things where the principle of should one innocent person be convicted at the risk of setting 10 guilty people free? Or would we rather convict to avoid someone guilty going free? Or would we rather protect someone being free rather than hitting them with a false conviction? And it's a major philosophical question. and really the duty of the state, of the government, because the prosecution is the government. The prosecution here is the, state of Georgia, Fulton County. They're not supposed to win. They're supposed to seek justice. They shouldn't want to score the convictions just because someone might be guilty. They have the highest standard beyond a reasonable doubt that they're supposed to prove their case to. And they shouldn't be able to do anything to make that happen. We shouldn't have this expansive exception to a hearsay rule to get anyone that we want to say anything ever that backs our case in. Bring that hearsay testimony in. Even though there's rules that bar all the admission of any hearsay. Not all of it, but not all hearsay is admissible. But we have here a prosecution that's trying to win by any means necessary, and they're asking to push the limits of the scopes of rules that are meant to prevent that exact thing. And it's just nuts. No, we're not going to find out who Thugger Daly is, you guys. Maybe one day Thugger Daly will be like, all right, trial's over, here I am, we're out. And someone started this stream at the beginning. They said something to the effect of, you think, Young Thug's going to reach out after this and show some support to the YouTube channels. The number one person that should be is Thugger Daly. Thugger Daly all the way. And then Nik is in the chat while he's eating, saying, what infuriates me most about this trial are the amount of victims that won't have their day in court because Fani Willis spends all the DA's office money on a few RICO trials. Yeah. Just sitting there. And I don't know. This weekend, I'll look and see if there's an update with the barred business and the ACLU, the stuff that they were doing to nudge, to ask for this writ of mandamus, to order to make Fani Willis finally notify the judge for anyone that's been sitting for more than 90 days without an indictment. That really came out in April of this year. I will look this weekend to see if there's updates in that case. Because there's a couple hundred people sitting with no indictment still. To the point where the ACLU has an issue with that. Like, that's not really a good look when the ACLU is trying to request these public records and bring a case against the same thing you platformed on. So kind of a big issue there. And I also see two other great creators in the chat, Classy Beats and Flesh of the Gods. Good to see you guys. Flesh of the Gods, hold on. Someone told me that you did another animation. I don't want to describe it wrong what the purpose of it. Julie had sent it over, but then someone in the chat today said that I have an animated character now. So that's on my to watch list tonight when I'm cooking. I have like a playlist of things I put together to watch while I'm in the kitchen. So I'm definitely excited to check that out. Although I don't know exactly what it's going to be. We've got a little more TV angle here going on. We're 1 minute late, you guys, at least according to my clock. But my clock said minute 37 when she said it was 35. So now my clock says 47. Let's see if we get her right on time for this lunch reconvene. It just looks like the deputy walking around. All right, I'm going to rule her late. She is officially a second late. Which is not a big deal to me, you guys. Oh, okay. Time has been changed to 2 p.m. Look at you guys. Infamous Sylvia. Shout out to Infamous Sylvia. I wonder if that's why, like, Law and Crime is, like, creeping the camera a little bit, but they're like, oh, wait, not yet. So they just, like, stopped halfway in their panning over. Oh, I don't really care who Thugger Daly is. So I think Thugger Daly has given, punctual, quick updates on what goes on throughout the day. I don't have an issue with Thugger Daly's information that they provide. I've even seen, I don't want to say like several times to mean a lot. That's not what I mean. But there's been a few times where I've seen Thugger Daly say, oh, look, it's actually this instead. My earlier tweet said that. So correcting things that might not be correct, and I really like that. Okay, so part 3 of the ex parte meeting. Okay, sweet. Well, let me pull that up since we have some extra time. I'm going to drop a link, and you guys will want to watch it over there, because Flesh of the Gods should get the view. I'm not going to snipe it. But the link that I just dropped, it's part 3. Go find part 1 and part 2 if you haven't seen it. But these are like AI animations of the ex parte meeting that Flesh of the Gods has made. It's definitely worth checking out. Interesting way, I think, to convey certain information. This will probably tell my age a little bit, but there is an old Dr. Demento skit about Dungeons and Dragons. And it was just like an audio thing that they did for radio programming. But some YouTuber, maybe it was them, I don't know. They ended up creating an animation to it. And they used the little, like, wizard characters from the original Final Fantasy games. Let me see if I can find an animation of it. And if anybody in the chat knows what I'm talking about, it's a bit of a throwback. So this is how they took these characters, these Final Fantasy characters, and they voiced over a Dr. Demento skit where he did a humorous reenaction of what it's like, a parody of what it's like to play Dungeons and Dragons. This is one of my favorite things of all time. I just love it. But this is what I thought of when I saw you did your animations of the ex parte. So we'll go back over here. We've got a few minutes, guys. If you're just coming back, you didn't miss much. We just have a 2 p.m. return time now. And don't forget, there's probably a lot of research going on during this lunch break. I doubt that many people are actually getting to relax, kick their feet up for this hour and 15-minute break. They're probably looking for case law, getting their arguments together, trying to figure out what else we're going to get back and talk about for the rest of the afternoon. I think we've got like an hour and a half, 2 hours more of this admissibility issue around this evidence, but maybe not. Maybe the judge is tired of hearing it. And then let's see. Oh my god, spoiler alert. That's cute. I can't wait to see the animation. That's gonna be hilarious. Oh my gosh. All I can think of, and this is all love, but all I can think of is Tasha K getting her hands on an animation of TLA, of the lead attorney. Am I playing? No. TV, like video games, I've kind of turned into being the same way I am with TV and movies. I'll like watch the same thing over and over. I don't have time to commit to something new. But I've heard Dark Souls is great. I've heard it's a good time. Yeah, look at you guys showing all the love for the animation. It's so cute that you guys are over here in the chat talking about it. Super awesome. So everyone's got to check that out. I will check it out when, and I'll probably go cook as soon as this court day is done. So as soon as this is done, that's the first thing I'm going to do. Shout out to the UK. Let's talk. Okay, so yesterday, maybe 2 days ago, I said I want to do a panel with different attorneys on pronunciations of different terms that are used in legal arguments, different Latin terms, because not everybody can agree on how certain things are pronounced. Well, one of the motions I was reading, I think it was a response from Love. She said, well, if the evidence is for impeachment and for a substantive matter, and 2 people commented like, it's not substantive, it's substantive. And I'm like, oh my God, I've been saying it wrong the whole time. And I realized it's actually a UK pronunciation to say it as substantive instead of substantive. So the inflection, the stress is on a different syllable in the UK versus the US. And I don't know if I just heard the word substantive from listening to podcasts voiced over by somebody from the UK or where that got ingrained in me. But there really is a true different pronunciation. Americans say substantive. And the UK says substantive. And I'm like, oh my God, they're going to eat me alive. I pronounced it the UK way the whole time. I'm not from the UK. I don't have an excuse. It's just however I heard that word used the most must have been someone with an accent. And I think other words that beat people up, certiorari, certiorari. I hear lawyers pronounce it different ways all the time. But at the end of the day, we'll just say Love's pronunciation is abysmal. I think she gets substantive. She says substantive the right way. Okay, recap so far. So thank you for the super chat, by the way, but this would be helpful for everybody. So immediately, and you guys can put what you think was the most important takeaways from today so far in the chat. But, you know, Whitaker gets right in there. The first thing she wants to address is this request from the state to restrict extrajudicial statements by the defense counsel. She's basically like, nope, yeah, I'm not going to do that. That's denied. We do still have some outstanding. She's not going to disqualify Love and Hilton, but we do still have some outstanding rulings to be made on the mistrial motions. And as far as bond, Douglas Weinstein had stood up and said, look, for my client, Mr. Kendrick, can you defer on your ruling on the bond motion for him until after you rule on these mistrials, because it just makes sense to do it that way. So Whitaker agreed. The biggest thing we're dealing with is this admissibility issue, really a motion filed by Max Shart that we got a lengthy-ish response from the state on about the admissibility of statements that came in. Garlington tells Copeland, Copeland tells police. Can these statements come in? What's the hearsay exception here? Is there a valid hearsay exception? And we left off mostly with the state's arguments. We did have Max Shart object a few times, but I think we're going to see some rebuttal when we get back in. So everybody's filing back in. I also want to say thank you so much. No Weapon Formed Against Me has gifted 5 memberships. So everyone shout No Weapon in the chat. Super awesome. You guys know I love the gifted membership feature on this channel. I don't do that much members only content because, you know, if I'm promoting a case or a cause, like I was talking about the Sean Williams trial, I made one of the uploads members only, and then I was like, for just like 12 hours. And I was like, you know what? I like having the chat available with the premiere. So I stopped doing the members only videos. But I'll do some other fun content that will be members only for a little bit, then make it public. But the big thing is, as a member, you guys can race each other with Mario Kart icons in the chat. So have a way, choose your racer, and say thank you to No Weapon. And then the blind lawyer explains, absolutely, intro of bad evidence can cause a mistrial. Now, blind lawyer, hold on. Let me see if it'll let me pull up your channel. Because we're going to get you up there. Because I hope you start doing some explanatory content. If you're still in here and want to drop a comment, you don't need to do another super chat. But are you trying to grow your channel? Because you offer great insight in the chat here, but I'm not sure you're actually using your channel to produce content. If you are, I will drop a link. Let me know. Don't super chat it. I'll look for your regular chat. Yeah, look at you guys showing all the love. And by the way, this isn't like an anti-Second Amendment thing that I'm asking you guys to do. I mean, I appreciate all perspectives on that. I do not oppose people's right to have weapons. It's just No Weapon's name. Okay, and so Asiatic As says, that visual makes a difference for real. I think you're talking about Flesh of the Gods, ex parte meeting animations. So lots of love for that. I can't wait to check that video out. Let me drop that one more time. This is the ex parte animation video we keep talking about. So bookmark that. Watch it now. I think it's something you could probably check out in the next few minutes, maybe. Okay, you're on Rumble. Just under, so if you guys use Rumble and want to look for the Blind Lawyer Explains, that's going to be my marker. I don't think I've signed into Rumble in like a year. I don't even know if I would know my password. I never use it for content. There was a period where like YouTube was striking a lot of channels and everyone was like, have a Rumble just in case. And then I never ended up using it. But guys, if you use Rumble, the Blind Lawyer is streaming on Rumble. So find them over there because they have great insights over in the chat. Who's ready to argue? Oh, I thought we had someone standing. Yeah, we're gonna bring in random words too. Like, how do you pronounce this Latin term? And then is it tomato? Is it tomato? Is it GIF or GIF? I wouldn't mind having a stream for at least a little bit that showed this Zoom camera. Because it's showing the prosecution table's faces, because their camera looks like they have it. Poor Atkins is the one that they put on camera the most. He's dead center. They're red, white, and blue. Love is creating distance, staying out of that camera frame. I don't even know what these tomatoes. Is that what the long O would sound like? Tomatoes. Well, hold on. Let me find some classy beats. And Classy Beats is out here too, doing YSL trial coverage, like right now, but other stuff as well. So when it sends, that's Classy Beats channel there if you want to subscribe. Oh, and I don't know. I've tried to write timestamps so I can timestamp this long video.
Motion is
We're moving on.
Mr. Williams has filed a motion, and again, I don't know whether this is styled for reconsideration or what, but it's an issue we're going to have to deal with going forward. So while I'm not reconsidering prior rulings, we do have to sort out how we're going to handle this moving forward, and that is concerning 801 and self-serving statements.
So we're
So,
done with
Mr.
with Shard's motion on Garlington, Copeland statements coming in through as hearsay.
There's been a lot of objections. Can't change the past. I've objected to it all. Over objection, I've been prevented from trying the case and putting on evidence based upon this so-called self-serving statement. My understanding, Your Honor, is that changed with the new evidence code. And I cited for the court in my motion that I filed on, Attorney Adams, and I filed on July 10, 2024, some cases, and I might have attached the cases actually to the motion.
Probably a decision tomorrow on what we left off with.
Walker, W-A-L-K-E-R versus State, 306 Georgia, at page 44.
Can you give me just
Of course.
1 second? I'm
Of
sorry.
course.
The poor lady doesn't want to be on camera, or she's just trying not to be heard. Yeah, we just got started. We are looking at Steele's motion on self-serving statements. And I don't know what this interruption is. It just might be a tech issue.
Okay. No apology ever, Your So Walker is WALKER versus State, and it's 306 Georgia 44, specifically footnote 3, 829 Southeast 2D 121 2019 case, where our highest court wrote that and I'm quoting now, the blanket policy against self-serving statements might not have survived the passage of the Georgia New Evidence Code. Then in Jones versus State, it's 303 Georgia, 496, it's in Division 4, 813 Southeast 2D 360 2018. That case is a pre-January 1, 2013 trial. So the self-serving statement objection was valid. That's why I put that case in the motion. And then it's a good case of Hodges, which it's State actually versus Hodges, HODGES, 291-413, footnote 6, 728 Southeast 2D 582 2012. Obviously, that's before January 1, 2013. But what happened was our Supreme Court said that the new evidence code has indoctrinated or codified, I guess, OCGA section 24-8-801C, and that the new evidence code would not retain the self-serving statement rule. And instead, the court looks at relevance 401, 402, and then obviously 403 is for everything. In federal courts, United States versus Jackson, JCKSON, 780F2D, 1305, it's 7th Circuit, 1986. For over 40
1986.
years, self-serving rule was not followed in federal courts. And here, what was happening is anything said by Mr. Williams that I tried to get in on cross-examination would be met with an objection that was sustained as self-serving statements. At times, the recused Judge Glanville would allow it in under the rule of completeness, so 106 and 822, or 24-1-106 and 24-1-822. There were times that he let in, but self-serving statements were excluded, even though they weren't going to innocence, which under the old rule, self-serving statement has to go to innocence. That's why it's self-serving. But anyway, I'm not saying that it's ever going to come up, but it happens so frequently. I just wanted to be courteous because that's the way it was going for several months in the court. So I just wanted to raise that to your attention. That's really what it is. In paragraph 11 of that motion, Your Honor, there was not as much, but under, I think it's 24-8-801. You got, I'm looking, my computer, 2B. I'm not sure that's right, but I think it's 2B. It deals with a statement that's adopted. So Judge Glanville would allow in, well, this was sent on social media and your client didn't respond. Oh no, that's not accurate. Or there was an alleged meeting and your client was there and he didn't deny it. Or somebody else had a lyric in a musical song and your client didn't come back with the next verse and say, oh no, that doesn't apply. And that's not an adoption has to be specifically intended to adopt by your silence. Like, so anyway, those are my issues.
Okay.
They came up a lot. I'm not, Your Honor, I am not saying that there'll be issues going forward, but it like permeated this trial.
Okay, I appreciate you bringing all of that to my attention. And I mean, this isn't really, I guess this is more bringing it to my attention than anything else. We're not talking about anything specifically right now. And obviously, as we're moving forward, we'll take up specifics of things as, I'm going to say as we get to them, although if there's evidence that either side knows they're going to be intending to use that might have issues or objections, let's try to deal with that to the extent we can before we're in front of the jury. I think I said that already. But, I looked at all your case law and I've looked at the statute, and I don't know whether maybe some people were just using self-serving as sort of shorthand for something. I don't know, but I agree that there is not that's really no longer the issue. And if something is going to be excluded, it's not going to be on the basis that it's self-serving. It's going to be on the basis that it's hearsay and there's no recognized codified exception that has been met. That'll be my intention going forward is, to look and see, is it hearsay? And then if it is, and obviously a prior statement of your client is probably going to be hearsay unless and until he testifies. So the question is going to be, does it come in under an exception? Is it a prior consistent or a prior inconsistent statement? And with regard to adoptive admissions as well, I agree. There has to be something to indicate, not just I heard it and I didn't say no. It has to be I heard it and I didn't in some way dispute it when the circumstances would expect me to dispute it. So yeah, generally speaking, that's my understanding. And like I say, we'll take up the specifics as they come at us.
Thank you, Your Honor.
All right,
That was the totality of that.
great, thank you.
Now remember, the judge does have discretion to allow or not allow, but the grievance is Glanville always allowed in one direction and not the other.
I don't want to take something, but there's a transcript of the January 10th, 2024. That's yours?
Yes.
Okay, I just want to make sure.
I don't know. I think I handed yours back to you before.
Okay.
So I handed, or through my staff attorney, handed you back your copy. I don't know what that is. Okay, understood. All right, the state has a motion to exclude victim character evidence. It was filed on July 23rd, and I don't know if that's
So
something
this is
that
evidence
has
about
been
Donovan
ruled on
Thomas.
previously, or what this one is really, has that already been dealt with, or where are we on that?
It has come up, Your Honor, ADA Atkins on behalf of the state.
Oh, okay, Atkins.
Wanted to file that for the court's guidance of any motions where we were going through specifically Mr. Copeland's redactions.
Okay,
And there was a couple times, and Judge Glanville overruled the state's objection. We wanted some, what we classified as speculative homicides that the deceased victim, Mr. Thomas, was involved in, that Mr. Copeland speaks about in his interviews.
okay,
And so those redaction conversations with the court were after June 12th. So the state, foreseeing and forecasting at least that specific issue and or additional questions that may come up, wanted to file this motion precluding improper victim character
okay.
evidence, Your Honor.
And flesh it out a little bit more for me.
Yes, Your Honor.
So.
Why is it
Mr.
more prejudicial than
Copeland
probative?
Wanted to testify to, and or you all had prior statements where he had mentioned and you wanted to get in him saying something about homicides that Mr. Thomas had been involved in perpetrating,
So, Your Honor,
potentially?
yes, Your Honor. And I have some, let me grab these notes right here.
Okay,
Oh, no. I wanted to show these examples that I have. So, Your Honor, I printed some examples where Mr.
Okay.
Copeland, this was what the state wanted to keep out. So,
wanted to keep out.
yes, Your Honor.
Okay.
And the way that the Honorable Chief Judge Glanville addressed these redactions was state.
Prior,
let me
the
know that you're not
Honorable.
playing, and
Right.
then defense counsel would bring up questions they were going to ask Mr.
Okay.
Copeland and or play. So there was portions the state was not going to play and defense counsel said they wanted to get into where
Okay.
Mr. Copeland is mentioning there's a murder on Auburn Avenue. There's an individual by the name of Scooter, and it comes up kind of off the cuff of he heard that Nutt had something to do with this murder. And so the state felt that that falls under what's kind of classically a specific bad act of a victim, which can't come in under really any witness to include a deceased victim in a case, and the case law and the state's motion on that is, explains all of that, I feel like succinctly. And so the state, knowing that we're going to have to go back over these interviews with Mr. Copeland,
Okay.
and some of this may depend on the questions asked and his responses, the state filed this motion. There may be other instances. Those are what came to mind because we recently addressed those. And they're in a recorded statement of Mr. Copeland that the state did not want to play, but defense counsel wanted to ask Mr. Copeland about and or play it if it was impeachment.
Under what basis, if y'all had gotten that far, and maybe it's. more
Yep,
for
I
the
want to
ask
talk
the
about
defense
this.
I was gonna
than
say
Kay
that,
Baker.
But,
I will defer to the defense on their basis for that because I don't want to misspeak
Okay.
for them.
all
It's
right.
okay for Copeland hearsay about what
Somebody
Garlington
from the
told him,
defense wanna
but not
let me
Copeland
know
hearsay about Donovan Thomas
what they
potential
might
crimes that other people may have wanted to
intend
kill him
argue
over.
with regard to this type of evidence?
Frustrating.
Couple things. First of all, regarding Mr. Thomas's character in general, the state, and I defer to the recordings. I don't have it in front of me. I'm not intentionally misspeaking. My recollection is Miss Love indicated on January 10, 2015, Mr. Thomas was just hanging out, on the street with his good friends,
barber
having a
shop.
good time, and just having a friendly time. And then these mean guys did this thing to him, which was misleading. But then the state presented witnesses that said that Mr. Thomas was a gang member. This wasn't us. We didn't bring this up. That he is a gang member, that he was a gang leader. And then they brought in experts that talked about If Gang, Inglewood Family Gang, and Bird Gang. And these are the gangs that Mr. Thomas was associated with. And so all this character evidence has really come from the state's witnesses, and it's been elicited by the state. Now, regarding what Mr. Atkins just spoke of, I think we're putting the cart a little bit before the horse, because these are things that Mr. Copeland said in out-of-court statements. I am not conceding. I hope Your Honor is considering the prior argument today about whether the statements regarding what Mr. Garlington said, or Mr. Garlington's statements, alleged statements to Mr. Copeland, are even admissible.
Exactly.
But then there's another issue. Even if they were admissible, our stance is that Mr. Copeland on the stand, and assuming he testifies consistent again, would not deny making those statements. So I don't even know why we're playing prior statements to begin with. All that being said, my recollection of the arguments were that Mr. Copeland was making references to what he knew about Mr. Thomas as, a gang leader that may have been involved
Love
in
shaking her head.
other violent acts. My recollection of the litigation of that issue was that certain defendants, and it wasn't on behalf of Mr. Stillwell, but certain defendants have argued that Mr. Copeland is responsible for the death of Mr. Thomas. And the argument, as I recall it, was that if that's the defense's theory, that Mr. Copeland's belief and understanding, you got to remember in context, Mr. Copeland, aside from all the gentlemen here, was embroiled in his side controversy with Mr. Thomas's brother, Mr. Watts, Kelvin Watts. And there was a fight a couple days beforehand at Club Crucial where Mr. Copeland's face was blooded and he was robbed, essentially.
Right.
So he had this side disagreement going on with these individuals. And my recollection of the argument was that Mr. Copeland's knowledge and belief that Mr.
Look at Love.
Thomas
Look at Love
had a
writing.
history of violence created the motive to essentially a preemptive strike. That he knew that he was in a beef, in a disagreement with dangerous people, and that goes to his motive.
Okay, he's
Mr.
not,
Copeland.
yeah, who is not alleged to have had by anybody, as far as I can tell from what y'all have said to me today, to have had involvement in Mr. Thomas's murder before the fact.
I don't know. That's not been the state's theory, and that
Okay.
has not been Mr. Stillwell's
Okay.
theory. But that did come up.
Okay, well, it may be that what Mr. Copeland thinks about Mr. Thomas's violent reputation is entirely irrelevant then.
It may be irrelevant.
Okay.
I don't want to speak for other counsel, but that's my recollection
all right.
of the events. But again, I think that, in my personal opinion, the most prudent thing is to figure out which of these statements are
Right.
even going to be.
I'd be like, why does he have
admissible.
immunity?
But in general, Your Honor, the defense is not, we haven't been bringing out evidence about Mr. Thomas. The state played a video where Mr. Thomas's brother was carrying an assault weapon in the barber shop at the time of the shooting. The state's witness said that Mr. Thomas had a gun and was shooting back at whomever shot at him on January 10, 2015. That's all come from the state's witnesses. It's been elicited through direct examination. It hasn't come from us.
Okay.
Your Honor,
Yes.
I wanted to briefly, if the court would permit, I found my notes just to
Okay.
give the court some examples.
Sure.
So these are from my notes, so the time hack should be pretty close. But for example, in the January 28, 2015 interview of Mr. Copeland at Atlanta Police Department headquarters, right around 7:48:13, which is the time that evidence reviewer uses, Detective Dennis asked, "What do you know about Nutt having anyone else out there?" I might have missed a word, either killed. There was some alluding to that. And Copeland, I have, says, "On Cleveland, don't know much about it. What about the boy on Auburn?" And Copeland says, "Who, Scooter?" And Detective Gaither, another APD gang detective, says, "Mr. Copeland, tell us more." You start smiling. And Copeland says, "I heard something, but was not much. It's just like he did get caught up. Somebody had him killed." So it's that kind of, in the state's opinion, speculative examples of specific conduct. And that's why in the state's brief that I know the court has reviewed these briefings, a April 2024 Supreme Court of Georgia case, Ward v. State, 318 GA 884. I used in Ward, it's dealing with kind of the outer limits when someone's claiming self-defense. I like reading Ward, one, because it's the highest court in Georgia and it's recent, but number two, not being able to use specific acts of the victim as character evidence, and even a self-defense allegation, which no defendant in this case has alleged that they shot Mr. Thomas in self-defense, it still establishes it must be through reputation and opinion only. And so the state's it's a two-part motion specifically. Character of the victim is rarely relevant in a murder trial. And two, if it is relevant, it has to be through reputation or opinion on some salient issue. And three, what Mr. Copeland's discussing about, to the state's understanding, is quite speculative even at that. But the state's position is specific bad acts, which murder, I can't think of a more concrete example of a specific bad act of a witness or a deceased victim than murder. So speculating about that, the state feels that's just classic improper under 24-4-404 and 24-4-405 alpha.
Okay, well, I plan to follow 24-4-404 and 405. That's about as much as I can say about that right now until we get into specifics either. All right. But thank you for at least fleshing it out so I understand what we're talking about. All right, the state has a motion to compel defendants' compliance with the reciprocal discovery obligations and to exclude evidence intentionally
This one might
withheld
be
and
good.
not timely disclosed. And
This was the state's motion.
I had via email asked specifically as to the authorship of this particular motion, and to have whomever authored this motion be present in court. The response I got back was Ms. Love saying, "I will be present." Does that mean, Ms. Love, that you are the author of this motion?
Yes, Judge.
Okay. So I have some problems with some of the representations made in this motion. Specifically on page 3, the citation to U.S. versus Young, and then to U.S. versus Waddell. And then the
Okay.
statement, quote, "A defendant has a duty," underlined, "to disclose prior to trial and an ongoing duty to timely disclose," in bold, any evidence he intends to use as both impeachment evidence and as substantive evidence of innocence. See id, meaning see the above two cases, Waddell and Young. I've read both of those cases.
Get her.
Show me in either of those cases
Go.
where there is a proposition that discovery and reciprocal discovery obligations of the defense applies to evidence that's going to be used solely as impeachment.
You're back
I
up,
didn't
Nick.
say solely as impeachment.
Welcome back.
I said as both impeachment and as substantive evidence
Which
of
implies that the use of it as impeachment evidence triggers the reciprocal discovery
Hold on, you have some
obligation.
feedback.
No, unless I wrote it inartfully. What I was
Well,
I
you
don't.
wrote it inartfully.
I did then, because what I was saying was that it has to be both.
Let
That-
me.
That is the representation that
All right.
You have your
And then
microphone
when I
close to
amended it,
the
I didn't see
headphone.
an amendment.
I have a copy.
I adjusted it. It went away. So we're good.
Did you fix that?
This is such a horribly written
Thank you.
motion. I laughed when I went through it. I couldn't believe anybody with a law degree could write.
Well, she came out.
this
She's
bad.
like, she's ready.
So
She
you
said,
concede to
I had to
them
take issue with
that,
this.
If evidence is going to be used solely as impeachment evidence, that there's no triggering of a reciprocal discovery obligation?
Yes, that's
Okay.
not, yes, I was not saying that. I was saying,
Good to
and
know.
my apologies to the court for that inartful wording.
Okay.
And what I said in the amendment, Your Honor, was,
Did you email the amendment to my chambers?
I did
Okay.
yesterday. I believe.
Yesterday, okay.
Yes, it
Well, that
was.
may be why I hadn't seen it, although I've been looking at y'all's stuff nonstop.
Judge is not happy.
Okay, it's in front of me now, so.
So what our position is, Your Honor, as I state on page 3 of the amendment, is outlining what Georgia's statutory requirements are. Of course, the court is aware of what OCGA 1716 4C1 requires. And then I go down to subsection C on that same page where I cite Aggie versus the state 311 Georgia 340 at 343 and go on to say Georgia's discovery law does not explicitly apply 1716 4C to evidence used simply for the purpose of impeachment.
Okay.
And then I say it unquestionably applies to that second intended purpose, use as substantive evidence. And then in section D, Your Honor, I cite to relevant similar federal laws, pointing out that federal law requires the defense to provide the government with materials that are within the defendant's possession, custody, or control. Possession, custody, or control, my apologies. Where the defendant intends to use the item in the defendant's case in chief at trial. And that's Federal Rules of Criminal Procedure 16B1 alpha.
All right, so it can be used in the state's case in chief and maybe be impeachment evidence, maybe be substantive evidence, maybe be both. It's not where in the trial it comes in that matters. It's whether it's used and intended for use as substantive evidence or not.
That is, yes.
Okay, so as long as we're all on the same page with that, And I actually do think that to the extent anybody might want to take a closer look at what those distinctions are, I think it's Waddell,
Yes.
where the court actually says, hey, you know what, these can be tricky, these can be dicey. Here's what it means. Here's the difference between the two. So I would
Sorry, I just learned we can move these.
recommend for everybody's reading pleasure the court's
How's that?
exposition of that issue in the Waddell case.
And in that amendment, I did correct
All
the
right.
Waddell site.
Okay. All right, so we'll follow that law as well.
So, Your Honor,
Yeah, and so I guess I don't know if you've got specifics with regard to things that you believe have not been turned over or
I
that
do.
exist and haven't been turned over.
Well,
Okay.
I cite, for example, in these amendment to the supplement on page 1, the first example was recordings that were held by counsel for defendant Williams of an interview conducted with state's witness Adrian Bean. The evidence that was shown at trial was that Mr. Bean was a co-conspirator with defendant Williams in an intrinsic armed robbery. The state conducted days worth of direct examination of Mr. Bean, only to learn the weekend before the day cross-examination of Mr. Bean was to begin that counsel for defendant Williams had a recording of an interview he had conducted along with his investigator, which had been in counsel's possession since January of 2023.
Okay.
In which Bean claimed that defendant Williams was never involved in the armed robbery, and in which Bean claimed that the police told him to put defendant Williams in the crime. Mr. Williams presented this statement not just as impeachment evidence, but as substantive evidence, and further based upon information provided by Bean to the state upon information and belief. The recording that was given to the state was only a portion of the recorded statement at issue. And we do not have, if there are further statements, if there are further recordings, we don't have them. We've not been offered them. We don't know what they consisted of. Another example is defendant Williams has asserted verbally that he is in possession of a video recorded statement of the witness currently on the stand, in which that witness reportedly asserts, "We killed Nut," referring to Mr. Donovan Thomas. The state is not in possession of any such recording, is unaware of the existence of one, but as I stated earlier, Mr. Williams has asserted verbally that he has such a statement. Mr. Copeland, as I stated, is currently on the stand, and the state has not been given any such recording or been privy to or been able to review any such recording despite a specific and direct request for it. We assume that defendant Williams intends to use the recording, if one even exists, not simply for impeachment purposes, but as substantive evidence. Given these explicit and deliberate decisions to withhold material specifically that we've outlined above, and I will also point the court's attention to a similar example of with intentionally holding back material. There were jail recordings of the witness on the stand now, Mr. Copeland, that apparently defendant Williams has had in his possession for quite some time, long before Mr. Copeland took the stand. And we were only around the time that Mr. Copeland took the stand presented with these recordings. We expressed having a problem with being able to access them, and we were given another set of recordings that contained some other files that maybe were missing in the first one. But the deliberate withholding of these items is what has prompted the state to ask the court for relief here. We are not asking the court to exclude late, disclosed discovery. That's not what we're asking for, but deliberate intentions to withhold information that a defendant intends to use both as substantive and impeachment at the same time. Evidence. We are asking for the relief that we have referenced in our initial motion. And if the court is not inclined, as we've stated on page 5 of our amendment and supplement to the state's motion to compel, we recognize that both Georgia and federal authority instruct that courts employ the least extreme sanction to remedy discovery violations. If the court deems exclusion of a particular piece of evidence too extreme, the state requests that the court issue an order directing defendants to permit the state to inspect and copy any and all material that a defendant possesses, which the defendant intends to admit as substantive evidence, even if the material is also impeaching of a witness, and directing that where the proffering defendant intentionally withholds such material, that it be admitted, if at all, solely as impeachment evidence, and with a limiting instruction prohibiting the jury from considering it as substantive evidence.
All right. So with regard to the 3 things that you outlined specifically, you now have the recordings of witness being, is that true?
We have one recording of witness Adrian Bean that apparently was made on an iPhone, but is, according to the information that the state received from the witness as he got off the stand, that may not reflect all of what was taken down.
What do you mean by taken down?
Well, there were, as the witness left the stand, he indicated that, and actually on the stand, he instructed Mr. Steele to keep it 100, implying that that's not everything. In other words, that what we were hearing was not everything. The recording itself was kind of degraded, and we were not, it did not appear to be one pulled directly off an iPhone the way that an iPhone would, the quality of an iPhone recording would be. And I apologize to the court, but there was one more instance. D'Angelo White was a witness that the state put on the stand, who represented to the state that that counsel for defendant Williams recorded the interview, or appeared to be recording the interview that he conducted with D'Angelo White at the Fulton County Jail. We've never received any recording of an interview between counsel for defendant Williams or anybody else conducted at the Fulton County Jail. I believe I heard earlier reference today to, I don't know if I heard that was the subject of any ex parte hearings or meetings with the court between counsel for multiple defendants and the court. But if there were or are any interviews of D'Angelo White in anyone's possession or that were made, we would believe the state to be entitled to them. He was a witness who was examined and cross-examined on the stand. So there were 4 instances.
All right, well, he already has been examined and cross-examined?
Yes,
Okay, and no such recording was used?
right, they did
Okay,
not.
then why would y'all be entitled to it?
It's just an example of something that we wouldn't, that we weren't aware of.
Okay, but y'all aren't entitled to be aware of every
There we go.
aspect of a defendant's
I don't
case.
disagree.
You are entitled to something that would have been a recording that then gets used as substantive evidence, but it sounds like that did not,
The court is
right?
correct.
Okay, so that one doesn't
scratch it
matter.
off.
Okay. So the Mr. Williams saying he has a video recorded statement of Mr. Copeland saying we killed Nutt, which he might want to use as substantive evidence, as well as any jail recordings of jail calls of Kenneth Copeland, I guess, with anybody, I would assume.
And we have been,
Y'all got all of those too, right?
so we have been provided, these were not jail call recordings from the Fulton County Jail. They were
Okay.
from a different, but we've been provided, according to Defendant Williams, counsel for Defendant Williams, we've been provided all that they have.
Okay.
And so if that is the case, then there is no further issue.
Okay. That one's fine too.
Correct.
So, Mr. Steele and or any other defense attorney, if you have recordings or statements or anything like that, that you intend to use as substantive evidence, whether it is in a case you might present later or the state's case, I think you know this, but need to disclose that to the state. Now, if it just comes up at the very end that, oh my gosh, I didn't know I was going to use this, but now I think I want to, then we might have to sort out whether that's in fact what's going on or not. But I expect everybody to abide by their discovery obligations. If I end up making a determination that somebody is willfully failing to abide by those obligations, then I will consider sanctions. But I would hope at this point, and with what I've already heard, I haven't really heard anything that I find alarming and improper. So unless anybody wants to say anything else, I'm just at this point going to say I expect y'all to abide by your discovery obligations.
And Your Honor, if I may add one more thing, I believe that counsel for Defendant Williams emphatically stated he does intend to use a video recording that he has in his possession of the witness currently on the stand purportedly saying what he asserted, and that we're
Okay, well, I mean, I can see how that might be impeachment evidence, and I'll have to hear whether and how it might be substantive evidence. Mr. Steele.
May I have 1 second, Your Honor?
Sure.
Without interrupting anything, we really need to pay attention now, because I have a small notion
This
would
is
be
like
good.
911 territory for the state.
We want to report an assassination of Miss Love. Figuratively speaking, not literal. Don't sue us. Yeah, I think this might be an attempt by Miss Love to rile up Mr. Steele so he gets high-pitched. I don't think that will happen.
It's just the order of the motion we heard right before lunch
Yeah.
about hearsay. And then we come back to have the state kind of want the exact opposite.
Yeah. And I mean, the prosecution has withheld evidence, not as in they gave them all the discovery, but sometimes they bring up stuff. Oh, now we want to bring in this. Well, you haven't told us you were going to bring this in the middle of the testimony all the damn time. And now they want to exclude the defense and want everything they have. No.
The answer to JL's question, I think you have it, Nik. Why is it so? Why do we get to see Love run on and on and on with a poor argument previously in this trial, but today it's getting pushed back? What's the difference?
Yeah, I mean, the difference is
Mr. Steele.
she can't manipulate Judge Whitaker as she could Judge Glanville. She's very respectful, but one of the things she does is that she rambles while her co-prosecutors desperately tries to find good case law. It's almost as if they don't even research this beforehand.
Yeah, and then they made the argument earlier, our case law is better.
Yeah.
I know he's going to start as soon as I step away. I need more water and some ice. I will be right back. Hold it down.
Okay. I know, folks, I talk a lot. I do that sometimes, but it's good that you tell me in the chat when I do it too much. Thank you.
Your Honor, may I approach?
Yes. Thank you.
Thank you, Your Honor. So I believe that what the state has asked you to do and what you said from the bench about the law that will apply in this case is not accurate under Georgia law.
Okay.
I also, again, I'm not going to continue to repeat. I hope that you would take it the way Judge Glanville did. I have all objections to any proffer made by District Attorney Love. They are not only wrong, but I'm going to show you why they are knowingly wrong. This is the fourth time we're having the same hearing. I know you're not here privy to this.
Okay.
What Prosecutor Love did not tell you is the Georgia law that I've already handed to them. Judge Glanville has ruled on this 3 times.
Okay.
Every time telling the state the same thing, that they're wrong. So I'll go through it for the 4th time that Ms. Love intentionally, I assume, she has a memory of this because she was here. I handed her all these cases. So I assume that she's doing it intentionally. First of all, what she has told you about the case in your reading of Waddell is not accurate. The original case that the state is using is a case from the 4th Circuit called United States versus Young. Young is what Waddell talks about.
Okay.
If this honorable court would look at United States versus Harry, which should be in your package. I may not have put this in perfect order because one of them were not stapled, but you should have the United States. Okay, and Harry is Harry, and it is 2014 U.S. District Lexus, which is LEXIS 160233. And what happens in the Harry decision is the district court judge in New Mexico analyzed a beautiful analysis of the Young case. And that starts, Your Honor, on page 11 of 17 of the copy I've given this honorable court and the parties. And if you can turn to that page, if you don't mind,
I'm there.
on the left-hand side, the first full paragraph. And it reads, in United States versus Young, which is Y-O-U-N-G, the Fourth Circuit did not explain its decision, but held only that the district court did not abuse its discretion. The holding in United States versus Young may be explained by the fact that the Fourth Circuit was applying the previous version of Rule 16, which used the term evidence in chief. Unlike Judge Friedman in United States versus, and I'm just going to spell it if you don't mind, HSIA, the Fourth Circuit did not define evidence in chief as case in chief. And then it goes through defining case in chief. The advisory note, I skipped 3 lines, Your Honor. The advisory committee notes to the 2002 amendments state that the change from evidence in chief to case in chief may be substantive in nature. The term evidence in chief may have, as the Fourth Circuit held, encompassed both the parties' case in chief as well as a party's non-impeachment cross-examinations. Even if the term evidence in chief encompassed all non-impeachment evidence, including cross-examination, this broad term does not mean that the term case in chief does as well. The Fourth Circuit in United States versus Young indicated that a party's case in chief encompasses the time in which a party calls its first witness until it rests by repeatedly using the term case in chief in that manner. So I tell you this because the Waddell case goes back to the Young case. The Young case is a federal analysis of a rule that we don't have in Georgia. In addition to that, there have been 0 circuits following United States versus Young. Georgia has never cited Waddell or Young, but Georgia speaks directly on what our law is. And there's 2 different cases, Your Honor, with the same name of Green, Green. And if you can take a look at the most recent Green case, which you should have in your package.
Yes.
And for the Honorable Court Reporter, this is going to be Green, no E at the end, and it's 368 Georgia Appeal 74. 889 Southeast 2D 190 2023. And what the Honorable Judge Pipkin, which is Pipkin, states, and Your Honor, you could look at, if you don't mind, at this case on page 3 of 5 of the copy I've given the parties. And this Honorable Court, footnote 3 is at the bottom left. And it reads, we also agree with appellant. This case was reversed. So let me just take a step back, if I may. What happens is the state did exactly in the Green case what Ms. Love's asked you to do here. They said that the lawyer for Mr. Green had evidence for a while, didn't turn it over until the day of trial. The judge excluded because the quote, and this is a quote, sat on it too long. Therefore, the state was prejudiced and excluded the evidence. And the Court of Appeals said, you know, there was no evidence of bad faith or prejudice analysis, so we're reversing. But they dropped this footnote. And the footnote they wrote, and I'm quoting, we also agree with the appellant that it is not at all clear that the defense failure to timely disclose, and I'll just tally them, but TALON'(S) note was in fact a discovery violation, given that talent was a state's witness, COCGA section 17-16-7, requiring the production of statements concerning the testimony of witness. That, and it's in italicized, so it's stressed, the party in possession, custody, or control of the statement, and then in italics, intends to call as a witness at trial. I didn't call these witnesses. I don't intend to call these witnesses. The next line goes further, and I'll explain it if you don't mind. It's very easy to explain.
Yeah.
However, we assume, I'm just reading the footnote, for purposes of this opinion, that the note was subject to discovery And we need not resolve the question or address any possible tension between, and then it gives the two code sections that we're dealing with, OCGA 1716-4, little b as in Barry 1, and OCGA section 1716-7. So if we look now, and I should have given this honorable court and the parties a copy of both code sections, OCGA section 17-16-4. If you look at that first, assuming everyone has it, and it starts for the criminally accused obligations under the Discovery Act, and Mr. Williams did, in fact, opt into discovery. And if you look at the copy I've given this honorable court and the parties, it starts on the very bottom of page 2, but it just says B as in Barry, but it really goes over, Your Honor, to page 3. And that's where the 1 is in 1716-4 in the copy I've given. And it says that the defendant, within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties, or as ordered by the court, to inspect and copy books, papers, documents, photographs, tangible objects, audio and video, tapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings or places which are within the possession, control, custody, or control of the defendant. And this is what I stress, Your Honor, it's stressed in the footnote, and which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at trial. Your Honor, under OCGA section 17-16-7, if you look at that, and I've given a copy of that to this honorable court and the parties. And that has, give me 1 second. That has no later than 10 days prior to trial, or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing, other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in possession, custody, or control of the state or prosecution, or in possession, custody, or control of the defendant or defendant's counsel, that relates to the subject matter concerning the testimony of the witness, that the party in possession, custody, or control of that statement, and this is what I stress, intends to call at the trial or such post-indictment pretrial evidentiary hearing. I didn't call these witnesses. So the reason that it is so important is we're just dealing with whose case in chief. Georgia doesn't have the pre-2002 Rule 16 analysis that was done in United States versus Young. This is not even close. Page 5 of 7, and Your Honor, I am now in the other green. So it is GREEN versus state, but it's 307 Georgia 171, 835 Southeast 2D 238. It's a 2019 case. No relation that I know of. It's in Division 4. It's on page 507, like I said. Left-hand side, the last line before the footnotes, 2 lines up, actually. It says, however, that is not what Georgia law requires. As provided by the plain language in 1716-4B2, the statute does not require a report to be prepared and made available or served unless the defendant intends to introduce in evidence the defense, I apologize, in the defense case in chief or rebuttal the results of the scientific test or experiment. If you go to the next case, which should be, or another case, I don't know if they're in order, but it's Carmichael, Your Honor, which is CARMICHAEL versus state. 353 Georgia Appeal 64. That's 836 Southeast 2D 184, 2019 case. And Your Honor, if you can turn to, from the copy of Guinness Honorable Court and the parties, page 7 of 8. And Your Honor, this is on the left-hand side, the first full paragraph, but counting from the bottom. 9 lines up on the right. I am quoting from our court, and this is just one case. There's so many. Just before the state rested its case in chief, the trial court instructed the jury that when a stipulation is entered into the facts, as to facts by the parties, you can accept those facts as being true without further proof. My point is, their case in chief is, it's a term of art.
It has a distinct meaning.
Yes, and if you go back to the Harry case, it's actually a fascinating case to read. It's an enjoyable case to read. They go through case in chief versus evidence in chief, and they talk about specifically all the U.S. Supreme Court cases. It's on page 8 of 17 of the United States versus Harry, Your Honor. It's a well-written, it's really a good job. On the left-hand side, the first full paragraph on page 8 of 17. And the district court in New Mexico wrote, courts have repeatedly used the term case in chief to refer to the part of the trial between the time that a party calls its first witness and when it rests. And then they go through all these United States Supreme Court cases that talk about that. I mean, it's not even an issue. So I, for the 4th time in doing this, the state then has, or the court said that wants to know about Waddle. Waddle is different. Waddle specifically, and I assume that you have the case because I heard you refer to it. If not, I can get it.
I do.
So in United States versus Waddle, which is WADDELL, and it is 2016 U.S. District, which is DIC period, Lexus, LEXIS 68748. It was decided and filed on May 25, 2016 by the district court in Southern District of Georgia in the Savannah Division. Your Honor, if you go on I'm not saying we have the same copy, so this is on I have page
Maybe what page of the slip opinion?
I'm trying, I think it's page 11 is what I'm looking at. It starts out with one
Right.
final point. Okay. So the Waddell case, the judge said, no, you don't have to give it over. But if you're lying, that's, I think, I'm not saying that's.
Right,
what
right.
was in
No,
the
I
opinion.
read it. Yep.
Then you're going to be in a lot of trouble or something
Right.
to that effect. But what happened in the issue in Waddell was they were talking about a statement given to the accused before the indictment. So it wasn't done under the auspices of work product, where the lawyer goes out and interviews witnesses. What Ms. Love tries to do is, I would have a chilling effect. I interviewed every witness that would talk to me. I interviewed everybody. And what Ms. Love is saying is, give me your work product. If I'm not going to use it the way I understand the law, unless you tell me differently, I'm not giving it to the state. So
That's my understanding as well.
So when she says, Mr. White, and I heard what you said, they didn't use it, why would you ever get it? That's exactly right. I hardly cross-examined Mr. White. But the state is telling me to give it. They went so far as Ms. Love called our investigator and tried to get involved and break the attorney camp. She told our investigators, you can call me, give me any recordings that you have of Mr. Bean. Now the investigator's skilled. So he must have said, I wasn't on the phone. But Ms. Love then reported it to Judge Glanville, who said that was appropriate. He shouldn't have given me anything. Said Mr. Steele's investigators obstructing us. This is so wrong of the prosecution. 4 times I've given the same case. 4 times I gave that Green case. 3 times Judge Glanville ruled. In addition to that, there's factual, not only, am I rejecting, I am never taking Ms. Love's proffer. Okay, so she says that I said, I don't talk with Ms. Love, by the way, if you didn't know that. So I never said anything to her.
Oh my God.
But that I
Is there
said,
somebody on the state's case that you are able to talk to?
yeah, Ms.
Okay.
Willis.
All right. Well, okay.
On
Go ahead.
the second page and I'm just looking at the amendment to supplement on page 2, in the center of the page.
Right.
And I should start above, but I'll get to that if you don't mind. For another example, defendant Williams, it's me that she's talking about, has asserted verbally that he has a video recorded statement of Kenneth Copeland in which Copeland reportedly asserts we killed Nutt, referring to Donovan Thomas. Well, let me tell you how that happened. I never said that. Ms. Hilton sends an email and says, upon interviewing Kenneth Copeland, we found out that he put out a social media recording that he killed Nutt, or we killed Nutt. It's in writing. Can you please give it to us? We can't find it. The most I may have said, which I don't have a memory of saying anything, is I'm not giving you anything. If I use something, I'll use it in court. That sounds like something I would say to these prosecutors. To other people, I would say, you're going to have to, I don't have to give it to you, and I'm not going to be able to talk about that. I never said, I verbally asserted that I have anything. But if I do, I'm going to say the same thing that I'd always say. I'm not giving it to them. If you tell me to do it, I'll do whatever. But I'm not going to give them anything because I don't have to. That would be impeachment. Mr. Copeland, before the 12th day of June of 2024, specifically was asked by Ms. Hilton, did you kill Nutt? And he said no. That would be impeachment. The next one that I did not give over Mr. Copeland's jail calls until recently. Let me tell you the truth. October 2023, I gave jail calls of Mr. Copeland to the state. October 2023. The state doesn't raise this until more recently when Mr. Copeland is a witness. They want me to tell them which jail calls am I going to use to impeach the man. I said, I'm not going to do it. Judge Glanville said, you don't have to do it. I'm not going to do it unless you tell me to, but I don't understand how I'm doing this.
Yeah.
And then to stand here and say, I just gave it to him is preposterous. In addition to that, then we go to the first one, Mr. Bean. Mr. Bean testified for days. This case, Your Honor, has taken so long. I don't know how long he was on the witness stand. It would not shock me if he was there for 3-4 days. All he said was, I don't recall. That's what he said. I don't recall.
One in the
Did you
chat
say this?
if
I
Love
don't
would have
recall. I
objected
don't
with
recall.
Glanville.
So the state got in his prior statements to
Yep.
Detective Quinn. Well, I impeached him. He gave me a statement on recording. The state then doesn't ask Mr. Bean in front of the jury, doesn't ask him in front when he's here to be cross-examined. They come up with the Judge Glanville ex parte, give him some sort of document that supposedly shows Mr. Bean is scared, which I doubt. This is just me, doubt, I have no evidence. And then in the middle of that document says that Brian Steele and his investigators, I'm not quoting, were in a car with Mr. Bean and his son. And Brian Steele was telling Mr. Bean what to say. And his son has that on recording. That never happened. That never happened. But what Ms. Love was allowed to say in front of the jury, believe it or not, did Mr. Steele stop and start that recording? Mr. Bean said what he always says, I don't recall. I objected outrageous, outrageous. It just flows right through. The same way Ms. Love stands here today and says it's hard to hear, or whatever her words are, hard to decipher on an Apple iPhone. That did not happen. It is offensive. The legal analysis is wrong. There is no distinction in Georgia on substantive or impeachment. What you were told is wrong. And this lawyer knows it because she sat here in court and I did the
She's
same
nodding.
thing without being tempered.
She's nodding when she said this lawyer knows
Right.
it.
That's 4 times.
Thank you for clarifying that.
She was nodding when he said the lawyer knows it.
Yeah, when Mr. Steele clears the area. Yeah, go ahead, Ms. Love.
Thank you, Judge.
Do you have any Georgia law that represents what you have asserted in your motion and amended motion?
Your Honor, that's just it. I have been clear in my amended motion, and to
Which
the
I
extent that
just
it
got
wasn't,
a copy of.
yes.
Okay.
And also, I just
So
want to say
no,
that,
no Georgia law that.
right, Georgia law does not define, it does not define case in chief. It does
Well,
not break it
we all
down.
know what a case in chief is. I mean, don't we?
Do we?
I think we all know what a case in chief is. Is there any support for your assertion that reciprocal discovery is required based on the concept of substantive evidence?
Your Honor, what I have said and what I maintain is that, one, there is an absence, and I'll point the court to 3 different cases, Harris versus the state, 314, Georgia 238 as one. And these are just instances.
238? What did you say?
Yes.
Okay. What are the other two and what are they going to represent?
307 Georgia 171, which is the 2019 Green case that Mr. Steele cited for the court, and 146 Georgia App 423, which is Phillips versus the state. And
When is that from?
I'm sorry.
What year?
Just 1 second, Your Honor. That's a 78 case.
Okay, so that one's not relevant at all.
1978.
Because we have a new evidence code since 78, so, okay.
And Your Honor, even with respect to the older case, the only thing that I was citing Phillips for was the proposition that in the absence of specific legislative or decisional case law on the particular issue that is at hand in Phillips, we commend the Federal Rules of Criminal Procedure, Rule 16, for guidance. That is,
Well, we've got a specific rule here now, don't we?
well, when you say we have a specific rule, is the court speaking of the discovery statute that says?
That's what we're talking about in
I
this
don't
motion, right?
Right, yes, Your Honor. We are talking about that, and the state's position, the state maintained, first of all, let me be real clear, we didn't file a brief. This is the first brief that we have filed where we've asserted these things. We have asked that the court require Mr. Steele to turn this stuff over, but we've never argued it out. Mr. Steele has stood up and said he's not required to, and he has pointed to the discovery statute. The court has said, okay, yeah, he doesn't. And we
Landon
put
made a
that in
ruling.
our motion to the court, that the court has previously made a ruling that we thought deserved a second look at. Defendant Williams has adopted as his witnesses all the state's witnesses in the witness list that he filed. And so, Your Honor, when we assert based on Waddell, and Waddell also speaks about work product, and it makes this distinction between factual history and work product and what the state or is and is not entitled. The state stands on its assertion regarding what the requirements are because of the fact that I understand the court's position that there is no misunderstanding about what case in chief means in Georgia.
Chief.
But as there was
Why'd she say it so hard?
this, expounding on its meaning in Waddell, I think it's important to recognize that there's not been a similar sort of expounding in Georgia, and we can all presume or take for granted that it just means when the defendant
When
is
you're
putting up his
presenting your
particular case.
witnesses.
Right.
Okay, so do you have any case law
In Georgia,
in Georgia that supports the position you took in your motion that reciprocal discovery requirements are triggered based on
This is
whether
the
you're
fourth
presenting
time the
something
judge
as
asked
substantive
her the same
evidence?
question.
That's my question to you.
Your
All
Honor,
we've
the
gotten
only,
is Judge Glanville made a
what we
previous
have in
ruling.
support of the motion is cited in the amendment and in the motion itself. We have not ever presented or represented to the court that there was a Georgia case that addressed this issue, and the conclusion that is asserted in the state's filings are the result of the fact that, one, from our position, it's not addressed directly that, what case in chief specifically.
So you are telling me that when our discovery statute says that the defendant is to produce or permit inspection and copying of whatever it is that they're in possession or control of, which the defendant intends to introduce as evidence in the defense case in chief or rebuttal at the trial, you think that there's some kind of lack of clarity about what that means? Is that what you're representing to the court?
Your Honor, I'm representing that. That was the position that was taken. That was what was analyzed in the cases that we have cited in our amended amendment and supplement to our motion to compel. That is.
Now is the
in
time
our
to say, withdraw our motion,
a
sit your ass
reasonable
down and shut the
interpretation.
up.
And as we've said in our filing, Your Honor, there was the requirement in Waddell that anything that was within the defendant's possession, custody, or control, where the defendant intended to use the item in the defendant's case in chief, that be turned over. The Waddell court, Your Honor, in analyzing the meaning and understanding of case in chief, as the court correctly pointed out earlier, said that if it is going to be used as both impeachment and substantive evidence, that constitutes case in chief. From there, we made the assertion, the state's position,
That's
that
not what it says.
if the defense intends, because there's nothing in Georgia law that analyzes it at this level, if the defense intends to introduce evidence as both impeachment and substantive evidence, then they have a duty to disclose it. And that is the origin of the state. That is the basis for our position. If you're
And have you heard Mr. Steele argue 2 or 3 times before that that's not at all what Georgia law means?
We've not made this argument before, so
I don't mean in writing. Y'all have not had
we have
any
literally
discussion
not-
whatsoever in front of Judge Glanville about.
As I have said
What
in my
that
motion, Your Honor, what we have argued, the state has said, Your Honor, they have a duty to disclose this. This is
She's
stuff that we are
actively
entitled.
lying to
And
the
Mr. Steele
judge.
has said no, and citing the Georgia statute, he said we do not. I have never asserted, I've never made this distinction. I've never said that case in chief means if it's being presented as impeachment as substantive evidence. I've never made that argument in a written or oral filing.
Okay. All right. Well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms. Love.
Oh, here we go.
Very serious.
Oh,
Okay. So,
oh.
anyway, we'll be abiding by the
judge
discovery
just-
requirements
Wow,
set forth
she
in
just
our
said that.
statutes. And Mr. Steele, thank you for the clarification.
That was the judge. Oh, damn.
All right. I think that brings us to the
That was the
issue
judge in
of
legal terms telling Miss Love,
Sit
When we
down.
first
ever
met,
do this again.
Mr. Short had
Oh, we are going to
suggested
have a
that
talking.
there might be, well, I don't know if it was Mr. Short or Ms. Love, honestly, one or the other of you. We discussed the possibility that there might be outstanding discovery that maybe actually was
gotta talk about the
required to be
reports. The
produced
reports.
that either was
Oh, the
missing or
reports.
just hadn't
Please,
been
Mr.
talked
Steele, the
about.
reports,
And
the
I
missing
wanted us to
reports.
kind of go through in detail what it is that everybody thinks maybe the other
That-
side has that they're entitled to that they haven't gotten yet. So are we in a position to be able to do that now?
I think they did their updated evidence list. There was something filed, but it wasn't actually
If
on
not, we
the
can
the
do
record.
it tomorrow or the next day, and we can move on to, we've got other stuff to do too. Which exhibits have actually been admitted, if that's an easier one for this afternoon?
Wasn't Miss
Which would y'all
Weaver
rather?
supposed to give that list
We
to the
got to
judge?
do them both, so I don't really care which order we take them in.
Speaking for the majority on this side of the room, we'd ask if we could take that up tomorrow.
Okay, so can we do then today, I think Mr. Steele provided sort of as a starting point, a list or a chart or a spreadsheet or something of his understanding of what exhibits have actually been admitted. And for us to take this pause is a good time to make sure we're all on the same page about that. And I know that Ms. Weaver, the court reporter, had at least provided to me, but I don't know whether she copied y'all or not, a couple of places based on that chart where she thought she wanted some clarification, or she thought maybe it had been talked about but not actually admitted, so we can go through all of those. Do y'all have that, or do I need to get y'all that?
Your Honor, we have that. I believe that might be a rough draft. We have been keeping a list as well, and
Okay.
we've been referencing the recorded.
Don't take Miss Love's
to
words for
ensure
what
that
evidence
we
is
are
in or not, Judge.
accurately keeping
Yeah, this
note
is
of
this is
what
relating to that
has
100
been
discrepancies in
admitted. As I
exhibits.
stated earlier, there have been instances where it has been proffered that evidence has been admitted, it has been
I just realized I
Right.
should
that
have
has not been the
streamed
case.
its
So
entirety
we are
to
still-
my
we
audience
ask
as
the
well. Now I have to do
allow
all
us
of this
to
all
get
over
a
again
little bit
tomorrow
further
morning.
along in, checking
But I don't
all of
mind.
these exhibits.
All right.
Feel free to
so-
syndicate it. I don't care.
No, maybe next
So
time. Maybe
the
next
question
time.
was, do y'all have the kind of response from Ms. Weaver about her take on a couple of discrepancies? Okay. Ms.
Hey, John.
Persfield, could you share that with everybody?
John is great.
Thank you, John. And also thank you to Truth
And,
Always Wins from
I
earlier.
was-
I'm so glad
I
you're
was
here for a
hoping
live. This
that
is a
we
good
could
one.
Do this today. The state is not ready to yet. You know, I want to try to take us to the end of the day because we have a lot of work to do. Maybe there's something else that we still need to cover that we could cover today.
Judge, we have, we are going through.
The prosecution was very busy with not being around Miss Love when she had to write all the motions
Okay.
herself.
Actual physical piece of evidence, that.
And that
we
is why
have
all of them were
submitted or defendant has submitted. So that.
She tried to plug her ears when the judge kind
I'm
of
sure
inferred
it's
as much.
time consuming, voluminous.
And we have endeavored to make certain that it's accurate, so.
Well, that'll be helpful. We would want that. All right. So, Ms. Percifield will email out to y'all all the couple of comments that Ms. Weaver, in her looking back, believes might be inaccurate on the chart that Mr. Steele has put together and shared with everybody. So y'all can take a look at that. We can deal with it tomorrow. I know one thing that we're going to need to sort out. Ms. Weaver had mentioned that there are times when, and I think she said it was, I don't know who, but somebody on the defense side, or maybe more than one person on the defense side. I don't know if the state's doing it as well or not, but you will approach a witness with a laptop and show them something on the laptop and ask them about it. And that it is difficult for the court reporter to then sort out what was that exhibit actually. And I don't know if anything has been admitted that way, but I do know that the prior judge, there is an administrative order filed in April in this case that requires all evidence offered by any counsel be submitted to the court in physical form and marked as appropriate at the time of its admission for it to be properly made a part of the record, and directing counsel to provide physical copies to the official court reporter, who now obviously is no longer Ms. Weaver for going forward. It is going to be our new court reporter, Ms. Winfrey. But we need we actually need, electronic copies too, but we need something that is physical, whether it's on a jump drive or a flash drive, or whether it's a piece of paper.
The state's
There's no way
evidence
for the court reporter to
is
capture
gossip.
sort of, I guess, a screenshot, unless
Yeah,
y'all
that's it.
take a screenshot of the screen that you're showing the witness and then give that piece of paper or electronic file to the court reporter. That would be fine, but there has to be something that represents whatever you showed the witness on the screen, okay? Does everybody understand? Anybody have any questions about that? Okay. So we can take up tomorrow, after y'all have had a chance to look at it, the couple of issues that Miss Weaver's got a different record than what Mr. Steele does. And then I would love for y'all to be able to get together on, if there's no discrepancy, then we don't have to worry about it if everybody's on the same page. But if there is a discrepancy, if y'all don't talk to each other, maybe you could just email each other. Here's where we think there might be a question or an issue, so that we all know before we talk about it, what
Mr.
it is
Steele
that we need to
tried,
talk about.
and Miss Love still lied
So
about
can y'all
what
do
was
that
in that
this
email.
evening? Don't ever, thank you. Okay. All right, very good. All right, the state has provided an updated witness list, which is still fairly long. And I would like to know from the state, does that list include, is that just the witnesses that have been called yet that still need to be called, or does that include everybody, the witnesses who have been called and those who are still to be called?
Your Honor, that includes the witnesses that need to be called. Some have already been called, but
Yeah.
those are everyone moving
Yeah,
forward.
there were a few you highlighted and said we may recall these. So that is 105 or so witnesses still to go then?
Yes.
Okay. And is that with y'all narrowing it down and picking only the witnesses y'all need?
Yes.
Okay. Well,
What, but-
we'll see. But,
Remember the Hertz guys?
all right, are there any
We called
other,
2 days of
people.
testimony.
Yeah.
we've got to figure out
2
how we're
people
going
for
to
a full
deal
day of
with
testimony
Mr.
about how to rent
Copeland's
a
sort of
car.
redo. But are there any other motions that I haven't gotten to yet today or mentioned today that are outstanding?
I emailed Your Honor's chambers regarding motions that I filed, and because I did not have access to Odyssey and I could not pull them off the internet, and I did not have the file copies on my computer, I identified what they were, but they were noted. Essentially, I would think they're titled notices of objection. They were regarding. Your Honor may or may not know this. There was a wiretap in this case. There's, and then also my client's phone, actually 2 phones, were extracted and dumped. So there's numerous phone calls, texts, emails, things of that nature that are on either the wiretap that were intercepted, some involving some with my client as a party to those communications, some not, as well as all the things that are typically on a cell phone that deal with someone's essential life on an electronic device. The state has, to my knowledge, not identified what they plan to use from either of those sources of information at this time. And that's why I labeled it a notice, because there is irrelevant information, there is prejudicial information, there's on the wiretap, not so much Mr. Stillwell, but there's other individuals on these wiretaps discussing all sorts of other acts that have nothing to do with this case. And so there's just a lot there, and we're going to need to have that discussion at some time.
Okay, thank you. when does the state intend to let the defense know what it is they're actually using out of the universe of all possible things?
Your Honor, what I think that we have represented to the court previously is that prior to, I believe we had said at least the week before, because there is a large volume, to say the least, of calls within the jail calls and within the wiretap that are that have been turned over in discovery. And I believe that we had previously said that did we say the week before? 2 weeks before we intend to use them, we would apprise defendants of which ones.
Can y'all explain to me how you are dealing with a large volume of what ought to be motions in limine while in the midst of trial?
Because Judge Glanville did it.
Do we all know what a motion in limine is in this courtroom?
And still being in any way efficient with the jury's time? You're not, essentially. Okay. All right. That's just not practical. I mean, we're going to change that going forward. And I'm not going to say I need you to know everything tomorrow, because I know it's a voluminous case, but y'all been putting this case together for 2 years. And you ought to know, I mean, you clearly know what witnesses you're going to be using, and you've given me, you know, kind of a very broad idea of what exhibits you intend to use with those witnesses. But I don't know that if we're just every other week saying, okay, let's figure out all of the evidentiary issues that have to do with the next 2 weeks worth of witnesses. We can do that in one day on a Friday. We just can't. So we're not going to be able, I mean, we all know that we've got this week, and we know that the jury has already been told before I became involved that they essentially have the week of, what is it, August 19th out. So, you know, this week might be taken up pretty much with sorting out the 2 things I just mentioned, and then sorting out all of the evidence that goes along with Mr. Copeland, because he's our next witness up. But the week of August 19th, we need to be plowing through a whole lot of other evidence, not just what's coming up in the next 2 weeks. We need to be covering the next several months, which ought to be, frankly, the end of this trial by then. I mean, it should not take another 7 months. It shouldn't. Whether it does or not, I don't know. But so the state needs to produce in much more detail a much more winnowed down but comprehensive list of what the evidence they intend to use with each witness is going to be, so that the defense can see it, evaluate it, make whatever evidentiary objections they have to it, and the court can have some time to view the evidence, listen to the evidence, whatever the evidence is, and evaluate the evidentiary issues, so that we know by the time the witness gets on the stand, here's what is coming in. I mean, for the most part, it's a trial, but what's coming in and what has already been excluded. So do I need to be more explicit about that? Or do y'all understand your marching orders?
Yes, we understand what the court is asking.
All right.
Sounded like kids that got in trouble.
I feel like I need to be more explicit about it, even though I know y'all understand. By the beginning of next week, I want to see, you know, at least the next 30 witnesses worth of evidence, okay? And then maybe by the end of that week, the next 30. Okay? All right, and we're
They
going to plan to be
barely
here
make
all of the
one
19th, and I
witness
don't know
worth
when
of
else we're
that
taking breaks.
in
But
1 week.
okay, so that's that.
Can I ask a clarifying question, Your Honor?
Yes.
And Mr. Adams and I, Attorney Adams and I filed, I think that motion, it was not helpful just say like witness Kenneth Copeland, jail calls, social media. I think you just covered that though.
Well, and you know, in fairness to the state, I do think that when I asked them for that, I said kind of broadly, let me know what evidence. And now I'm asking for it in more detail, just because practically speaking, in the middle of a trial, we've got to sort out what evidence is admissible. And ideally not while the jury's sitting there waiting on us.
That's perfect. And
Okay.
we appreciate it. The specifics will make us roll better anyway.
Yeah.
Thank you.
All right. So any other motions that are still needing to be addressed?
This might actually be an appellate issue, that the absolute difference between
And y'all, it's 3:30
forward
and I
and what
plan
has
for
been.
us to do work until
surprise
5:30
evidence
and
from
we
the
can
state
take a
every
little
damn
break,
week.
but I'd really like for us to figure out something that we can make some progress on for the next 2 hours. So let's take a 10-minute break. Be back, well, it's 3:34. Be back at 3:45 and y'all think in the meantime, all right, what can we use this time productively to do?
you can throw out the case.
Thanks.
Yeah. Atkins loves anything that deals with efficiency. He just starts.
Yeah, and I almost feel bad for the prosecution, because their entire case is about surprising the defense with absolute garbage. They get 5 minutes from Judge Glanville to research and come up with something against. Otherwise,
Well,
it gets in.
And at the same time, they're arguing for this unfounded reciprocal discovery requirement that somehow exists in some world that Love lives in, that the defense needs to tell them everything they plan to think about using.
Yeah, and the judge replied to her when she was done. I mean, that was so great to hear when she said, "You need to be reminded of your candor to the court," which is, as a few in the chat says, don't BS me. This was a BS motion and you know it.
That was as close as to agreeing with the defense that this was a bad faith motion without explicitly calling it bad faith, because that would open a can of worms.
Yeah.
But that's, this is here.
Yeah. But now Judge Whitaker is definitely alerted on what Miss Love is prepared to do.
Oh, wait, Thugger Daily pulled these clips he said he's doing a series now. Let's pull these clips. So, let's see.
Oh.
Make sure
In a written or oral filing.
Okay. All right. Well, I would like for you to take your duty of candor to the court with a little bit more seriousness in the future, Ms. Love.
Respectfully, I take it very seriously.
Okay. So
In a written or
Okay, so.
And Miss Love mouthed back at the judge. Most
And that's
attorneys,
like the third time she did that today, where something was said and she had to clarify like that's not me or I am.
Yeah. And I don't think Miss Love can help herself, but now she's up against a judge. And I mean, had she never had a case against Judge Whitaker before? I don't. If she had, I'm
sure
for
she has.
entertainment purposes, I want the trial to continue. I mean, because this will be a completely new trial. For fairness, after this 10-minute break, I would love Judge Whitaker to get out and say, you know what, prosecution, you don't go screw yourselves, bang the gavel, mistrial with prejudice. Now, that would be extremely fun. I would live on that forever. But everything that was said now when she started to focus, the jury will be back then, and they have a week off then, and blah, blah, blah. It's not going to be a mistrial, folks.
Yeah, I don't think so either, but I really think she's looking at these key issues that could make or break the state's case, even mid-trial. Even if I think it's so beneficial to the defense that it's been off the rails for 100 days, and then if it comes back running with a tight ship, tight admissibility decisions, rulings that don't lean in one direction, you have 100 days of blather, and then you have a tight, what'd she say, 30 weeks, or she wants this done in 30 weeks, or is that just for the state's case in chief?
No,
imagine that.
She said specifically, this trial should not take another 7 months. I believe that was her actual wording. And she was quite shocked at it because
she could stop their case in chief. She could tell them they're out of time.
Yeah, she could actually, she has the discretion of putting a time limit on the prosecution. She has that right as a judge. And
I don't know what clip this was too, but if you want to watch, it was 2 minutes. It's the I think it's about what we're talking about. It says talking about there's going to be no sense and it was impractical. So this is where she gets called out for exactly what we're saying.
Can y'all explain to me how you are dealing?
And hold on, pause. This was unsolicited. She went into this on her own. Sua sponte. No.
Can y'all explain to me how you are dealing with a large volume of what ought to be motions in limine while in the midst of trial?
What is she mouthing?
And still being in any way efficient with the jury's time? You're not, essentially. Okay. All right. That's just not practical. I mean, we're going to change that going forward. And
She's looking right at them.
I need you to know everything tomorrow because I know it's a voluminous case, but y'all been putting this case together for 2 years. And you ought to know, I mean, you clearly know what witnesses you're going to be using, and you've given me, kind of a very broad idea of what exhibits you intend to use with those witnesses. But I don't know that if we're just every other week saying, okay, let's figure out all of the evidentiary issues that have to do with the next 2 weeks worth of witnesses. We can do that in one day on a Friday. We just can't. So we're not going to be able, I mean, we all know that we've got this week, and we know that the jury has already been told before I became involved that they essentially have the week of, August 19th out. So, this week might be taken up pretty much with sorting out the 2 things I just mentioned and then sorting out all of the evidence that goes along with Mr. Copeland, because he's our next witness up. But the week of August 19th, we need to be plowing through a whole lot of other evidence, not just what's coming up in the next 2 weeks. We need to be covering the next several months.
My only guess is that Atkins has said over and over, this is poor trial strategy to be taking so long, because he is always so enthusiastic about efficiency, streamlining, not repeating things, not wasting time. And he probably asks or advises or tries to speak and brainstorm with Love, and Love probably doesn't want to hear him.
Yeah. I saw this earlier in the chat. I am, for the record, I have a law degree. I work with law, but I don't work as a lawyer. And in Sweden, lawyer is a protected title. I can only call myself a lawyer if I work as an actual lawyer. I have all the things needed, but I don't work as a lawyer.
It's weird because I
So-
used to hear there was a distinction, and I heard, like, now I know that it's not true, that they're still used synonymously, but a long time ago I heard that a lawyer in the United States, you know, they have their law license, but they might not practice in the court, but an attorney is the one that practices in the trial court. And that really isn't the distinction, but I feel like conceptually there should be a distinction there. It's a different kind of skill, different type of approach. And then while we're talking about legal definitions, Biliano Fever, I think you wanted to explain a motion in limine. Now, a motion in limine is, we are trying to, or we want to make this motion to exclude something, whether it's evidence or testimony or even just an argumentative theory. Sometimes it could be the theory that we know, maybe the state or defense wants to put forth the theory that there was self-defense. Maybe we want to argue against that being allowed in, or we don't want to let them refer to this witness as a criminal on the stand because we don't want their testimony to become less credible in the eyes of the jury. So we'll make these motions pre-trial. Motions in limine, you typically see pre-trial.
Yeah. And they had, remember, they had 10.5 months of jury selection to work through all of this. But the prosecution didn't want to, and Judge Glanville allowed them to. Every week, in the midst of testimony, the prosecution has brought up, now we want to refer to jailhouse call 3, 4, and 5. And the defense goes, what? Yeah, you got that. When? It's in the discovery. Yeah, but that's 7 terabytes of documents and stuff. And there are, I believe, the number I heard in discovery is the amount of jailhouse calls in discovery is in the thousands. And that was enough for Judge Glanville. Well, you had it for this long, haven't you? Well, yeah, but we also had 578 more jailhouse calls. And the Judge Glanville didn't care. It was enough for him that it was in discovery. Up until a certain point when he asked them, the Friday before, you need to connect the witnesses with the evidence you are trying to get. And then they had, for instance, with Woody on the stand. Well, he said he doesn't recall. So now we can bring in this pile of evidence. And apparently, they instructed Woody to answer in this manner so they could get, it was self-serving. They opened their own door. And opening a door means that either the lawyer
it couldn't
asks,
normally come in.
Normally they couldn't get in, but a lawyer or the witness make a statements or questions which opens the door for further examination of that particular issue. Here, the prosecution opened their own door, which I don't think there's an exception for that.
I think the number one
door.
example that I like to refer to, because I know a lot of people paid attention to Depp v. Heard, was there were motions in limine about the story that Amber Heard said she was held in a 3-day hostage situation where she was R-worded by a Maker's Mark bottle that was broken or maybe not broken. There was motion in limine. They wanted to be able to make that private testimony that wouldn't be televised to the world, on the grounds that it could be sensitive to repeat and relive, and that would, but her attorney talked about it in opening statements. Yeah. So guess what? You ruin your own motion in limine. You rammed the door down for that to be questionable and televised cross-examination in the public eye.
I remember that. It was so cringe because then
so
she
bad
to the court that, but what we say in opening statement isn't evidence. And
it doesn't matter. It's an argument. It's an argument that you're making. So that's why when I was saying, like, what motions in limine refer to. It's not just the admissibility or we want you to limit something that can come in as far as evidence, exhibits, or testimony. It can also relate to theories and arguments that could come in.
Yeah.
So in a lot of DV cases, they don't want to, if there's an assault between two people and there isn't something to substantiate that there was actual ongoing patterns of abuse, they'll want to restrict the other party from being able to use terminology like coercive control and DARVO. They'll make motions in limine say you can't use those terms and try to trigger something in the jury's brain to think about a pattern that we're not going to be discussing any evidence for. So, but I don't think Love understands what a motion in limine is. Mid-June, she filed one about the judge sustaining too many leading question objections from the defense. And it was stupid. It was a stupid motion.
Yeah.
Somebody on this side of the courtroom actually has some kind of speaking relationship with somebody.
The judge
Yeah,
should be.
zoom in on her. Look at her. Oh, why am I
Yeah.
lagging? Let me refresh it before she starts saying something important. Let's get in here. Oh no. I could switch over to a different feed. Because I don't have any bandwidth issue indicators here.
You want me to
Dun, dun,
pull it up?
dun. Yeah, let's do that.
Hold on.
All right, what is it?
Thank you.
And as you can see, you can have the text green.
I love that. You taught me like 2 new things now.
I'm gonna come up here. There are, way back when, and we're looking for the filing right now.
Okay.
There's back in, I would estimate, June of 2023, maybe. There was discussion that we needed to know all the alleged co-conspirator statements that the state intended to use,
I remember
as
this,
well
yeah.
as any and all extrinsic acts that the state intended to introduce evidence of at trial. My recollection, and I would defer to that filing, was that there was only 3 801D2E
I don't know.
co-conspirator statements.
Okay.
There was only 3 listed, and then there was also a certain number of extrinsic acts that were listed. Throughout this trial, the state has gone past that list, and that has led to much delay and litigation and sending the jury out. So I think that's something we could discuss.
Okay.
What if that is the entire list, which I submit it should be, we could discuss that. Also, there are, and I don't know if this falls under the discovery that we were going to talk about tomorrow, we are missing the reports of many experts
Okay.
that the state plans to call, is my understanding. Also, Your Honor, there are, in this case, the state, I believe, has announced that they plan to call 5 different gang experts.
And they've called 3 at this point, is that right?
I believe that is correct. I believe it's 3.
So maybe explore what, if anything, the other 2 are going to add.
And not only that, but the state has announced the intention to call a few of them multiple times.
Okay.
So that is another issue that's continuously come up in this case. Am I missing anything from our list?
the reports that are suddenly
That was it?
missing. But the
Okay.
evidence,
Okay.
So
All
those
right.
are
Because
the
it
those are
can't
the
be
issues that we came up with.
Thank you.
that
All
they
right.
find.
And if the state needs the evening to, sort out everything and make sure that you're being inclusive and answering to the extent you know, that's fine. But if you know now, that's also fine. Do they have notice of all the different co-conspirator statements that the state intends to use and the extrinsic acts the state intends to use? Y'all can answer now, or y'all can say, give us till the morning.
Your Honor, I'd ask that the court just give me a moment. We're pulling up the.
Okay. All right. And while y'all are looking, I'm just going to make a general sort of admonition to not the parties in counsel, but anybody that wants to come in here to watch this case and I mentioned before, but I don't know, I may have to mention it a couple of different times. I don't expect there to be frequent up and down, in and out. That's distracting. So try to keep that to a minimum. There shouldn't be any talking in court other than the parties maybe whispering between the attorneys and the clients in the court. If you're watching the case in here with us, and you need to say something to somebody else, step outside to do that. There doesn't need to be any it's just distracting. There's a lot going on and there's a lot to pay attention to. And when we've got other conversations going on, it's that much harder to focus on what we and I need to be focusing on. And I also want to make clear that the deputies in here have my full authority to manage this courtroom. So if they give you an instruction, you need to abide by it, okay? And I'm not talking about or to anybody specifically in here right now. Just some things I've noticed so far. And I, again, will probably make that announcement a couple of different times in the upcoming weeks so that everybody is clear on what the expectations are.
Yeah, I will be in this courtroom on the 14th of August. Unless Miss Willis and Miss Love sees me, then I might be in jail.
To whom should you what? Send it? Miss Percifield.
Your Honor, to the extent that the court's question was specifically, have we noticed the defense of the evidence of intrinsic acts? Is that the question that the court asked?
No, maybe it wasn't very artfully formed, but to the extent you can, to the extent you know, and hopefully you know since you're in the middle of your case, I would like for you to make sure that you have given the defense notice of whatever co-conspirator statements you intend to use, and then separately, whatever extrinsic acts you intend to prove.
Okay.
Okay.
But Judge, that removes.
And
the
if you want
surprise
to
element.
do that now, that's fine. Otherwise, that's something we can go over in detail tomorrow.
Judge, I'm looking at I'll start with just the intrinsic acts, and I'm looking at 51 of them. I'm not sure about the 3 that were referenced, but within the intrinsic act notice that we filed on November the 6th of 2023,
Okay.
we made specific references to 51. And we also said acts contained within this non-exhaustive list. We referenced that the list was non-exhaustive, and we noticed the defense of the state's intent to introduce evidence of these particular acts. if the court will permit me one moment. I just wanted to call the court's attention to the November 6th.
Okay, so given that you noticed 51 but said it was non-exhaustive, that sounds like there might be others. So at this point, can you make the list exhaustive?
Yes.
Okay. And then the 3 was co-conspirator statements.
I've lost. I can't even count the amount of co-conspirator statements they have brought in. Everyone is a co-conspirator in this case. And every time they want to make a hearsay statement go in, oh, these are unindicted co-conspirators. Their statement goes in and Judge Glanville was, okay.
They're working so hard at that prosecutor bench today.
It would be so much fun.
And then shout out to Polo. What about Woody's testimony after the recusal request? I mean, they're not striking the 7th, 10th, and 11th from the record and part of the 12th from the record. So, but I'm sure they'll have to revisit some of the logistics of getting him back up on the stand.
Yeah, I mean, it's still up to the judge's discretion. She might, I mean, legally, she can go from the 12th forward. But I believe it is in her discretion.
Well, we don't need to take court time now. How about you
have
testimony? Can you have tomorrow?
That's also
by
my
tomorrow,
understanding.
what all the co-conspirator statements are going to be? And then how much time do you need to make the other list exhaustive?
Okay. So, Judge, what we're discussing is the number of co-conspirator statements that may be contained within the jail calls that we are also, jail calls and the wiretap calls that we are intending to introduce. And so, to the extent that we reference simply what we filed, we can present that, but we would ask the court to allow us to address on the week that the jurors are out. The 19th?
Yeah, for the record, everything Woody has said online the past month.
So if it's anything with
be
Mr.
used.
Copeland, that needs to get dealt with this week.
So with respect to Mr. Copeland.
Sure. Go ahead.
I believe it would be the right judgment call from Judge Whitaker to make. Because how do you instruct a jury? Oh, you can only remember the first 3 days of his testimony, not the last 4 days. I
To be fair, they might not remember those long videos.
It is in the realm of possibilities that he will sit up and plead the fifth.
I'd be interested to see how Whitaker handles that.
Yeah.
Okay, Your Honor. With respect to Kenneth Copeland, will the court permit the state to address in its entirety tomorrow the ones that we are intending to introduce? As we are discussing, those statements are contained within the videotape interviews and jail calls that we have intended to introduce and have noticed defense of our intent to introduce. So in terms of what the specific statements are, I think we would best be.
Okay, so does everybody from the defense understand, at least with regard to Mr. Copeland, maybe not in detail, but what the universe of potential statements is for Mr. Copeland?
So,
I mean, y'all had gone through a lot of this and hashed it out once already, and you might not have gotten through everything, but y'all had done various statements and gone through in detail on what was in and what was out. And I know we might have to do that over again, and then there are jail calls that y'all had not reached yet, but I think the state had represented there were 5 or 6 of them, and y'all know which ones they are. So That y'all all know, right?
So we know about the jail calls.
Okay.
That assuming that the state's not expanding that list.
They're not going to be expanding that list, are you?
And
Not the jail calls for Mr. Copeland, no.
Okay.
and when they say noticed of things that are in statement or as past statements, I am aware that I'm not aware of any co-conspirator statements by Mr. Copeland from, I'm aware of the Garlington to Copeland
Right.
statement,
Yeah.
but
From
I'm-
Mr. Copeland himself.
I don't, when they say they've noticed us on statements by Copeland that are in his statement, in his prior statements, I don't know what that
All right.
means specifically.
Okay. So are y'all including within that, like, here's what Garlington told me?
Yes.
Okay, so. All right, so that y'all do have, and how many of those are there?
How many statements of Garlington to?
How many co-conspirator statements from any alleged co-conspirator are there that y'all are going to be introducing through Mr. Copeland? Or potentially introducing through Mr. Copeland?
Oh, good add-on,
At
potentially.
least 3 co-conspirator statements, 2 from Garlington that is contained within the June 10th interview. And then there's a jail call with Mr. Copeland and other unindicted co-conspirators as well.
Okay. So defense.
If there's more, we can correct that tomorrow, but.
Okay.
I'm thinking of-
All right, so take a look at it tonight and make sure. Okay. And then with regard to the other acts, do you want me to I think it would be a good idea to have a deadline for giving the exhaustive list over. So do y'all want to make a suggestion as to how long y'all need to do that?
Just 1 second, Your Honor. Monday, Your Honor, is that?
That's great. Yes, that'll work. So that'll be Monday, August 5th.
For the intrinsic act.
Yes. Okay. Moving on to discovery reports of state's experts. Did you know specifically which
we
reports
go.
or which experts you feel like you're missing reports from? Okay.
Now, this has been handled before, so I don't, which will probably be Ms. Love's counter argument. That your plan will found that.
Your Honor, I just
Right.
asked my coworker that I'm privileged to work with to email to your Honorable Court's coworker and everyone else the November 17, 2023 written order on this topic. And I don't know if this court has seen it, because, and if you want the court reporter to be emailed out, I didn't do that either. Apologize. But we had a hearing on this on or about August 21, 2023. Opening statements were approximately November 27, 2023. And we have no reports of any gang expert. We got a PowerPoint the day of testimony from
Opening
the first
statements?
witness is my memory, but if I'm wrong, I apologize and please correct me. And that PowerPoint had to be gone through and had to be excised. His name is Detective Belknap, which is B-E-L-K-N-A-P. Then Detective Dennis testified. He was allowed over strenuous objection to say that we did this work and we spoke with witnesses and we spoke with victims and we spoke with co-conspirators and we spoke with people who identify themselves as a gang member in IF or a gang member in YSL. And based upon that, we know that the following crimes occurred, and here's some 911 calls. I don't know who these people are. We have no background. That's in my opinion, that's a confrontation clause violation because it's the police officer doing the work. We never got any reports. When I've asked for the reports, I was told that that's under lock and key by the City of Atlanta Police Department. And he, meaning Detective Dennis, no longer works there and cannot get, they have a gang book. He described it as a gang book, but they can't get it. Detective Belknap said he cannot get access to give out that gang book. So we're basically in the dark and we're hitting as best we can, but this is all over objection. I have no idea how to challenge. Like you heard earlier today, there's a lot of information for the court, but you heard earlier today that, God forbid, it's at 7:22 p.m. The 911 call goes out and Mr. Donovan Thomas is shot. He's killed. It's on video. It's bad. It's a drive-by shooting. He gets shot. Multiple gunfire. 2 other people are shot as well, but thankfully not fatally. Within the next several hours, so it's 7:22, so within 5 hours, Mr. Copeland says that abodes that are close to his family members, and you heard a representation that Mr. Williams, they said stepfather's home was shot. I have no idea who shot that stepfather's home. I have no idea who to speak with about it. There's a 911 call about it. I'm not conceding that it was done by a gang member. That's why it's impossible to cross-examine. The next witness, who is deemed an expert by Judge Glanville, is a Detective Gaither, which is Gaither. And she testified as well. I didn't make a report, but she goes into, I spoke with people, they're unnamed people. It's the same thing. I would like to know who these people are because I'd like to talk with them. Because if they say, no, I never said that, that's important for the jury to make credibility determinations. That has all been kept away from us. Judge Glanville ordered the state, and it's just, it's easy to read the order, but I wrote the order after the argument, but he signed it. In order to permit a meaningful opportunity to cross-examine, all expert notes, reports, documents, statements, basis of opinion are required to be disclosed by each expert for the prosecution as to the underlying facts or data so cross-examination can properly, lawfully, and constitutionally occur. That's right out of the case of Harris, Harris versus State, which is 314 Georgia, 238. It's in Division 6A, is in Elisa, 875 Southeast 2D, 659, 2022 case, where our Supreme Court said that is not the rule in Georgia, but we encourage trial judges who can control the proceedings to order that to be done, and Judge Glanville ordered it. The state never gave us those witnesses. Then you have Detective Belknap talking about, well, at APD, meaning Atlanta Police Department, we have 6 criteria that we designate someone a criminal street gang member and a criminal street gang. Then you have Detective Dennis. He gave those same policy requirements. Then you have Detective Gaither. She gave the same ones. Mm-hmm. It is my understanding that the next 2, which is Detective Underwood, which is UNDERWOOD, and she's going to testify, I assume, I don't know because I have no reports, similar policy. And then you have Investigator Viverito, which is VIVERITO, also with the City of Atlanta Gang Division of their policy. All of this is cumulative. All of this, I have zero, none of us has any type of documentation. And the way I understand the rules, an expert, yes, they can rely on hearsay, they can rely on the opinions of others. I understand that. But when asked and when you testify, you can challenge those opinions and those statements. So you have to know who said them to you, and all that has been kept from us. So that is, I filed a subsequent motion that it's cumulative. Then how many experts you need? Judge Glanville said, it may be getting cumulative, but he did not rule that way. But he said this could be getting cumulative, but he allowed the next expert to testify, which was Detective Gaither. And then I don't know how we have no reports when there's a written order. We had zero on it. It's hard when the expert is just saying, or the witness is just saying, well, I do this, I'm on the street, I know these people. Brian Steele, you don't know how streets work. And I go out and this is how I get information. People will talk to me because they know that I won't put it in a report. Well, that makes it pretty hard to say, well, I don't think the jurors should just rely on your word. I'd like to know who that witness was. Well, I'm not able to tell you. I don't want to tell you. I can't tell you because I left the office. That's the issue I'd like you to address.
Okay, well, I mean, I understand the frustration. If there is no report, there is no report. But what was the date of the order that Judge Glanville issued that you referenced?
It is, and it was emailed to your honorable court's coworker
thank you.
at 11, which is November 17, 2023.
Okay, 24?
No.
23, 22,
23.
23. Okay.
Thank you.
All right. And that's, unless I specifically change what's been directed in an order, all of the orders that have been issued continue to apply. So I'll expect the state to abide by the requirements of that order. And we'll have to address whether the other experts might be cumulative. Besides these gang experts, are there other experts who you believe there should be reports for that you don't have?
My knowledge, unless my mind is not working, I believe I have reports on everyone else.
Okay. Anybody else?
That's if I misspoke, but that's my understanding.
For any of the other defendants, anybody believe there are other outstanding expert reports that you don't have? Hearing silence, I assume it's just those. Okay.
Your Honor,
Yes,
may I briefly address the court related to this matter?
you may. And one thing before you start, I want to ask, and I could be entirely wrong, but with regard to the experts that are being recalled, I would assume y'all are trying to present your case kind of in some semblance of order. So it may be that right now they're testifying as to ABC count and later they'll testify to XYZ count.
Correct, Your Honor.
Okay.
There's some witnesses who were fact witnesses, so to speak.
Okay.
For a specific part of the investigation. And they also will testify down the road about another.
Okay. All right. Is that all? Yeah, go ahead. And if there was something else you wanted to say, yes.
Your Honor, just briefly, I wanted to kind of orient that as different gang experts that the state have called to the stand, this argument has been addressed or raised to Judge Glanville. And part of it is gang experts, unlike GBI experts on blood or touch DNA, the police reports that the state has related to the underlying crimes. This is obviously crimes that span a decade. So the gang detectives, specifically Detective Gaither, Detective Dennis, they worked, I think, approximately 26 retaliatory shootings after the January 10th murder of Donna Thomas. So they worked as the lead detectives. For example, we have put evidence, you've heard about D'Angelo White. That was a shooting, attempted murder that happened that Detective Gaither and Dennis picked up after essentially an aggravated assault detective within APD had it, because they're gang detectives. So when they talk about, they don't have, as you would have in, say, a scientific report like a 50-page treatise of the Young Slime Life street gang. They have worked these crimes, and their reports or warrants that the state have been turned over. And so the basis that they state their opinions to the, they speak it's from working the case, it's from talking to people. So
they're
that's
experts based on their experience.
yes, Your Honor. And part of the issue arises is the reports that the defense is requesting, they do not have. And so, for example, I believe it was Detective Gaither and or Dennis, they mentioned, they know they are retired from APD. So when you ask them, well, do you have some other additional reports? They say all the reports I made, were in my file. So the state is not aware of any reports from these gang experts that we have that has not been turned over. The state believes that those kind of four corners from this decade of acts in the case don't exist, of like Detective Gaither or Dennis didn't write some large report
Sure.
in total.
Okay. Has the state asked, not the individual detectives who have since retired, but APD? Do we have all of the reports relevant to this case?
Yes, Your Honor, and I will defer to my co-counsel because I came on this case in December, but my understanding is that that has been Chief Deputy Love or Hilton, correct me if I'm wrong, to the court.
Yes, Your Honor, the reports, this is an issue that has been addressed multiple times after the order was entered. Every time that we address either Gaither, Dennis, or Belknap, the issue is raised that there is an absence of a report. Judge Glanville, the court can search the transcript for this. Judge Glanville has addressed repeatedly Mr. Steele's motions and his assertions regarding their lack of a report from various experts. I'd ask that the court review that portion. You do a search for the word expert or report.
I'm not going to do that. Sorry. I mean,
No, I don't have any problem with that, Your Honor. My point only is that we've addressed
got
that.
enough to read besides
We've
searching
addressed
for
that issue
expert.
multiple times.
Okay.
And Judge Glanville has ruled on Defendant Williams' repeated motions for a report of detectives Gaither, Dennis, Belknap, our gang experts. Judge Glanville has ruled on that even after the order that was entered. So I don't believe at this point that there is any further ruling unless the court wishes to reconsider the rulings that Judge Glanville has previously made. I don't believe that there is any further matters to be ruled on as they relate to expert reports and the gang experts that the state has identified for the defense.
All right. Just make sure that you have abided by and continue to abide by the order issued on November 17th, granting the motion for complete witness list and expert reports and analysis and findings. Okay.
Except
Can I
that
respond to that?
go there
Yes.
explicitly said read
And I was
by
going to provide one
reports.
case to the court.
So,
Either before or after.
okay. All right.
Mr.
Yeah,
Sharp.
no, we'll let Mr. Atkins
Thank you.
finish. Let me, and Mr. Steele quoted it for us, but what the order says is all expert reports, their analysis, findings, and the basis for same must be provided to counsel for each person accused instanter, which means immediately. So
Defining the words.
the way I read that, that means even though this goes beyond what our discovery statutes might require, this order is what controls. And so even if there is not a written report, you need to give to the defense any findings that these experts have made and the basis for those findings. Okay, just make sure y'all understand that.
Yes,
All
Your
right.
Honor.
Okay, go ahead.
The case, and I apologize, but it's Hassan v. State, which is a March 19th, 2024 Supreme Court of Georgia, HASSAN v. State. The version I pulled up is from when it was just pronounced, so it has
What's the
Site.
S24 number?
It is, Your Honor. So I need to pull up another version. I have the version I saved when
Okay.
it first got published. So I have a 2024 Georgia Lexus 7.4.
Well, that'll work. 2024 Georgia Lexus
7.4, and then it gives a Westlaw.
7.4.
Yes, Your Honor.
All right, I don't use Whistle.
But what I
I
wanted
used
to,
to. I just don't anymore.
I've only used primarily Lexus, Your Honor.
All right.
What has came up
Mhm.
briefly in defense counsel argument, but gets brought up is this case is important because it discusses when, for example, gang detectives are speaking about. Typically, experts can talk about or rely on hearsay
Right.
to make their expert opinion. So when you have gang investigators who have spoken, talked with a number of people, part of their response or expert opinion on XYZ is based on years of experience. And so this case has an important holding in relation to specifically, neither witness expressly repeated the out-of-court statements of any other person, although the detective testified that he was familiar with the Ramsey investigation, which was some other investigation he was talking about. and referred to speaking with another detective who worked on it, he did not specifically state what the other detective told him or how he, developed his familiarity. So it was not obvious that the evidence was hearsay, such that the trial court should have sua sponte excluded it. And this was a gang case where, kind of like how Detective Gaither, Dennis, and then Detective Viverito down the road, they reached their conclusions. And so if they are not directly deriving what their statement is from hearsay, as an expert, this case is helpful to illustrate in the context of a gang expert how that can come up. So I just wanted to share that, Your Honor.
Appreciate it.
Thank you.
All right.
Thank you, Mr. Sharp.
Okay.
So, Your Honor,
Yes.
I don't want to be taken as crying over spilled milk, but I'm really just trying to bring things to your attention. Miss Love referenced in kind of, I feel like I was the one that was making the most noise about the reports, especially investigators' reports. And the reason I was doing that, and we're not talking about expert testimony right now, reports by an expert.
Mm-hmm.
These experts were also testifying as fact witnesses.
Right.
And there were several times, it was Investigator Gaither, and I believe it was Investigator Dennis. I could be wrong on that, but it was definitely Investigator Gaither and another investigator. I think it was Dennis. And they testified to doing things in these cases.
Mm-hmm.
And we're looking at a lack of reports indicating that these tasks were done, showing photo lineups to certain people, interviewing witnesses. And I complained about that. And I said, well, where are the reports? Because at first I was, in cross-examination, well, wouldn't that have been something you would write a report about? And they said, well, we did write the reports. And so we met out in that side room with Investigator Gaither, but I believe Investigator Dennis, we also talked to him, and they insisted that they wrote reports about this work. And it is correct when they said, when we left, we're retired, we cannot access the reports,
Sure.
but we left them with APD.
Okay.
The state has stated that they don't have these reports.
All right. That should not be happening. We'll take that back up when she comes back in here, whoever she is.
The state has stated repeatedly that they don't have the reports, and I think all of us are left in this quandary where the state's saying they don't have reports, but the witnesses are saying we wrote reports. And
Okay. Do you have dates for any of that? Or have you previously discussed with counsel for the state
well, when I brought this up to
what you think is missing?
yes, well, unfortunately, those witnesses have already testified. So, of course, I would like the reports. But going forward, and the part of my frustration is when the state says, we don't have reports, and the witnesses are swearing there's reports,
Right.
so we can't really nail the witnesses on it, and the state's saying, well, we can't hand anything over either. Then we talk about it, and the court at the time just kind of said, well, there was a hack in 2018. And
That's actually what I was literally about to say, is it's possible that for some of these things, I mean, we all remember, we were all around in 2018, the city of Atlanta there was some huge cyber attack and lots of things got
All
disappeared
the other
from
reports exist, except the gang experts.
everywhere, wiped out. So if that is the excuse for some of it, it's probably legit.
well, I'm
And
not
it's
saying
gonna
it is
depend on
or
the
isn't
dates.
legit. I'm not saying it is or isn't
Right.
legit, but I just,
I'm happy to bore down on it some more and talk
Because-
specifics.
I mean, it wasn't even, I can't recall if that was even suggested by the state, but that was just thrown out there. Well, reports are missing because of the hack. And I'm like,
Well,
well, how do
I'm
we know that?
happy, yeah. If you want to get together a list, and I mean, maybe more so for the witnesses going forward. And these, we're at this point not really talking about expert reports. We're talking about police reports, fact basis that ought to be out there. And if you want to in detail get that, because that is frustrating for everybody. I mean, yeah, it's out there. You wrote it down. So unless it disappeared in the cyber attack, it ought to still be able to be gotten, even if not by that witness, because that witness is retired, by the state, because the police and law enforcement are a part of the state. And so it is within the control, if not the custody of the state. So I'm happy for us to bear down and bore down and drill down some more on that. If y'all want to give me specifics, or if you want to, well, give both to me and share with the state specifics, because that will help them as well, to not just say, hey, APD, please give me everything about this case. But there should be a report from Detective Gaither dated August 2nd, 2000 about a lineup she did. And then they can actually search for something. So let's, to the extent y'all want that, and you're certainly entitled to it, let's get details together so that we can give that to the state, so they can give that to APD, and we can actually hopefully find something if there is something out there but missing.
Yes, Sean.
Okay.
Thank you.
All right. Yes.
We
Yes.
turned over to defense. Every report from 2015, every report that the experts have referred to or will testify about, and the complete case files that exist for each of those reports.
Okay.
So we've turned that over. If I will await defense giving to us what they now posit they don't have.
Okay.
That we have not already addressed.
Okay.
And Your Honor, I am asking the court to refer to Hassan versus the state, 318, Georgia 673. It's a 2024 case. That's the full citation of the case that
Okay.
Mr. Atkins just.
Oh, perfect. Thank you.
Your Honor, I mean, with all due respect to everyone here, that's a bit disingenuous,
I think
because
is your mic on?
I'm turning it on.
Maybe we need to take a look at that and see if it's still working.
With respect to everyone here, that's a bit disingenuous to say, well, we're raising this for the first time. We had the issue in court with Investigator Gaither. The state is very aware of what those reports are. I'm not saying I know all the answers here. All I'm saying on those previous occasions, there wasn't, in my estimation, from my vantage point, there wasn't a lot of effort, and it was just blame the hack.
Okay, well, thank you.
Yeah.
And I don't want to keep going back and forth with blame or bashing. I want us to be productive and talk detail so that we can make things happen. So thank you. All right, what else, if anything, that we can deal with today? It's okay to say that's about it for today, because I've got some homework anyway. All right, so we will adjourn for the day, and we will see everybody's smiling faces at 8:45 tomorrow morning. Thank you.
Your Honor, before the court.
Oh, yeah, there's one more thing for me too. Go ahead.
There is a scheduling matter that we would like to address with the court.
Okay,
With a member of the bench at the bench.
okay, come on up. And I guess one person from each team.
Yeah, Miss Love lied to the court again. She knows damn well. Last time they argued this with it was Detective Gaither, and she specifically said, we have called the APD and they say they don't exist.
Earbuds and what have you over
I know.
here that I have never used before. And if we're going to be using those during the trial, I would like a little bit of practice on them before we get in front of the jury. So maybe, the next day we end at 4:30. Y'all remind me and let's all figure out how those work because I don't know yet. All right. Are you just going to be representative of everyone?
Yes.
Sounds good.
Yeah, but what's surprising about Love lying or making something up or stretching the truth anymore? And
Yeah,
it does suck that the judge wants to, in retrospect, looking at things that are behind her, give the benefit of the doubt, But
Yeah, and the more she does this, because next time Belknap or Gaither will be on the stand, this will be up there again. And then
well, and I was gonna say she's gonna make herself dig the hole that the judge has let her crawl out of. She's gonna dig it again.
Yeah.
I have no faith in Love to not do the same thing she just got a pass out of for. She's gonna do it again.
She can't help herself. She just does it. Last time Gaither was on the stand and this issue was brought up, she told the court and the Judge Glanville, we have contacted the APD. Those reports do not exist. And now, in front of the court, he said, we have everything has been brought over, every report, everything. And then she alludes to the fact that only the gang experts' reports are actually missing. Only the gang experts. But conveniently, the evidence that suits the prosecution that was in those reports, those were found.
I think that was very generous to give the benefit of the doubt about the hacking issues being a reason for the suspicious missing reports. What detective was it that Brian Steele said to go home and do their homework?
Oh,
It wasn't one of the first people called. It was this year.
It wasn't Velasquez. It was that short guy. Who was?
That's the thing. Like at that point in time, I was listening to the trial. I have no visual for that. I was listening to the days.
The state, due to a scheduling matter, may
it was
want
Belknap.
to,
Thank you.
whenever we do pick back up with the jury, which hopefully will be soon, but I'm not sure yet what all we're going to get finished with this week.
No.
If we bring the jury back
This is a
next
former
week,
prosecutor. One of the best
there
in
is
this
a
trial.
request for the court to consider having a witness who is not Mr. Copeland be the next witness because of a scheduling matter for the attorney who was examining Mr. Copeland. Now, we have to redo at least part of Mr. Copeland's testimony anyway. I don't know if that's an issue to y'all. We're going to have to come up with whatever we're going to say with regard to, you may be hearing a lot of this again, and you're going to need to disregard what you heard before. We'll have to work on that, and y'all be thinking about that. That's y'all's homework. But is there objection to moving to another witness and coming back to Mr. Copeland? And if so, what is it? And then I'll consider whether I'm going to permit it or not.
Do the Melnick argument. You better find a way.
There's an objection to going back and telling the jury anything about disregarding Mr. Copeland and having to do it all over again. It's impossible. There's no way in the world.
All right. Well,
The jury
yeah.
just disregard Mr. Copeland.
Okay. But that's not what I was asking. I understand that you just think that is a total disaster and makes this trial one that needs to be a mistrial. I understand. But that aside, just with regard to scheduling, assuming we are going to go forward for the purposes of this discussion, and assuming that I mean, y'all don't stipulate to everything he's already said and that we have to redo a part of his testimony. Well, whether we do or not, we're going to have to continue his testimony. So is there an objection to essentially taking some other witness out of order in the midst of his testimony?
Yeah, go Adams.
Your Honor.
Yes.
Keith Adams on behalf of Mr. Williams. Mr. Steele and I have consulted about that. I don't purport to speak for anyone else. We do object
Okay.
to that. We believe that given the complexity of Mr. Copeland's testimony and the issues surrounding his testimony and the confusion that will probably already attach to a jury coming in and seeing some of what Mr. Copeland's heard and testified to and possibly having to be instructed about disregarding some of his testimony, we would object to going to another witness.
All right. I appreciate it. And I think with that objection, it's well-founded. So y'all do what you have to do with regard to who might be handling the examination, but we will
Are they going to make love
pick
to it?
back up with Mr. Copeland and finish with him before we move to another witness.
Would you allow another member from the state to continue his examination?
That's what.
Considering that we're going to have to, as I understand it, there are a couple of days of, and I don't know whether y'all got testimony out of him or not, or if it was just a discussion of whether he was going to plead the fifth or all of that. If there was there testimony from Mr. Copeland prior to the motion to recuse on the 12th?
Yes, sir.
Okay. All right. Considering that Ms. Hilton handled that testimony, we don't normally switch attorneys mid-witness. There is now a request on the floor to do just that, to switch attorneys mid-witness. We're switching judges anyway, and we're redoing some things, so it's a little out of the ordinary anyway, but if there are objections to that, I will entertain those.
May I speak?
Yes.
I would hope that that's not as of tomorrow when you rule on qualification, so that Ms. Hilton can go wherever she would like to go. As far as I'm concerned, we will not call her for several months. Who is the witness that would be substitute? I heard what Ms.
I don't know. Do y'all have another witness in mind?
What is the hiatus?
You said you had to call
I don't
Copeland
know that
next.
either.
Will be 1 week, Your Honor, will be my absence, will be 1 week. Your Honor, we do have several witnesses. It would be the state's intent to potentially just go in order of who we have kind of listed. So we wouldn't be calling anyone from the bottom of our witness list, but it would be someone within the same act that we're.
So you just essentially skip over him and go to the next witness on your list and then come back to him.
Yes.
But I've kind of already entertained an objection to that and said, no, you can't do that. So the question on the floor at this point then is if we're continuing with Mr. Copeland and not picking up with another witness in the middle, is there an objection to another prosecutor handling the remainder of his testimony and whatever needs to get redone?
We just have a moment.
Sure.
Yeah, I wouldn't.
This is crazy.
Miss Hilton is being buried by Woody. He is making remarks. He's being snarky. Yeah.
I mean, I honestly think Woody could handle anyone questioning him. Like, can you imagine Atkins questioning him?
Yeah. Yeah, that would be interesting. Here's the thing: for Woody has been around.
Look at Shart. Look at him beaming. He's so tiny in the back, but you can tell he's ear to ear right now, like the.
Yeah.
Look at them all looking to see their facial expressions. Nosy Nancy's.
Yeah,
It's just
tell Penny.
hypocritical. They
Oh.
made Melnick figure it out.
Do you think, you in the chat, do you think Hilton will come back after her vacation? Press 1. If you think she's going to skip the country, press 2.
Speaking only for Mr. Kendrick. Mr. Kendrick objects.
Okay. And on what basis? Because you want to make it difficult for the state,
No,
which is fair.
well, no, Your Honor. This whole thing is messed up.
All right.
We've got to
Go,
redo
Doug,
this
go.
witness.
All right.
We can't redo the witness.
Okay.
I don't even want to get started. So switching out the questioning attorney
All
is
right.
just even more complicated.
Okay. So let me take that part of this under consideration. All right. Okay. So the other thing that I had
Your Honor.
is I
Your Honor.
asked.
Judge,
Yes.
I'm sorry.
yes.
I'm sorry. Didn't speak
Oh, I'm
quick-
sorry.
No, that's
Did you-
okay. I didn't speak quickly enough, or my microphone didn't come on quickly enough.
We'll blame
Um,
it on that.
Yeah, it's the microphone. Just to be clear, on behalf of Mr. Williams, we don't have an objection.
Okay.
And I don't believe, I'll let everyone else speak for themselves, but I don't believe there are any other objections back here.
Other than the one already voiced by Mr. Harvey.
All right, so
right.
that's just us.
Okay.
I object to Mr. Adams making me look bad.
Okay, well, so noted. All right. Well, I'll think about that one. Okay, so there had been Miss Love put on the record this morning that she had made the request for the Monday morning meeting. That was the June 10th meeting with Judge Glanville and Miss Bumpus and others at some point in the afternoon of the Friday the 7th. And I said I would get that ex parte because it did get taken down. And so I reached out to the court reporter who handled that, and she has given me a rough. Now this, and I'm going to share it with each of you. It's a rough, so this is not the official transcript, but I mean, she's an experienced court reporter, and this is probably pretty close to what it's going to be officially. But anyway, I'll just share that with each of y'all so that everybody's on the same page about everything. Okay. So if y'all all want to come up here and get a copy from Ms. Pursfield, after that, we will be in recess for the day. Thank you.
Did I hear that correctly? That there was an ex parte meeting on the 7th as well?
You rewind it.
Oh, yeah. Well, sorry, I have control.
What did you guys hear?
And she has in the afternoon, Monday morning.
That's making me look bad.
Okay, well, so noted. All right. Well, I'll think about that one. Okay, so there had been Miss Love put on the record this morning that she had made the request for the Monday morning
We get to hear the screech again.
meeting. That was the June 10th meeting with Judge Glanville and Miss
Okay.
Bumpus and others at some point in the afternoon of the Friday the 7th. And I said I would get that ex parte because it did get taken down. And so I reached out to the court reporter who handled that, and she has given me a rough. Now this, and I'm going to share it with each of you. It's a rough, so this is not the official transcript, but I mean, she's an experienced court reporter, and this is probably pretty close to what it's going to be officially. But anyway, I'll just share that with each of y'all so that everybody's on the same page about everything. Okay, so
Okay, so if I heard everything correctly,
Sounds like There's a
On
different transcript then of something.
Yeah, but Friday the 7th on the afternoon, Ms. Love asked the
Yeah.
court for the ex parte meeting.
And we
Now,
thought it didn't
that
happen
was
till
the-
Monday.
And they didn't have it until Monday morning, not alerting anyone during the entire weekend. So this wasn't a Monday morning thing. This started to happen on Friday the 7th. And the transcript will be her request for an ex parte meeting and why they needed the ex parte meeting. That is what I assume.
So looking for the in-court transcript of in-court when she said, Your Honor, can we... So I remember her standing up on that Friday. We were watching it. Like, so she wants a
Yeah.
transcript of the actual in the courtroom proceeding.
Yeah.
Okay. That makes sense.
If-
So she's
if
probably
she-
looking for the reason why.
Yeah. But Miss Love, according to Miss Love this morning, made a statement to the judge. She asked for this ex parte meeting at some point in the afternoon of Friday the 7th. Now, was it in open court? Was it in recess? Was it her up on the stand? I have no idea. Oh, present
Sounds-
day 87 at 5:34.
I'll say it sounds like she's worried, or was worried this morning at least,
Yeah.
that there would be an issue with the, if we're looking at the transcript, we don't trust that Whitaker will find a reason for this ex parte meeting to have been held and could find a problem with it. So we want to go and say, like, well, we said on the record on Friday why we wanted to have one.
Yeah.
And I don't know if that will really help her or if it'll make it worse, because now Judge Whitaker's going to look further into the context, because Judge Whitaker said she already looked at the context of these stuff
Yeah.
surrounding the ex parte, but now she's got to look at the transcript about something that would be pertinent to the request for the ex parte,
Yeah.
which she clearly isn't fully aware of, fully contextual, like caught up to speed on.
Yeah.
So
But still, I'm still very impressed by how much this judge has managed to research this far in just a week.
yeah, I don't think it's a realistic expectation for her to actually be caught up. I don't really think that's
No, no.
realistic, period.
Not to be caught up, but she actually, at least regarding all these motions, those she was completely read up on. And I think that, to put into context, her telling off Miss Love, do not ever post any garbage like this towards me again. Yeah.
I agree with Ayana. If Love ran in to tell the court today, why wasn't it in the motions that were due Tuesday or the response that was
Yeah.
turned in Thursday and Friday? Great
Yeah.
point. Great point.
Yeah.
And then what was the last issue they were resolving before they actually adjourned? Wasn't there one more thing that Whitaker was gonna... We rewound it. Rewound.
But the last thing was about changing the who asked the questions to.
No, there was like something she was about to say, but we started rewinding it. But there was more she was going to say before the stream ended.
Oh, let's play it.
So it was like a little bit less.
If y'all all want to come up here and get a copy from Ms. Persfield, after that, we will be in recess for the day. Thank you.
That was a decent chunk
Okay,
of
so that's it.
paper.
I don't know, you guys.
I mean, if that was just Miss Love's, we need an ex parte meeting in order to discuss this, that was a decent sized paper pile she handed out with transcript. Now, that could have been the last half hour. I have no idea.
Yeah, it could have been who knows, a handful of documents, because everyone's got a mess of documents today too. But
okay, let's say something about. But this is all about exchanging the prosecutor asked questions. Yeah, I should
And
forgot
then
about the
I
phone
saw the
ringing in open court.
timestamps. Let's see. I'm gonna see. I'm sure my YouTube's fine now. Was this a law and crime stream, Demisha? Let's see. Because when I heard it, I remember it was mentioned more than once, but I don't know if the court reporter could have caught anything, because when I heard her ask, I didn't hear a reason stated out loud. I just heard her ask for it. But maybe she said something more and the court reporter caught it and
Yeah. Yeah, I don't know. Wow, it's 11 p.m. and my clock goes up at 4:30 a.m. It's 11 p.m. now. Yeah, I now lucky for me, I sleep twice a day, about 3.5 hours. I have a very strange sleep schedule, so I can manage it.
I don't know how you do it.
I've done it to my parents' enormous frustration. I've been doing this since I was a baby. Imagine your 4 or 5-year-old being put to bed at 9, waking up at 1 a.m. wide awake. That must have been fun for my parents.
Guys, what day was June 7th numerically? Like day 91? Because Law and Crime doesn't sort it by dates.
It must have been Friday the 7th.
Like when I searched June 7th, let's see.
Let's see here. Let's go back a bit and see.
88. They're so good. Oh my God, you guys are so good.
Day 88. Well, there's no idea in checking where I was because I press pause every 5 minutes because something interesting happens and I want to discuss it with the chat. And then I never have breaks. Seldom I have lunch breaks in my streams because I need that hour and a half to be caught up. The rest of
You got to do the 2 times. I think there was a lot of important stuff to hear today. Like every word was pretty important. Even though I know Shard, everyone said it was slow to listen to, but it would have been we would have lost stuff if we tried to 2 times it.
Yeah.
Okay.
And imagine this hearing with Judge Glanville. Oh my God. That would have been.
Okay, so this is a little off. This is 2 hours, 23 minutes, and 8 seconds. Let's see if it lets me go like 10 seconds further. Right when they come back, right? Okay. Or maybe was this supposed to be 3 hours, 23 through 3:28? Let me see if I got this right. Let me come back to the chat. Oh, 87. Okay. Hold on. No, I don't want Ashley Benefield.
Matters that I need to convey to.
There we go. This looks like Friday. This is definitely Friday. Let's go to 2. Okay, wait, so 5. Oh my God, it's definitely replayed, look. I remember at the end. And we'll still have to figure out what these other timestamps were. Let's make sure we're not missing anything else.
Lieutenant Walker?
And Your Honor, the state has a matter we need to take up ex parte with the court.
Okay, all right. Lieutenant Walker has been asked by defense counsels as a corporeal body for them to be able to talk with their clients once you clear the courtroom.
Yes.
Can you make that happen?
Yes.
Okay, all right. So once everybody is
cleared the courtroom. You just secure it and let them be in here along with their clients. Okay? Oh, yeah, once we go down.
Okay,
Yeah.
I'll make that happen.
Okay, all right. Okay,
One last thing, Your Honor. I just thought of this. Your Honor probably already thought of this. The no contact order with Mr. Copeland should probably also include not just these gentlemen, but other gentlemen that are on this indictment that are not sitting for trial. I think that would probably be. Okay.
okay, all right. All right,
Oh, did I miss it? I was like tuning out.
okay, we'll see you Monday, okay? 8:30. We're in recess.
Was it before that?
It was in the first 5 or 10 seconds when you started this.
Okay. Okay, cool. So she didn't give an out loud reason.
No, just they had
Yeah.
something they needed to address in an ex parte meeting.
No, I saw in the chat that it looked like she was whispering, but nothing that would have been audible to a court reporter, right?
I don't know.
Lieutenant Walker?
And Your Honor, the state has a matter we need to take up ex parte with the
Okay, all right.
There it was.
Lieutenant Walker has been asked by defense
Yeah, I don't see her giving a
counsels,
reason.
No.
as a corporeal body.
Yeah, so there's definitely like, I mean,
And that is definitely not alerting, because even if they say they want an ex parte meeting, yeah, but they there's plenty of them about scheduling a witness down the line. Nothing about we need an ex parte meeting regarding Woody.
yeah, and how would the court, like, Whitaker's relying on what's in the transcript. She says the transcript was the best evidence we have of what was said. If the court reporter didn't transcribe a reasoning given right here in this moment for this request for this ex parte, and she's being asked by the state, like, hey, we, at the end of that day, okay, well, I'm going to pull the transcript of that day and look. I mean, maybe Kristen Weaver has superpowers. Heard a reason that I didn't hear given, oh, we're worried about his safety.
Present, not perfect, says listen before that for context. Okay.
I mean, this is highly replayed right here. They come back from the break.
Did you have enough time? All right. Mr. Melnick, welcome back. The time is 2:35, I should say. Did you have an opportunity to talk with your client?
I did.
All right. Who is going to be here on Monday?
Kayla Bumpus,
Kayla Bumpus.
Bumpus.
Okay. All right.
And I can state, as Mr. Copeland's attorney of record, told him, are you sure this is what, asked him, are you sure this is what you want to do? And he said, yes, he intends to assert his Fifth Amendment privilege again on Monday.
Okay, well, I will.
And hence,
if you will tell Ms. Bumpus she needs to be here at 8:30, and we will certainly take up with that knowledge before we call our jury, and I will ask him in her presence whether or not he intends to do that, and we'll see where we go from there.
Okay.
Okay. All right. Anything else? Okay. All right, sir. Enjoy your time off. Okay. All right.
And there's all this time before she decides she needs an ex parte. Like, she wanted it to be said last.
Yeah.
Because this is, we have several more minutes before she actually says, it's like 6 more minutes before she says.
Okay.
Your Honor.
Counsel, is anything else I need to cover with you before we recess until Monday?
Got it.
Yes, Mr. Botts? Mr. Botts, you need to use the microphone, sir.
Is it working now? Can you hear me fine?
Yes, sir.
All right. Your Honor, we started this whole fiasco out with whether the state knew that Mr. Copeland was going to take the Fifth Amendment when he took the stand. And if so, was that proper or improper to put him up on the stand knowing that they were going to?
You have to speak up, sir. And if you could hold the microphone, it'd probably be better.
That he was going to assert the Fifth. And I know that they did know that he was going to take the Fifth because I heard it said outside right before I walked into court. I even said the officer.
Then why didn't you, as an officer of the court, tell me before we took his testimony?
I told Mr. Steele.
No. Why didn't you, as an officer of this court, tell me?
Well, then that's my.
I got a problem with you now.
Well, that's fine. I mean.
I got a problem with you now.
Well.
I would suggest you don't say any more.
I've already said it.
I know that, sir. And the problem is you should have told me if that were your case, then you've just made an argument we didn't even need to have because I could have certainly asked him based upon your proffer. Now you want to have it both ways. You can't do that.
Your Honor, I thought the state knew that
And that's not what the point is. The point is you as an advocate is you should have told me. Both sides have an equal responsibility under the rules of professional responsibility.
Okay, as long as we're both responsible, that's fine.
All right, have a seat, sir. Thank you.
Yeah, isn't that weird? Only the defense has the responsibility.
Is that okay?
No. What's your request, sir?
So in the attempt to avoid any spurious allegations moving forward, I would ask that Your Honor order that the deputies transport Mr. Copeland to the jail completely separate from any.
Yeah, thank you for reminding me of that. In our order, wait, just 1 second. In the order of the incarceration, I'm going to also have a keep separate order for him.
Your Honor.
For the transportation and the housing, because none of these gentlemen are going to say anything to him, but I don't even want anyone to claim that they did.
I think that's fair enough, and that's a good suggestion. All right.
We'll prepare.
Yes, Lieutenant Walker. So that will not be an issue? Okay. But we'll go ahead and have him, if you could also have him housed separately too? Okay. Thank you, madam. All right, anything else, counsels? All right, take a couple deep breaths this weekend, take a knee, and come back on Monday and let's get after it again, okay? All right, we'll see you on Monday morning at 8:30, okay?
Can you get us the list of names and then any exhibits for Monday?
I think the only, I don't know who is being called. We can find out. Ms. Lovett and Ms. Hilton and Mr. Atkins, who is going to be called?
This is where they
Let's
say they have
assume
to call.
that Mr. Copeland invokes again. Do you have some other witnesses that we can take up at that point?
Your Honor, we will apprise after we look at and reevaluate where we are because our order of proof was building blocks that at this point began with Mr. Copeland. And there are certain things that have to take place before we can tell them anything. So we have to do that. We have to deal with that and where we are right now.
All right.
And that's just where we are.
Okay. Well, be thinking about what scenarios you'd like to have the court look at.
Yes, Your Honor.
Depending upon whether or not Mr. Copeland decides he'd like to invoke his privilege again, okay?
Yes, Your Honor.
All right.
And Your Honor, go ahead.
Madam?
Mr. Sharp, he can have the floor.
Yes.
I'm just going to ask a courtesy of the deputies, could we just keep our clients here for just 5 minutes after court ends, 15 minutes after court ends? The attorneys would like to have a discussion with our clients.
Lieutenant Walker?
And Your Honor, the state has a matter we need to take up ex parte.
Okay. All right. Lieutenant Walker has been asked by defense counsels, as a corporeal body for them to be able to talk with their clients, once you clear the courtroom. Can you make that happen?
Yes.
Okay, all right. So once everybody,
All right, so that ends there, and then I have a clip from day 100 at a timestamp from Julie. Nik, did you have to head out? I saw your motion
Yeah, I mean,
in the
it's
private
over
chat.
11 p.m. I should have been to bed an hour ago. Um,
I know how that goes.
Yeah, but yeah, thank you for having me on. And
No problem at all. Anytime.
yeah, and
I will
yeah.
drop your stream again. I'm gonna also play day 100, which if you pop back into the chat, you can hang out and watch what was said on day 100 by Judge Glanville. So that's
All
Nik
right.
Starow's channel I just dropped in the chat. Who else is sick of hearing Glanville's voice? We're sending you off to bed with Glanville one more time.
Already, my blood pressure, I felt it. Oh no, and I can't say the words I want to say on Cat stream. I can ruin my own ad revenue, everything if on my own channel, but I can't do it to Cat.
Oh, I appreciate you. I think we're far enough in that I don't know if they're even paying attention. Just use a heavy accent.
Yeah, I know the 4-quad thing. Yeah.
Well, see you in the
folks,
chat if you pop back in. We're just going to play this one clip. We just dropped your channel link too, so guys, make sure you go and subscribe over to Nik. He will continue doing coverage of this trial beyond anyone's patience, I would say.
Hey, no worries. I have a whole life behind me. Okay, see you around, folks. Bye.
Bye. Thank you so much. Okay, so let me switch to... I think I'm at the right timestamp. It looks like they're right about to come back. Right? Did I have your timestamp right, Julie? It was like 2... I started. It's like 2:21:55. Assuming long crime stream. Because it looks like they come back at like 2:23. Is this it? Julie, let me know if it was long crime stream or someone else's. Okay. So 2:21 looks like there's nobody there. So let's go to... Okay, this looks like a good place to start. And certainly many people have replayed this exact part, so... Oh, Fox 5. Okay. I'll keep this going. We'll pull it up on Fox 5. Okay, it's coming in right here.
oh, where's Mr. Weinstein? Okay, all right, okay. All right, thank you, Deputy Ham. Anybody else joined us since we last recessed, other than Mr. Uhalski, who I haven't seen so long, he's grown a mustache? Anybody else? Okay, all right. All right, folks. As you all are made aware of, last week the court was going to do an in-camera review of the ex parte proceedings on June the 10th of 2024. In considering whether or not to have an in-camera discussion or review of the records, this court has decided to release the entirety of the transcript of those proceedings as courts one. And I'm going to take judicial notice of the following timeline. On Friday, June the 7th, 2024, Mr. Kenneth Copeland was granted immunity from prosecution pursuant to 24-5-507A, and that'll be marked as courts 2. So the transfer will be court 1. His immunity agreement, Mr. Copeland's, will be court 2. Mr. Copeland, who was represented by Mr. Jonathan Melnick and advised of his rights and obligations, during the proceedings on Friday, June the 7th, which will be marked as courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt, and that will be courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or I had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland. Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Kayla Bumpus, attorney or ADA Ms. Adrian Love. Also present were the DA's investigators.
Guys, do you think it's good for the state if Whitaker has homework now to revisit all of this context surrounding the ex parte meeting on June 10th? And if she has to go back and look at June 7th, kind of at the prompting of the state, even if she just looks at the transcript and doesn't watch the video, I think the way Judge Glanville was speaking to Mr. Botts is going to be palpable. You will know the tone of it from the words on the paper. I know you can't always tell tone from words on paper, but I think it will be palpable for that interaction. And then we've got to go and look back at this judicial review, because hopefully she's looking at that also. I really don't think Whitaker has looked at all of this context, but now she's being pointed to it. And this is more than just what Julie's thinking. I don't think there's a reason for this meeting at all. I think the reason clearly is to secure the testimony of Kenneth Copeland. And they wanted to secure this testimony so badly that they told Mr. Melnick, figure out a way. Find a way. Who cares about the counsel for this witness who we're about to force to testify through an immunity deal being plopped on his lap? Forget counsel. If you can't be here, not a big deal. We need you to figure it out, because we need him to testify. And when you put all these layers together, you add on today, the pancake on the top is that today, Hilton has a scheduling conflict. And she won't be able to continue questioning Kenneth Copeland. And suddenly, they could, if they wanted to, they decided not to, was objected to, whatever the resolution there is. They were almost about to try to call a different witness to push back the rest of Kenneth Copeland's testimony. But they didn't want Kenneth Copeland to be able to be called later, when it wasn't convenient for them. When they thought they were going to force him to be cooperative. They wanted him up there right then and there, because they said they needed him for all the other evidence and the other witnesses that they would call. They needed him first. And today they're arguing to Judge Whitaker that they could call somebody else. Somebody else could question him if that's not the available option. Guys, I really it was Friday that They asked for the ex parte. Glanville has his times jumbled in this, which I don't think should surprise anybody. But like, do you guys, like, this is insane when you put all of this in context. And I think they're prodding, they're funneling, the state is funneling Judge Whitaker to go look at this with a closer lens. Like what are they gonna do? I mean, we could keep playing this if you want. Do you guys want to continue playing this? I mean, I've watched this so many times, and that clip with bots, it pisses me off every time I see it. Getting another look at Judge Glanville, hearing his voice after having a new judge, I'm like probably more annoyed hearing his voice once again than I was when we were, still having back-to-back days with Glanville still presiding. Like, I don't know, that was a rant on my part. But it's like none of it makes sense. Obviously, Bruce Harvey, I agree with his argument that this is just too much. This is ridiculous. You see the other defense attorneys like shaking their head when Bruce Harvey's saying that. Like, I wouldn't be surprised. I know Bruce Harvey adopted the full motion for a mistrial, but yeah. Yeah, so at some time in the afternoon on Friday the 7th, I said I will get that ex parte, so I reached out to the court reporter who handled that, and she has given me a rough transcript. So this is what Whitaker said today at the end of the stream from today. So that's why we went back and revisited Friday, June 7th, day 87. Day 87. Thanks to you guys with all the days and the timestamps. So was there another meeting? I think that there was probably another meeting, and I had seen the chat is gone off the screen. I can't find it. When I'm scrolling up, I don't see it anymore. So I lost it. I should have started. But someone suggested that ex parte could have just been the state and the judge. No witnesses. Melnick wasn't there. Kenneth Copeland wasn't there. It was the state and the judge. So if this is really what Judge Whitaker is asking for, and these motions for mistrials have not just been flat out denied, you guys, she's still weighing in. I think she denied the motion to disqualify Love and Hilton, but all day I've seen people mention that the motion for mistrial has been denied. I think there's been valid speculation, like good reason to speculate that maybe she wants to continue to keep this trial going, but she has not actually denied the motions for mistrial. That's still open. Just like Mr. Kendrick's renewed bond request is still open because Doug Weinstein said, hold on, can you wait? Can you, defer that until after you make your ruling tomorrow on these motions for mistrial? So if she's looking back to see if something happened on Friday night, something else happened on Friday night. When she asked today, there was a pretty lengthy discussion. It was early on. It's like probably on like page 1 of my notes from today. I've got so many pages. When was that she asked for everyone, are there any other meetings that I should know about? Meeting with White, witness White. That was all the way back at like 2 hours in. Because we are like we're approaching 9 hours in. But she specifically asked, any other ex parte meetings we should know about? And yet somehow she might be looking for a transcript of an ex parte on June 7th that I didn't hear Love disclose in open court today, but she seemed to think was necessary to go and mention earlier today. It seems to me, tell me if I'm reading it wrong, she went and mentioned it one-on-one in passing to Judge Whitaker. Like, so it's like, you're going to speak to the judge alone again. To try, like, did she think that Judge Whitaker wouldn't eventually make mention of this? Did she think that she could just whisper it to Judge Whitaker so Whitaker wouldn't fault her for it, but the defense wouldn't be able to find out? Like, yeah, a meeting to plan the meeting. Like, and she still has an open motion for mistrial pending. Like a joint, like whatever. They're all like co-opting. They're like, cool, we agree, sort of. Except for Bruce Harvey says, if you don't agree to this motion for a mistrial, I also have my own where I'm fine with a mistrial without prejudice attaching, right? So they all want this mistrial with prejudice attached. I'm going to keep referring it to mistrials. You guys know that there's a little bit of a distinction there with Bruce Harvey, but whatever, you guys get what I'm saying. But what is this? This thing that we're ending on with this little closing note today? It seems to me like Whitaker almost forgot to mention it, and that would have been really bad. And I don't think she intentionally meant to not mention it, but she probably expected it to come up when everybody was laying out their other ex partes we should know about. That might be why she thought of the question. We thought it could be just to answer one of the requests in Brian Steele's motion. Maybe she thought to ask that question because Love came running up to her in the morning saying, hey, I just want to let you know that I did this thing on June 7th. Just so you know, because you said you looked at the record. So maybe she mentioned it at lunch. I don't want to like drag us through and rewatch that clip. Oh, it was right at the end. I guess we could, right? Did she say it was this morning? She said it was this morning. So I wouldn't take that to mean at a 12:30 lunch. But okay, going to day 87, 139. I do think we had pulled that up. And we ended up changing the timestamp that we were looking for. Day 87, we're gonna hope this was law and crime. And then by 1 hour and 39 minutes, and then also 3 hours and 28 minutes. I'm assuming 2 different sound bites, right?
But Your Honor, I don't have any of the other notes. Mr. Copeland met with law enforcement on the January 11th of 2015. So God
I'm a
forbid,
little
the killing of
behind.
Mr. Thomas is at 7:22 approximately, January 10th, 2015. By the early morning hours, I'm going to tell you about 4 a.m, Mr. Copeland is on video, audio recording with Detective Thorpe the next morning. So it's January 11th, 2015. And he made statements that he knows nothing about anything. Since then, he has made additional at least 5 recorded statements.
I don't see Melnick. Drea, I don't see Melnick at this 1:39:11 timestamp. Was it before? Was it earlier? No, that's Steele. There's Melnick walking out. Okay, so I think it's earlier than that, 1:36 maybe. And then I'm going to pull up today's stream. We'll watch the last, like, 15 seconds of that to see exactly what she said.
All right, sir. What's your pleasure?
Say what?
I said, what's your pleasure, sir? Do you wish to give testimony? I know you don't want to give testimony in this case, but you've been given immunity in this particular circumstance, use immunity. So are you going to testify?
Yeah.
Okay. All right. All right, sir. Then what we'll do at this point in time is we'll call for our jurors and we'll swear you in, and we'll go ahead and take your testimony. Okay.
All right.
All right. What is it, Mr. Steele?
Melnick was about to speak, and then he leaves.
Does our witness need to be excused?
Yeah, so Dre, I think that timestamp might be for a different stream. And let's go over to this last bit of the law and crime stream. Go, Doug. Look at the court clerk. It sounds like something new. Sorry.
The official transcript.
Sorry.
but,
Oh my
I mean,
God. Sorry,
she said
guys.
When it gets started.
Hold
So,
on.
if y'all all want to be officially heard this morning, that
sorry,
she had
guys.
made
Sorry.
the request for the, Miss Love put on the record this morning.
This morning.
That she had made the request for the Monday morning meeting. That was the June 10th meeting with Judge Glanville and Miss Bumpus and others at some point in the afternoon of the Friday the 7th. And I said I would get that ex parte because it did get taken down. And so I reached out to the court reporter who handled that, and she has given me a rough. Now this, and I'm going to share it with each of you. It's a rough, so this is not the official transcript, but I mean, she's an experienced court reporter, and this is probably pretty close to what it's going to be officially. But anyway, I'll just share that with each of y'all so that everybody's on the same page about everything, okay? So if y'all all want to come up here and get a copy from Ms. Pursfield, after that, we will be in recess for the day. Thank you.
So that does look like it looks like she took 2 stacks of paper separate. Maybe we can just replay the different stacks. Was she keeping one transcript copy for herself and then handed multiple copies? Or is that big stack the length of this transcript?
Reporter, and this is probably pretty close to what it's going to be officially. But anyway, I'll just share that with each of y'all so that everybody's on the same page about everything, okay? So if y'all all want to come up here and get a
She
copy
combines it in
from
one.
Ms.
Oh, no, she
Pursfield,
takes it back.
after that, we will be in recess for the day. Thank you.
Okay, cool. So based on that stack of paper with multiple copies, because really there should be 6 copies, I would assume. I mean, it doesn't look like it was a brief, high and by in the hallway type of transcript. And it's certainly not long enough to be the transcript of the whole day of June 7th. So this sounds like a totally separate ex parte relating to a witness who was already taking the stand. That the judge here, her language is, so that way you can all know about it. What's the implication? That to me sounds like, because I don't want anyone to have problems. I want everybody to know about it. I just found this out this morning. What if we see a new motion because of whatever took place on Friday? Like, I don't really have an answer except hopefully we'll see something. Hopefully someone will give us a peek into what this ex parte meeting on June 7th was about. It is just a totally separate thing. And we had the opportunity earlier in the court day for the state to disclose in open court that there was this other ex parte. They chose not to repeat it in open court because they had already told Whitaker privately, one-on-one. Like, that is a problem too. And so the reason I think tomorrow will be wild is because Judge Whitaker is supposed to go and look at the context of everything surrounding June 10th and this ex parte meeting. There were certain things where she was really, like, she was like 9.5 toes down that nothing was wrong surrounding this ex parte meeting, but there was a tiny bit of wiggle room where, for one, she ended up conceding that Judge Glanville shouldn't have been giving, or portraying the idea, the scare tactic, that we could hold Woody in contempt until all the defendants are tried. He shouldn't have been doing that. He was clearly mixing like civil and criminal contempt, and then also misinterpreting the extent of which, until the trial's over, we're going to say that includes the trial of any co-defendants that are not enjoined on this instant trial, this case right here, that we're trying right here with these 6 co-defendants. But she was pretty adamant that even though Krause, her statement that the ex parte meeting was proper was just in dicta, it might not have actually been a factual finding, she still leaned on it a little bit like it was a factual finding and didn't want to challenge what a judge said. But she still has outstanding motions for mistrial. In the chat, someone mentioned that it seems like the motion to disqualify is actually still open. She's taking it under advisement. I thought she had ruled that she wasn't going to grant that. So we'll probably see that too. But while she has this homework on her plate to go and check out, we get this new detail that there may have been another ex parte meeting involving the conversation about Kenneth Copeland's cooperation, getting him on the stand to actually testify. Like talk about shooting yourself in the foot. This judge was okay with moving on from the ex parte thing with Kenneth Copeland. But now we have another thing to revisit. And whatever was said on the record there could be in contradiction to the things that were said on Monday. Could be in contradiction to the way that we've seen, Melnick was sending emails and didn't even want to email the state, even though it's sent directly to the state. There are so many other ways that even in maybe that transcript, if you break it between 6 people, maybe it's like a 9-page transcript, who knows? But it could still be a lot of stupid tripping over their own feet for the state, maybe for the judge, for Judge Glanville. I don't know. And I see, Veronica, you have a channel. Someone's saying share your channel link. What is your channel about? We can share it. It's just nuts. She had the opportunity to disclose this. She didn't. She tried to disclose it privately to a judge. She tried to disclose an ex parte communication that hasn't been disclosed to the defense to date, privately to the judge, the same day the judge wants her to disclose, or not her, but all parties, to disclose any possible ex partes that might not be known to the other party at this point in time. That's audacious. That's gall. like holy moly. And before I lose my cool, I want to thank Maiden Lumping Service. That's a cool thing too. Those are the people in like logistics. They like unload the trucks. They keep everything organized on the pallets. Not work I'd be good at doing, but very necessary for supply chains. But Maiden Lumping Service sent a $20 Cash App saying, love your commentary, beautiful in and out, and I appreciate that. I wanted to make sure I got that before I forgot. You said go ahead and sigh for us. Because it's like How do you do that? How do you do that? And yeah, absolutely. Okay, thank you, Ghost, for sharing Veronica's channel. I didn't catch what Veronica's channel is about, but you guys are showing lots of love for Veronica in the chat, so shout out to Veronica. I'm looking to see what we're going to talk about so I can say it. Okay, so Coco. So Veronica says, Coco, I want to go live and talk about it today too. You want to join me? I got stuff to get out and nobody to talk to. Heck yeah, get it out there. Get some rants and vants going. So, and then you guys won't be able to click it on screen, but Ghost just shared Veronica's channel if you want to check that out. Good to see you too, Coco. But yeah, what else, you guys? That is a very loud way to end the day. It seemed like it was going out on a quiet note, but holy moly. Holy moly. Julie lost it at 8 a.m. We started at 8:45. Oh my gosh. Too funny. Well, I think we're all caught up. I'm starving. I did write timestamps. I've got a notebook of timestamps I want to go back and add, but it'll probably be like an hour before I go back and do that to timestamp this stream, at least everything except the first hour when I wasn't thinking to timestamp. It'll be more easy to navigate if you want to come back to the stream and use the timestamps here. Julie, thank you so much for all your help with the timestamps today and in other streams that we've done. You're always so good with when and where things were said. If you guys want to tune into something else right here after this, let me find Flesh of the Gods again one more time, in case you missed it earlier. Flesh of the Gods has done animations for the ex parte meeting. We might need another video for this possibly new ex parte if we get to see the transcript from it. We might need another animation for this new one. So there's the link to that if you want to watch something right now as we close this out. Thank you guys so much as always. Thank you for showing so much love to like everybody in the chat, to me, to my panelist, Nik Starow. Appreciate you guys forever and always. Until next time, you guys take care.